time zone information. Why is this important for you?
Um,
In layman's terms, describe the very technical work you did on this. All right. So on your first page here, what is this first box for computer information?
so a computer has a place where a bunch of the information on operation instructions and who it belongs to and other information is stored, called the registry. And in this case, this is a selective output of that information. And the first box itself shows that it is a Windows machine and it gives you the install date, but the more important part of this is pulling the registered owner.
Which says what?
In this case, it says G. Farris.
Excuse me. Okay, and then time zone information. Why is this important for you?
It gives me which time zone the computer is set in, so that way when I'm doing any sort of analysis work with any of the files involving times, I know which time zone I'm looking at. And it's actually fairly common for a computer to be in the wrong time zone. So just to make sure I'm getting the times correct, we look at this entry.
Do you often have to convert time zones when you are analyzing digital evidence?
Yes.
And in this case, for this computer, were certain sections that you were looking at in different time zones? Or did they all appear to be consistently in UTC or Eastern Time?
Everything was either in the UTC value or in Eastern Time.
What is UTC?
It is the Universal Coordinated Time, or as they used to teach it, Greenwich Mean Time, which is in England, where it's just there's no compensation to the time zone. While in Georgia, we are either 4 or 5 hours behind that timeline.
And then I'm going to move down to the computer name. This computer had a name. What was the name?
Yes, basement PC.
Okay. Pretty self-explanatory there. All right, I want to move on to your section 1. And I've titled these sections just to keep them straight. Chrome downloads. What is Chrome?
Chrome is a internet browser that is made by Google.
Why did you decide to look at internet browsers for user intervention?
That's one of the both easier and more common areas to see information on usage, as a lot of the use of a computer nowadays is becoming internet browser based.
Okay, so we started with Chrome, and it appears that these are in UTC, so what does that mean for you?
So in this case, that is in that coordinated time and not compensated to Eastern. So we would have to subtract 4 hours, because in July our time offset would be 4 hours. So that to get to the time that it would be here in Eastern Time.
So these were the last downloads that you pulled right here that you took a screenshot of?
Yeah, that was the 3 most recent Chrome downloads.
Okay, and they appear to be PDF files. Is that accurate right here?
Yes.
And the user downloaded them, and it appears saved it onto the desktop. Is that what that means?
Yes.
You located that same file that was downloaded in a desktop folder.
Correct.
Okay. And that was on July 3rd, 2018, and the Eastern Time would be 1:51:09 p.m.
So the download was showing slightly before that, but the 151:03 is the download, and then the file time itself, located in the download folder, was 6 seconds later.
Right here.
Yes.
Okay. All right, we'll move on to Chrome history. This would be the user's browser history.
Yes.
Okay. For Chrome specifically.
Correct.
Okay. you noted this website, and you might call it something different, but I'm going to use website. Citrix, can you describe that to the jury right here?
Citrix itself is a big company that offers a lot of applications, primarily to small, medium, sometimes larger businesses. It has anything from some remote computer applications to file sharing, to a varied other set of business tasks that can be logged into from a browser.
And you sort of focused on the access to citrix1.er. Can you describe that to the jury, why you focused on that?
Burr.com is one of the names that I was informed belonged to the law firm that Mr. Farris had worked for. I don't know that part of the arrangement, but and that just as far as establishing usage, getting onto a corporate resource and accessing work materials, I flagged it as the information I was presented was this individual was pretty much always working and always accessing work resources.
And are these times, these are UTC, so we would subtract 4?
Yes.
Okay. So let's move up here to LinkedIn. Are you familiar with what LinkedIn is?
Yes.
What is it?
It's, in lightened terms, it's social media for business, and allows you to make a professional resume style profile and list accolades and friend and recommend business colleagues, as well as it does have some hiring features, some job hunting features, as well as some news articles that are posted by both professional outlets and individuals.
And it appears that the history for Chrome here, the last entry was 7/3/2018 at 2:32 p.m.
Yes.
Okay. And then we move on to Internet Explorer, which is just another browser, yes? Internet browser?
At the time, yes. Not so much anymore, but.
Okay. RIP Internet Explorer. Okay. So this is also in UTC time.
Yes.
Is that accurate? Okay. Now we got a couple of, excuse me, later entries here. So I want to talk about the Internet Explorer history that you pulled from this computer. Can you walk through, you made a note here, can you walk the jury through this opinion that you concluded?
So that top entry listed July 4th shows a visit to a website that is titled msftconnecttest.com. I did a little bit of reading into the function of that task and what that task is, and found that it is a system task done by Microsoft that is essentially just a check-in to make sure that Microsoft applications and programs are operating effectively. So, for Outlook to work correctly, Teams, if you use Teams, which is a chat and video calling and meeting application, it will reach out when either you're booting into Windows or an application is about to be used, just to reach out to Microsoft to do that initial, hey, I'm over here, everything's okay, to check that connection status to make sure that your interaction with Microsoft products is a seamless experience.
Was that the only log for the 4th?
Yes.
Okay, I want to talk about the ones that are below it. This is in UTC, so is this 7/4 technically 1:14 a.m.? Explain what the actual time and date of these entries are.
So that would be on the actual night of 7/2.
Okay.
So you'd
So the
subtract
last-
4 hours back, you would get to the 2nd of July.
Okay. So we'll jump down to these down here. So these are the 3rd. Well, I guess, except, are these in chronological order? What kind of order are these in?
Yes, they're should be organized by timestamp.
So we've got a couple of AMs here, and then we've got the 7/3, 5:49 PM.
Yes, and that would be 1:49 p.m. on the afternoon of the 3rd of July in 2018.
Okay, and so all of these for AM would actually be on the 2nd if you convert the time accurately.
Correct.
Okay, so then for 5:49 p.m., 5:47 p.m., that's 1:49 and 1:47 p.m.
Yes.
Okay. So between the 3rd and the 4th, 1:49 p.m. appears to be the latest Internet Explorer visit from a user.
Yes.
All right. Move down to event logs. What are event logs?
So Windows keeps logs of pretty much everything that happens on your computer as you're using it. I can store, error logs, install logs, but one of the more important areas to me is the actual login, logout logs. It will actually have a entry into a file, which is actually just named the event logs, when a user or a task logs in or accesses system resources, among some other information.
So what event log is 4624? What does that tell you?
So the 4624 is actually the code that it attaches to login entries.
To log in entries?
Yes.
So when somebody actually sits down and types in their password and logs into the computer?
It will create one of those, yes.
Okay. So for this Dell, and is this in, it says UTC, so we have to subtract 4 again?
Yes.
Okay. So on the 3rd, the last login was when?
The last login itself is at 3:42.
So that's this one highlighted right here?
Correct.
Okay. All right, and then you had 2 types of logons. You broke that down on your next page here, and we're still on bot song 7. Can you describe that to the jury?
So each one of those entries, well, it's a simplified view that was on the prior page. Each one of those entries contains all of this other information inside of that file. So pulling this one as an example, there is multiple different types of logins that Windows will log. There's network login, there's user password, there's a system task that accesses the system, and those are all inside these 4624 log entries. They put a difference right in the second block of information. It's right there at the top of the page now. Under login information, the login type, it has a number next to it.
That's right here.
Correct.
Okay.
So in this case, the login type number 2 is the one that I can attribute directly to a user entering a username and passcode or a PIN to log into the system. The other one I was seeing that was in these as well was a entry number 5, which is a system task, was logging into the system.
We'll get to that one in a second. So the last one that you could attribute to a person was on the 3rd. Is this Eastern time right now?
Yes, this
Okay.
one has been compensated, and this was the last type 2, which is a user-initiated login that I could locate on this system.
Okay, and then you mentioned a type 5, so let's move on to the type 5. Okay, so here you're just describing the types. So talk about, you've already kind of described it, but now that they know there are 2 types of logins, describe again the type 5 logon.
It's when a service starts, which is just a process that's running on your computer, and a service account, which is just an account that's exactly for these tasks to run. Service task logs in and utilizes resources or performs a task on that system.
So not a human.
Correct.
And you noted that there was a login type 5 at 342? Well, all the way until 342.
Correct. So there was some intermittent of these tasks that were running all the way until that 342 timestamp.
And is that on the 3rd?
Yes.
July 3rd of 2018.
Correct.
Okay. And then you noted application event log, an Outlook error. Can you describe why you put this in your report?
Just while I was going through all of this complex logs, I was looking just for signs of user interaction or trying to narrow down the last use of this system. And the same way Windows captures those login events among other events, it also has a log specifically for applications. So anytime an application has something that is loggable, it'll have an entry in the system. In this case, what we're looking at is the Outlook application itself, which is a program for email, had entered an error code into this log saying that the attachments to the message was too large.
So then did you go back to Mr. Farris's emails and see if he had sent one with attachments? An email.
I went back actually to his phone and looked into the email list to see if there had anything inside that time frame that would be consistent with this error. And at fairly close to the same time, there was an email being sent from the phone with some larger attachments to it.
At 1:55 p.m.
Yes.
on July 3rd.
Correct.
Okay. These are the attachments that were too large.
Yes.
Okay. Another thing I wanted to discuss. Okay, I don't know if we really discussed this. So on the 4th, you mentioned that this MSFT Connect is a system push.
Yes.
Okay, that could be triggered how?
One of the things that I discovered during reading about specifically that task itself was in that check to the Microsoft servers. It happens when you first go to use a computer, whether it was sleeping, whether it was off, whether you were just about to log into the system. And one of the common places that it had been seen is you're first turning on your computer, or you're first opening the lid, or you move the mouse, hit the key press to get to the password screen. That Windows task is going to try to reach out to Microsoft to make sure those applications will function. So with laptops, if the lid's closed a lot of the times individuals will have their system set to go to sleep or in a low power mode. So the most likely scenario for this one is either the system was sleeping, the screen was off, or the lid was closed, and when the system powered on or came back awake or came out of low power mode, it went to connect to that Microsoft service to get ready for the user. So the most likely thing that occurred was either somebody had moved a mouse or that a lid had been opened.
And that was on the 4th, and we would have to subtract 4, so that'd be 11:09 a.m.
10:09.
I'm sorry, you're right. Okay. 10:09 a.m. on the 4th.
Yes.
Okay. And you can attribute that to the computer waking up, or essentially Microsoft getting ready for a user.
Yes.
So coming out of sleep mode, etc.
Correct.
Okay. Were there any tasks beyond that one?
No.
Okay. Now we're going to move on from the Dell and talk about the CPAP machine. At this time, Judge State would move to enter into evidence bot song 1, 2, 3, 4, 5, 6, 8, and 10.
All right. No objections?
No. All right, they're admitted.
Thank you. Okay. You had the opportunity to essentially pull the data from a CPAP machine in this case, or the SD card that was located within the CPAP machine.
Kind of this similar methodology to the trail camera itself. The CPAP machine had initially been imaged by the prior examiner, Kevin, and I started off with that copy of the SD card from the CPAP machine.
So it was data from the SD card that Kevin had imaged.
Correct.
And saved.
Yes.
Okay. And you went ahead and validated that and then figured out what to do with that data.
Yes.
Fair to say?
Yes.
Okay. How did you figure out what to do with that data? Because it didn't come in these nice little tables initially, correct?
Correct.
Okay, tell the jury about that.
So CPAP machines, keep a log of all the sleep events and everything else, and they're typically proprietary to whatever software or cloud-based solution that your doctor's office would use. The primary intent is to share your sleep data with your medical providers. So usually they're kind of walled in their own garden of needing to be opened in the proprietary software or a cloud account. I initially looked into how to read that data through this specific provider, one I believe was named AirSense, and learned that it is either paid software or a cloud account provided by a medical provider. Further research through the forensic community and some of the communities that I'm involved with online as part of my continuing education and keeping up with the trends. There was an article that I located about an open source project that created a free to use software application that was open source that had been specifically made to make an environment and software where you'd be able to look at the data yourself. So in this case, I downloaded that specific application after researching everything that it had done and talked to another examiner who had prior experience with that software application itself, and then created a instance on one of my forensics machines, installed it, and then I was actually able to load the SD card information into the software.
Into readable tables and graphs
Yep.
and data.
And then it took it and made it into where, instead of just seeing the file dates and times, which were pretty much all that were available until I discovered this application, into actually being able to view the data in a actually quite nice presentable format.
All right, I'm going to open bot song 1. It says CPAP statistics standard. So is this the program that helped you load all this?
Yes.
Okay. Oscar usage statistics. And this is the data that was on the CPAP. Was it an SD card?
So I took the image of the SD card and then I had to export it onto another drive, basically making a separate copy of the SD card. And then I put that into the system, running Oscar, and imported all that information from the original files that I had just exported.
Okay, so this breaks it down. Most recent 7/2/2018. Can you explain to the jury how the CPAP calculated days?
So this specific vendor, AirSense, both on its website and in the profile, when I selected in Oscar, or this application, that this was an AirSense machine, they both advised that it kept time slightly strange, and it kind of just gave it to you as an acknowledgement that, so you'd have the understanding of what you're looking at. Instead of the normal switching dates at midnight, like all of us do, seeing CPAP machines are primarily used at night, its date change is actually set for 12 noon. So between 12 noon all the way until noon the next day is one date. So the dates appear to be behind in this instance, and it'll clarify a little bit in one of my next reports, but this most recent 7/2, according to how this machine keeps dates, is from noon on the 2nd all the way until 11:59 a.m. on the 3rd.
Okay. And we'll get to see that in one of the next exhibits. So here it says days not used, 0. What does that tell you?
So, and this report is broken down into all the categories I had available. It has detections on how many days this device was not used. So, in the last night, it's showing that it was, double negative, not used. So this device was used on the last night. There was a log. In the last week, the last 30 days, and the last 6 months, it reported 0 days that it was not used. So it had been used every night in what it's reporting the last 6-month period. And then within the last year, it was showing a 60-day period of not showing use.
Why was that?
I believe the first reported entry was less than a year. This file goes all the way back to July, and if you look towards the top, the initial initialization date is in September.
So there's about 2 months there where either he didn't have it or he had another one or wasn't
Correct.
reading. Okay. All right. Let's move on to bot song 2. Overview report. And this is usage from, it appears, September 1st to July. Is that fair?
Yeah, it
Okay.
should be September 1st to July 2nd.
July 2nd. Okay. And there's not a void in this graph to show that it was not used one day. Fair?
Correct.
Okay. And then does this graph here show the times that the user, presumably Gary, the times of his sessions of the CPAP being on?
Yes.
Okay. And we don't know about pressure. Okay, so bot song 3 breaks it down a little bit. So this is a reporting for 305 days, and he used days. Does that say 305 days used?
Yes,
Okay, out of how many days?
305.
Okay. Is this broken down by month? Bot song 4?
It is.
Okay. Is July 2018 the most recent?
Yes.
Okay. And this has percentage of days used, 100%? Is that what that says?
Yes.
Okay. It also has an average of how many hours that user sleeps?
Correct.
Okay. All right, bot song. Let's go to overview last week. Usage from June 26th to July 2nd?
Yes.
Okay. And then, all right, so you mentioned that it kept time from noon to one day and then 11:59 a.m. to the following day.
Correct.
Is that right? Okay. And so what is this table telling you right here?
This is the reported data from the last entry that was available, the one that was marked in all of the graphs as July 2nd. But in that date example and all the disclaimers they gave, if you actually look at the start time, the start time is logged as 2018 0703 at 0037 or just after midnight. And then the end time has the same July 3rd at 0748, so 7:48 in the morning. So even though the log file is showing July 2nd, we clearly see that the start and the end date are on both July 3rd.
I'm going to pull up last one, bot song 10. What are we looking at here?
And this is a screenshot inside the Oscar application, something that I was not easily able to get into a report, so I took a screenshot of the last session that was available, the one that was showing the log file as 7.2, showing both the date a little better clarified as 7/3/2018 with the start of 0037 or 12:37 a.m. and an end at 7:48 a.m. with the total time of 7:11, and then it shows some CPAP, other statistics that I'm not as familiar with.
And that was the last session that the AirSense logged.
Correct.
That's all I have for you. Thank you.
Good morning, Investigator Botson.
Good morning.
It's nice to cross you again. I'm going to start with the SD card stuff. So, do you know who deleted the SD cards?
I do not.
Okay. Well, so you didn't delete them, right?
Correct.
Okay, because Scott Farris testified earlier that last week that he was the one who deleted it. So it is your opinion that, I know it's from the top, I believe. So this one, it says 1, it's got the file name and all that, and that's the photograph. So this is photograph 1, correct?
Yes.
Okay. So this is the last photograph that was deleted, correct?
Yes.
Because that says deleted is true, and that individual who was previously identified as Scott Farris is walking up to the camera, correct?
Yes.
Okay. Then you got another one that is not deleted, and that appears to be the same individual walking past the camera again.
Yes.
Okay. And then you've got just things on the 6th, and these are you weren't there, but those are Sheriff's Office investigators.
Yes.
Right? Okay. So, want to go to your review of the Dell. So, I got my notes on your copy. So your testimony is that with the Chrome download, that this time, that is UTC time?
Correct.
Okay, and so that would put that time 4 hours later, so at 1:51?
Correct.
And it was at that point that Gary Farris, or presumably someone, was downloading a PDF?
It just, a user of the system downloaded a PDF.
Okay, a user.
Yes.
Do you know, was this computer, was it password protected?
Yes.
Okay. How do you get in something like that?
So, Windows is designed to prevent access from the device itself. And unless you have some of the more advanced security features enabled, like encryption, that security is not designed to prevent somebody from removing the hard drive and plugging it into another computer and being able to read it, which in our standard practice, that's what we do. We do not use the individual device that comes into us. We remove the hard drive and plug it into that right blocked device and access it that way.
Okay. I want to go here, make sure that yours, that's not too good. Zoom in a little bit. So, I just want to clear something up. This event ID 4624, that is an ID associated with a regular normal login?
It's just the login in general.
Login in
There's
general.
not a regular normal.
Well, because you had talked about login 2s, login 5s, and things like that. So, is that a login 2? Or you don't know the difference? You can't tell the difference based on that ID?
The ID itself, no, but that is available further down.
Okay. Well, that's what I was going to ask, because here we've got an event on, it looks like July the 3rd, 7:42 p.m., which is UTC.
Correct.
So that would put that at what, 2:42? 3:42.
42.
So at 3:42 p.m., there's some type of event going on the computer, right?
Yes.
Okay.
And that one I specifically noted below is one of the ones I attributed to the system tasks.
Yeah. So we got an event going on, because I think you put in your summary report that basically Gary logged on at 1:20, and then there is a login 5 at 3:42, right?
Correct.
Okay. And with because Ms. Frankish had gone through with you, these are all UTC times too, all of these websites that he was visiting.
Yes.
Visiting. So he was at least on reading this, Congress trumps regulators regarding loans. That would have been at 2:32 he was reading that article, or the user was presumably reading that article.
The user had navigated to it. Whether they read or not is not something I'm able to see.
True. They were at least on that website.
Yes.
Okay. And then I'm assuming your testimony was that event at 3:42 is some type of Microsoft automatic?
The 340,
Something that it does?
The 342 one was one of the ones with the Type 5 login, which is those system tasks.
And you can't have a Type 5 login while you're logged in under Type 2?
No, those do happen.
That does happen?
Yes.
Okay. So you can't distinguish that type of event between a Type 2 and a Type 5?
I mean, I can distinguish between a Type 2 and a Type 5. Some of the screenshots are showing exactly that, where
Yes.
that information is available. Looking at the list like this, you cannot.
Okay. Well, this is your report, right?
Yes.
Okay. All right. And yet again, that's all 7.3. And I guess there is another one under the Internet Explorer. Right here on the 4th at 2:09 p.m. It was your opinion that was only some type of Microsoft security update or some type of Microsoft update?
Not an update, but reaching out to Microsoft servers to ensure that a Microsoft application was able to function properly.
Okay. And so is that's in UTC time as well?
It is.
Okay, what time would that have been not UTC time?
That would have been at 10:09:38 a.m. on the 4th.
Okay. All right. Now, I'm not going to go over all the CPAP information with you, but essentially, the gist of your testimony and your analysis of the CPAP machine was that Gary used his CPAP at least every day, according to what you can tell from that one SD card.
Yes.
Okay. Were you aware that Gary had gone to the hospital several times during the year, or at least one time during the year 2018?
No.
When you're calculating this or trying to figure this out, did the DA's office tell you to take the CPAP? I know not take it. You weren't there when it was taken. But did they reach out to you and say, hey, look at that CPAP SD card. Let's see what's going on?
They, the initial output from the initial investigation of the SD card just showed a bunch of files and not a bunch of information. I was asked to see if I could navigate it into a readable format.
Okay. So essentially from the CPAP, you learned that Gary used it every day, and the last time he used it was on the 3rd.
Correct.
On the 3rd when he took it off.
Correct.
All right. And going to the Dell, you were able to learn that somebody used that computer last time being later in the day, July the 3rd.
Yeah, not later in the day, but that afternoon, log in at 1:20.
Yeah, so somebody logged in and used it.
Correct.
And then there's not a top 5 login until 3:42.
Correct, and then no logins past that.
No logins past that, but you can actually have a top 5 login and a top 2 login at the same time.
Correct.
Okay. No further questions?
How big is the SD card in the trail camera?
I'd have to look. I don't remember off the top of my head.
How many images does it hold?
It had the images presented, and then there was another 20 or 30 images from a couple months prior that were in the deleted as well.
That aren't in your report?
That initial report was for Mr. Castellano or Kevin, who had produced the report based on anything with a July timestamp, I believe.
So we don't know what's on the camera from before the date of this report.
I've seen it and I turned over the files.
So we need to take something outside the presence of
We'll get there. Hold on. So there are images on the camera that were taken that were not displayed to the jury, correct?
Yes.
All right, we'll get to Wither's explanation. All right. Were there images that were not available to be extracted because they had been overwritten?
It's hard to answer it that way, but
Well,
there were.
you don't know how long it had been up, right?
Correct.
So if it had been up for a year and every month someone goes and deletes the images, eventually it's going to start overwriting it.
Correct.
Does it do that sequentially or does it do that randomly?
The file naming should be sequential, while the deletion is user-based and up to the user.
Does the computer inside the trail camera decide when it wants to start rewriting over files based upon when it wants to, or does it go through systematically and deletes the oldest files still on the SD card that's marked for deletion, or will it skip?
So as far as the SD, or as far as the unit itself deleting files, that is a setting that's inside the camera itself, which I do not know as far as the setting of that camera. As far as
William J. for the state.
James Owens on behalf of Sarah Boone.
Tony Henderson on behalf of Sarah Boone.
I do.
Ma'am, good morning. Can you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-7-7.
All right, Ms. Boone is seated at counsel's table wearing a gray suit and a white blouse. She is out of custody and unshackled. Mr. Beck, you arrived late, sir. Can I get your appearance for the record, please? All right, thank you. All right, we're here on a litany of different matters, multiple motions in limine. The state's motion in limine to exclude battered spouse syndrome evidence or exclude mention of battered spouse syndrome evidence until the defendant testifies to a justifiable use of deadly force filed October 6. Defendant's response to state's motion in limine to exclude battered spouse syndrome evidence or mention of battered spouse syndrome evidence until defendant testified filed October 15th, and then the defendant's amended response to same also filed October 15th. The defendant's motion in limine filed October 6th. The state's response to same filed October 6th. State's motion, objection and motion in limine to exclude decedent's medical records filed October 14th. And then the party's objections with regard to specific exhibits that may be sought to be entered at trial. The court has reviewed everything and reviewed all of your case law, and we're ready to proceed. I believe we should probably proceed first on the battered spouse motions first. So state, you may begin. And I also have reviewed as well the excerpts of the deposition of both Dr. Warner and Dr. Harper as identified in the state's motion.
Your Honor, for the record, I'm having Madam Clerk mark A, B, and C for identification purposes for this hearing. A is a copy of the defendant's statements that she made on body-worn camera to Deputy Sheriff Kayla Rodriguez on February 24th of 2020, as well as the interview that she provided to Detectives Kopsel and Lowen on February 24th, 2020, and February 25th of 2020. It is an identical exhibit as to what was provided to the court for review in chambers as a courtesy before the motion to suppress statements, as well as what is entered into evidence for that motion to suppress statements hearing that was held. State would move A for identification purposes in as one for the purposes of this hearing.
Responses to what was pre-marked as A. All right, what was pre-marked as states A will be received without objection as states 1.
B for identification for purposes of this hearing is the deposition of Dr. Harper. We would move that into evidence as states 2 for the purposes of this hearing.
Any objection?
No objection.
All right, what was pre-marked as B will be received without objection as states 2.
C for identification for purposes of this hearing is the deposition of Dr. Werner. State would move that into evidence as state 3 for the purposes of this hearing.
Any objection?
No objection.
All right, what was pre-marked as state C will be received without objection as states 3.
Your Honor is familiar with all those exhibits and has been able to review them prior to the hearing, so I will just proceed to the legal argument.
You may proceed.
Your Honor, this is a motion in limine. We are asking for a pretrial ruling based on the proffered statements that the defendant has made, which should, in good faith and reliance, the state should be able to assume that that will be her testimony at trial, given that her latest version of events was just given to our expert last week. So we are asking for a pretrial ruling on if that is the evidence that comes in at trial, will she get a self-defense instruction? Will she be able to then open the door to all the things that come with self-defense, such as reputation evidence of the victim for being violent, which she may or may not be aware of, that's not required under the law, or prior instances of violence between she and the victim, or the victim and anybody that she is aware of, because that goes to the reasonableness of her perception of an imminent threat of death or great bodily harm. We are not asking to not be allowed to talk about these things during voir dire. The defense cited numerous cases and spent some of their time in their response about the ability to voir dire that. That was not the purpose of our motion. I don't think we mentioned voir dire. Because we understand that the defendant can, like any other witness, change her story again. So we understand that we both, on both sides, we intend on spending a great deal of time on it as well for the state of Florida. We need to explore these issues during jury selection. But what we are asking from the court now, preliminarily, is if that is what the defendant is going to say in trial, and I'm not asking the court to make any credibility determinations about one version or another. We're asking you to treat this just like a C4 motion or a motion for summary judgment in a civil case. If this is what she says, does this amount to what they are asking for legally? And it's the state's position under the case law that no, because under her statements that she gave to the experts, there was no overt act taken by the decedent on that day. There was no overt action. And that's what's required under the law to trigger her response of acting in self-defense. There was nothing creating an imminent fear of death or great bodily harm to her until she committed 2 forcible felonies and a non-forcible felony. What her testimony was is, we were having a good day. Now, what's different, and again, we're not asking you to make a credibility determination about what's different, but what is different than what you had heard at the motion to suppress is, we were having a good day, but I'm on edge every day because of past instances of violence, including an instance the night before. But we were having a good day. We're out on the porch. There's a dartboard out there. There's puzzles that we're doing arts and crafts. We're doing everything to keep him preoccupied so he doesn't get sad or upset. Interjecting with some phone calls to his family, which she knows would potentially upset him, but that's her testimony. And then eventually, it comes to a point in time where they're sitting on the couch, and he reaches over to her and says, "Tag, you're it." And she apparently runs up to the shower to hide, and he apparently gets into the suitcase to hide, and it's not clear who's it. Eventually, she comes down out of the shower after she says she was getting cold up there and sees him in the suitcase and zips him up. And at the time that she zips the suitcase, what she describes as nearly entirely shut, but 2 fingertips could get out. Mind you, a 103-pound man, 2 fingertips. They're laughing. It's all fun and games still. There's still no overt act taken by the decedent during this entire calendar day to put anybody in reasonable fear, objectively reasonable in fear of imminent harm, of great bodily harm or death. And it's only when he begins to say, after she has zipped him up into the suitcase, and again, she is saying that she did not have malintent at that time. When he starts to say, "I cannot breathe," Now she describes to the doctors that she does have bad intent, and she wants him to feel what she has felt in the past. She gets angry, is her description. She shakes the suitcase, she beats it, it falls over, it flips over, he sticks his fingertips out, she hits him with a bat. So she's now the initial aggressor, and we'll discuss jury instructions as we get closer, but she's the initial aggressor, and she has now committed forcible felonies, aggravated assault, and aggravated battery, stating that I only intended to keep him in there for a couple of minutes. I believed he could get out. She never perceived, according to her, that he would die or face great bodily harm. And she just goes upstairs knowing now he's mad because she won't let him out. Now, because of the actions she took as the initial aggressor, she is facing death or great bodily harm from the decedent if he gets out, and she completely expects him to get out because her testimony is that he could get 2 fingertips out of the zipper. So, Your Honor, under the law, the state understands. We are deeply, deeply thoughtful about this request because of the risk of error, but this is just one of those cases, like the cases the state cited. There is no self-defense if that is what her testimony is. And therefore, the jury should not hear about any prior instances of violence, any reputation evidence, any battered spouse syndrome, unless and until there is testimony that is self-defense that's recognized under the state of Florida's laws. So what we are asking for is a ruling that if, and this is a motion in limine, and a motion in limine is, hey, this is what's proffered to the court prior to trial. If this is what comes in at trial, this is the court's preliminary ruling, unless something changes. What we are asking for is a preliminary ruling that if that is what her testimony is, then we should not be allowing introduction of past instances of violence, reputation for violence,
Go ahead, sir.
or battered spouse syndrome evidence. And furthermore, what the case law supports is our request that clearly this evidence can only come from her. There was nobody else in the apartment or townhouse that night. So she should have to testify before any of those things come in, and her testimony should meet the requirements of an overt act before any of this testimony comes in. It should not be allowed to come in prior to her testimony. And under the case law that the state cited, it's not unfair. It's not forcing her to testify. She chose to raise battered spouse syndrome. The state completely understands we have the burden of disproving self-defense beyond a reasonable doubt. But what the case law says is we shouldn't have to combat this. We can't put the toothpaste back in the tube until she actually puts forth the self-defense that justifies all this. So that is our request. We're not making any requests about voir dire because we understand she can come in and testify differently yet again at trial. And that's a discussion we'll have to have as well about how that will occur. The state's position is that if she changes her testimony yet again, she should have to give a narrative testimony. No attorney should be allowed to participate in putting forth new testimony about the events of February 23rd. Thank you.
All right, thank you very much. Response.
Good morning, Judge.
Morning, sir.
I'm a little confused, but I want to make sure, so probably can save some time here. My understanding is what the state's saying at this time, that there's no objection to raising this in voir dire to see how the jury would react or their feelings about it. So that's not it. So what that leaves me is, I guess the state's trying to say there should be no mention of battered spouse or anything like that in opening statement.
That wasn't my takeaway either. My takeaway from the motion and the state's argument today is from a evidence perspective, concepts or testimony or even opinion evidence about battered spouse syndrome cannot be raised, including any of the reputation or specific instances of conduct that are contemplated by self-defense until there's a factual basis for it. My understanding of the defense's Dr. Harper's deposition is that the basis of her opinion, and please correct me if I am wrong, but my understanding is that the basis of Dr. Harper's deposition is based on her 4 or 5 interviews or sessions with Ms. Boone as to what transpired on the day and night in question. Is that accurate?
I need to confer.
Sure.
Judge, if I could have you repeat that question.
Sure. So my understanding, well, let me ask, I'll ask a more of an open-ended question. What is the basis, factually, of Dr. Harper's opinion? So if we were at trial right now, for the purposes of this exercise, and you were going to call Dr. Harper to testify, what is the factual basis component under 90.702 in order to get her to testify? We're not dealing with her CV, her credentials. I'm not sure the state's going to have any position with regard to those, but let's just assume the state has no objection with regard to her credentials and that she is in fact an expert based on her knowledge, training, and experience in her field. What is step 1 under 90.702 to allow her to testify? What is the sufficient factual basis of her opinion?
Judge, I think her opinion would be based on several different things. Mainly, one of the things that her opinion would be based on is her interaction over the course of time with our client, Ms. Boone. That's one. But Dr. Harper has also reviewed other evidence in this case that helps her form the basis of her opinion, and also her knowledge of battered spouse syndrome. That has to be taken into account because, quite frankly, Judge, people who suffer from certain things, they don't know. That's why you have to, like if you have to get an expert opinion as to someone's mental health situation. I mean, a person doesn't really know that they're suffering from a mental health problem. They have no idea in a lot of circumstances. What they do is they get evaluated by a doctor. The doctor has experience of what signs to look for in these things, and getting those signs with what they told in outside sources too. They are able to make a determination based on their training and experience. So,
but based on the Akendo case, which is cited by the state as to what what battered spouse is it's an ambit of self-defense. So under the statute, are you traveling under 776.012 as your basis for self-defense?
yes, but this is the problem that I'm having here. Self-defense is a defense, it's an affirmative defense that's available to anybody. It's based on the evidence at trial.
But what's the overt act? Because in reviewing Dr. Harper's deposition, there were specific questions by the state inquired of her about the language, specifically in those statutes, about the imminence of fear. And she was unable to answer those questions. So my question really is, what's the overt act by the victim which would have given rise to self-defense? Because the case law, taking aside the state's case law under the stand your ground concepts, which I find distinguishable, because under 776.032, there's a specific statutory scheme for pretrial stand your ground motions. So I find those cases distinguishable for that very reason. But there's specific case law, bless you, there's specific case law that talks about in the self-defense realm that the state has cited to in their motion that an overt act is needed. What is the overt act?
Judge, the overt act has to come from testimony, and I agree in this case, but that has to be the testimony of Sarah Boone for that overt act. And that testimony can only take place at trial. In making a determination of whether to give the self-defense instruction, it has to be based on the evidence presented at trial.
I agree with you on that. I completely agree with you on that. And the case law is clear that if even there's a scintilla of evidence, I have to give that instruction. But we're not dealing with the jury instruction right now. What I'm dealing with right now is pretrial. The state saying you cannot proceed on battered spouse. There's two avenues in this motion. Avenue one is you cannot proceed with battered spouse because of the factual reasons based on Dr. Harper's deposition as to what she's going to be the basis of her opinion. Battered spouse cannot be entered. Alternatively, you cannot talk about it until there's foundation. That's my takeaway from the state's argument, that before battered spouse is argued or provided or opinion, there has to be that foundation to it. And the linchpin for me is the overt act issue. That how can we have anybody testify to opinions or any of the reputation or specific instances of conduct that we permitted until that overt act is established? What's your response to that?
My response to that, if I'm understanding you correctly.
And if you need to reframe the question, please.
Because it's procedurally. There's no way that we could come in here and put Dr. Harper on the stand before Sarah Boone. It just doesn't work. Because to even establish the relevancy of Dr. Harper's testimony, Sarah Boone, who's the only witness there at the time, I agree with that with the state, has to present evidence of self-defense. Has to present the evidence of the court, that overt act. It's not based on what the doctor perceives or what the doctor was told by Ms. Boone or what questions were asked at that deposition. I don't know. Mr. Owens took the deposition. The questions, though, at the depositions are limited and the doctor answers. But that's not what this has to be based on. What it has to be based on is what does Ms. Boone, in this case, testifies to on the stand. And if any of that, if any of that presents a scintilla of evidence to award the self-defense instruction, then the self-defense instruction should be given. That's the first step. Everything follows after that, Judge, because this isn't a situation where I think it's appropriate to make a pretrial ruling, because the ruling has to be based on the evidence that comes from that witness stand. Now, any of the evidence is subject to cross-examination, impeachment, anything like that. But that's a wait for the jury to determine. But as to the admissibility of the evidence, it has to start with Sarah Boone. A judgment can't be made or a decision cannot be made until the testimony of Sarah Boone takes place at trial. This is just procedurally incorrect.
Any other arguments, sir?
No other argument.
Thank you. Rebuttal?
This is procedurally correct. Parties are allowed to get motions in limine based on the proffers of evidence that have been made prior to trial. Apparently, opposing counsel has not read the depositions, or he clearly didn't attend them because he was not there. But the court has before it the statements that Sarah Boone made when directly asked, what happened that day? What happened next? And there was no overt act taken by the decedent on that particular day. What they want to do, and what is not permissible under the case law that I have cited, in particular the one that says you get a threatening text and then 2 days later you can't go slit somebody's throat because of the threatening text 2 days earlier. Not to dehumanize Mr. Torres at all, but to give you this analogy. If somebody owns a bad dog and that bad dog bites and that bad dog is bitten in the past, but on this particular day, the dog is just doing arts and crafts and puzzles and hanging out, drinking some Woodbridge Chardonnay, and you put the dog in the suitcase, and then the dog barks because it's in the suitcase and doesn't want to be in the suitcase when it's zipped up. That triggers you to, I remember when the dog bit me in the past. You can't, that's not how this works. That's not how self-defense works with or without battered spouse syndrome. There has to be an overt act. You can't bootstrap and make up a fictitious act of violence on that day based on the past violence. That's not what the case law allows. And the state is asking, unless they are saying that the testimony will be different at trial, we are asking for the court to prevent them from saying anything about this during opening statements, because they will know, based on the court's ruling, what your client has already said to Doctors Werner and Harper does not admit self-defense evidence into this case. So that's what we're looking for, is that ruling. If this is what the testimony is at trial, then self-defense is not going to apply, and all the ancillary prejudicial things that come with it, reputation evidence, past instances of violence, battered spouse evidence, is not coming in either. Now, if they make some statements and promises that they cannot fulfill in opening statements, then that'll be on them. King versus State will allow us to point those things out to the jury, and it will not be burden shifting. But that's what we're asking is, this is a proffer, just like any other proffer testimony, like a sex crimes case, where we file a deposition of a Williams Rule victim and ask the court to rule prior to trial, hey, if this is how the Williams Rule victim testifies, and it's clear and convincing and it meets all the standards under 404 and 403, can this prior act of sexual violence come in during the trial? This is what parties do all the time, is get pretrial rulings on crucial matters like this. This is a crucial matter because the tip of the iceberg is the second-degree murder. The rest of the iceberg, the 99% of what has been going on for the last month and a half, is the self-defense that just isn't there. It wasn't there under her former statements to the police, and it's not there under her current statements. So we're asking for a ruling, a motion in limine, which is subject to change based on the evidence at trial. But if this is what the evidence is at trial, the court should not allow any of the battered spouse, any of the prior violence, any reputation evidence in. That's all we're asking for.
Okay.
Thank you.
All right. Thank you.
Judge, could I respond?
Briefly.
Judge, it is not the responsibility of the defense to present their case at a pretrial hearing. However,
But the problem is, in the state's argument, in the case law, which the case law has been presented by the defense in your filings, are not germane to the issue. We're not addressing jury selection and the standard of proof and the burden with regard to self-defense, you establishing a prima facie case, and then the higher standard that the state has to overcome it. There's no dispute as to that. The issue is the necessary predicate to establish battered spouse. And the state's argument is that due to the lack of an overt act, based on what Dr. Harper has relied upon, to wit, the multiple interviews or sessions with Ms. Boone, that element seemingly is lacking. We all know what elements are, right? If it's a negligence case, it's duty breach causation. In this case, it's the elements based on the jury instructions are George Torres is dead, she caused the death, and it was done so in a depraved heart manner. I may have butchered that last element, but those are the elements that need to be established based on the jury instructions. Similarly with self-defense, the case law talks about the overt act.
yes, sir.
And then the flashpoint of the defense's argument is that the facts which were provided to the expert, who in turn will testify to battered spouse, that flashpoint, that overt act is lacking.
It's not, Judge, but I find myself in the position now to disclose what our view of the overt act is.
Okay.
That's what this is what this motion has put us into. So it's an exercise of the state to learn our theory or our view of the evidence, because the overt act is in the physical evidence. And the overt act is mentioned to Dr. Harper in the deposition as to the reaction of Ms. Boone by the overt act. And the overt acts, I have to tell you, his hand is coming out of the suitcase. That means he's about to get out of the suitcase. Now, based on history and everything else, she doesn't have to wait to see what's going to happen when he gets out of the suitcase. It's clear what's going to happen when he gets out of the suitcase. It's followed up by physical evidence, because there's a picture provided of Mr. Torres's hand that shows a mark on that hand that it matches up with the bat. That's the overt act. It's like a gun, okay? You don't have to wait for them to pull the trigger. You don't. And it's based on all the evidence in the case, just not testimony, but also physical evidence that might support the testimony.
Thank you, sir. All right, the court has had the opportunity to review the motions, review all the case law. The state's motion is going to be granted in part and denied in part. With regard to the state's request to exclude battered spouse syndrome evidence outright, the motion is denied. As to specifically Wagner, for the reasons identified in the court's prior rulings as to the concept of argument, again, there's no outright evidence of accident, not argument, excuse me. As to the state's reliance on Lantz, L-A-N-T-Z v. State, 263 Southern 3rd, 279, no argument of self-defense was ever offered in that case. I find the cases of Reed v. State, 213 Southern 3rd, 1110, Rudin, R-U-D-I-N v. State, 182 Southern 3rd, 724, State v. Woodson, 349 Southern 3rd, 510, and Morris, 325 Southern 3rd, 1009, distinguishable as all of those cases were traveling under 776.032 for stand your ground hearings. It's undisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court, 916 Southern 2nd, 750. I find the departure from the essential requirements of law argument by the state factually and legally distinguishable, as there was a specific statute for the state obtaining medical records as relied upon in Roberts v. State by the 6th ECA in May of 2023 WL 3262633 at Pinpoint Site 2. So for those reasons, the state outright motion to preclude or exclude battered spouse syndrome evidence in toto is denied. With regard to the second portion, that excluding mention of battered spouse syndrome evidence until there's a basis for it, the court's going to rely on Ladd and Medina, specifically that there needs to be testimony provided for the expert to testify to the battered spouse syndrome, and there needs to be sufficient predicate established for that self-defense. So I'm going to preclude any mention or testimony in the form of expert testimony as to battered spouse until that necessary predicate as identified in Ladd 564 Southern 2nd 587 has been established. Any questions with regard to the state's ruling? I'm sorry, the court's ruling, forgive me. Defense.
Meaning?
You want to mention an opening? You can mention an opening. Certainly I'm going to allow you, and the state at this point has no problem with the concept of battered spouse being addressed in voir dire, and even if the state objected to it, I most likely would overrule it based on the litany of case law that you cited, that you're allowed to dive into those things during jury selection. As to should the defense put on a case, the predicate under Ladd needs to be established before any expert opines to battered spouse.
My concern is opening. Can it be mentioned in the...
Yes, that's your decision. That is your decision if you want to mention an opening. There's no preclusion from you doing that. Okay. Any other questions with regard to the court's order on that matter? State.
No, Your Honor.
Defense.
No, Your Honor.
Okay, thank you. Moving now to the defendant's motion in limine filed October 6 and the state's response to same. It looks like we've reached some level of common ground with regard to that motion. The court is going to grant the motion with regard to the statements on page 69 through 71 of the transcript of the February 25, 2020 interview between Detectives Lowen and Kopsel and Miss Boone from page 69, line 6 through page 71. That will be granted to the state not objecting to same. That leaves us to the statements on page 53, line 11, 53, line 13, line 14, page 55, line 24, page 56, line 1, and page 92, line 15. With that, defense, you may proceed with any argument. Similar to the last motions, I have reviewed all of y'all's case law.
I believe there's some state witnesses here. We would like to invoke them.
Okay.
The rule of sequestration applies to testimony of other witnesses, not to anything else.
Response?
Is there going to be testimony?
Not from the state.
You've got state witnesses here, do you know?
She's allowed to be here to watch.
I understand, but I want to know whether she's going to testify.
I said there's no state witnesses.
So that's a no. May proceed with any argument, Mr. Owens. Yes, sir. I have reviewed the 2.8 instruction prior today. Thank you, Counselor.
Judge, the problem is the state attorney, when they filed the response, they didn't include the highlighted portion that's italicized at the beginning. Police opinions and statements regarding guilt are generally inadmissible and must be redacted from recordings introduced into evidence unless redaction would render the defendant's relevant admissions incomprehensible. If a recorded interview cannot be appropriately redacted, the trial judge must, upon request, give the following limiting instruction immediately before the recorded interview is played for the jury. That section, which is comments directed to the court, was not placed, to my understanding, in their response.
Okay. Any other argument?
Judge, this was a 2-hour interrogation that occurred the day or two after the event. And the day prior to this time, or that morning, the detectives uncovered the 2 videotapes, the 2-minute video that Sarah Boone had recorded, and then followed up 11 minutes later with a 22-second video that she recorded and they found on her phone, which I believe from the interrogation discloses that Sarah did not remember making those recordings. But the purpose of law enforcement's position about having her come in was to interrogate her in an attempt to get a confession from her to the murder. They spent 2 hours trying to do that any which way they possibly could. And the law says that they're allowed to use, and I cited several cases. I cited the Smith v. State case, the ODEH, O-D-E-H v. State case, and the Eugene v. State. And in those cases,
I didn't see a citation to Eugene. I mean, Eugene's included in ODA, but I don't.
Eugene is found. Do you need the cite?
I have it. It's included in ODA, but you did not cite it in your motion.
Okay. Eugene is 53 Southern 3rd, 1104. But law enforcement are entitled to use a variety of interrogation techniques to try to elicit a confession to the crime. But as in that case, in spite of the detective's efforts, Sarah Boone refused to admit that she was guilty of the murder. But as a a last resort, Judge, and it was a 2-hour interrogation. It was the last portion, at least the last quarter. It may have been less than that, is when the detectives made some statements that are highly prejudicial to the defendant and tend to be opinion and tend to invade the province of the jury. And that's why this special jury instruction 2.8, recorded interview, effective law enforcement statements on the defendant, has that italicized portion in there. And the statements we're referring to under my motion, the second section of evidence to be excluded, page 53, line 11, well, he's dead as a result of your actions. And then paragraph 9, line 13, he's dead as a result of your actions. She responded, line 14, I understand that. And then paragraph 11, page 55, line 24, I have one last question. I mean, you realize you're the person that killed him, right? Sarah Boone responds on page 56, I thought about that. And then lastly on page 92, well, intention or not, here's the detective distinguishing how he interprets the law and her culpability. Well, intention or not, George is dead, and you act like when you say unintentionally, that absolves you from everything. That is exactly the kind of opinion testimony from law enforcement that the courts are worried about. The probative value of that type of opinion testimony about her guilt is outweighed by the prejudicial effect. Thank you.
Response.
The state stands by the case law that we cited and that the jury instruction that would be read. I didn't feel it necessary to include italicized portions of comments to the court because this is what would get read to the jury. Those statements are designed to get responses from her. They did get responses from her.
Let me ask this question first, Mr. J. Do you disagree with counsel's representation of what is reflected in the Q&A at that point in time?
To the extent that he is making the argument that they're expressing an opinion about the
No, the words, not his opinion, not his thoughts or what it means, but the black and white verbiage is reflected in the motion. Is that what's reflected in the recording?
I'm accepting that he would not misrepresent that to the court.
Okay, thank you. You may continue.
And as far as the last line on page 92, line 15, if something's designed to get a response that a normal person would respond to and there's no response, that still makes it a relevant statement. He's not giving an opinion on the law. He's giving an opinion about her reactions to this interview and trying to get a reaction from her when he says, well, intention or not, Jorge is dead. You act like when you say unintentionally, that absolves you from everything. He's not stating that that is a legal defense. He's just commenting on what has transpired in the 92 pages of the interview. So we defer to whatever the court's ruling is.
Okay, thank you. Any rebuttal?
Just for the state attorney not to put that in there, the italicized portion, where the Supreme Court is giving instructions to the court with those comments. For them not to put that in there, I disagree with it.
Okay, well, the Jackson case speaks for itself, and the court has reviewed it.
Thank you.
All right, thank you both for your motion, your motions, your responses, and the case law. The court is going to grant the defense's motion. I disagree with the defense, or with the state rather, as identified in their response that the only issue is battered spouse. The issue is one of the elements is cause, and those three statements go specifically, I believe, to opinions as to the cause of Mr. Torres's death. So the court is going to grant the state's motion as under the Bush case cited by the state. Law enforcement's opinions are inadmissible due to the prejudicial effect that they may have, and I do find that this is the expression of law enforcement's opinions as to the guilt of the accused. As such, the motion is granted, and those will need to be redacted from. I apologize, thank you. The defense's motion is granted for those reasons. Any questions or clarifications with regard to the court's ruling? State. Questions or clarifications with regard to the court's ruling? Questions or clarifications with regard to the state's ruling? Or the court's ruling, excuse me. All right, that takes us now to the state's objection and motion in limine to exclude decedent's medical records. I've reviewed that as well. State, you may proceed.
Judge, just the other night, I received 550 pages of medical records regarding the treatment of Mr. Torres from 2 incidents, one in 2017 and one in 2018. A third email that I received from Mr. Owens purported he believed that they had attachments. They did not. I replied to him as such, and I have not gotten any additional emails with attachments regarding the medical records. So for the purposes of this hearing, all I'm arguing about is the 550 pages that I have been provided. One of those instances involved a narrative being given by the patient, Mr. Torres, that he had put his hand through a plate glass window.
This is the 2018 incident, correct?
Yes.
Yes.
And his wife, the following day, made him go in and get treatment. There was a 4.5 centimeter laceration that required 2 sutures. There is no history in the narrative about any violence that the decedent had committed. So I anticipate that Ms. Boone, when she testifies, will give us an explanation about how this was an instance of past violence that she was aware of by the decedent. So making that assumption, then what the state is asking for is the 57 pages seems excessive. This jury is going to have a lot of information to weigh and consider. Not every page of these 57 pages is relevant. What is relevant is, yes, he came in for treatment. That narrative, and the history that he gave of putting his hand through a plate glass window and that he got sutures, that corroborates her testimony. I understand why she will need corroboration for her testimony to bolster her credibility. So if she testifies that way, we get it, but it's just excessive and it's going to be confusing. They don't need to read 57 pages of all of his treatment. The second batch was 487 pages regarding an incident on Christmas of 2017, when what the decedent reports in the narrative to the hospital is that some unknown men jumped him and beat him up. Being a victim of violence is not relevant in this case. I expect there will be a story based upon the testimony that we've taken from the experts that this all happened at a family gathering, and one of the decedent's brothers learned from Sarah Boone that Sarah Boone said that the decedent, had committed violence against her and then beat him up. That's not the same ilk as corroborating violence with breaking windows or whatever it is that caused his laceration, whatever she ends up testifying to about the 2018 incident. But this incident, it's irrelevant that he got beat up by his brother. It's irrelevant that he suffered the amount and severity of injuries that he did. That is not required to corroborate her testimony that, I don't even know if it comes in, that she makes an out-of-court statement to the decedent's brother that something is true that happened in the past. That seems like classic hearsay. I'm not sure how she would get that in. I don't know that the 487 pages is needed to corroborate that. And if the court, like I stated in my response, if the court believes that it is necessary to corroborate her story that he did get beat up by his brother, then again, there are narrative parts of these medical records. Generally, I would say in this particular instance, it was a handful of pages that give the narrative as to what happened. And I don't know that it's relevant what the treatment was that he received, but there's narratives of that as well. They don't need to be bogged down with 487 pages of toxicology reports, nursing rounds, just all the things that I'm sure the court is familiar with from your past experience that are in these medical records. It's unnecessary and it's prejudicial. Its probative value is substantially outweighed by its prejudice, confusing, repetitiveness, as I outlined in my response. So that's our position.
Thank you, sir. Response.
Judge, as you know, we got on this case about 45 days ago, and I can't tell you how many pages of discovery there is that we've had to go through. And 2 or 3 weeks ago, the state attorney provided us over 500 pages from either telephone calls that my client was involved in from the jail or tablet communications, which are kind of like emails or text messages. And that hasn't been narrowed down, but that was given to us. So that's something else we had to stop and go through over 500 pages. And they haven't narrowed that down to which ones they believe are incriminating to her.
Understood. But respectfully, that's not the issue before the
I
court right
understand
now.
that. But yes, the medical records are going to be narrowed down. And yes, we would have to make some tie to Sarah Boone's testimony to whether or not their medical records of the decedent, George Torres, are admissible to corroborate her stories about the incidences of violence and whether they match up. But yes, I agree there's going to be a narrowing down, but it's kind of premature about that. They've got several volumes. I assume before they introduce something, they're going to have to narrow it down. Did y'all not have George Torres' medical records prior to me sending them to you?
No, we didn't.
All right, well, we took the deposition of Dr. Harper, and as you know, Judge, these forensic psychologists, when they're trying to make an opinion as to battered spouse or whatever the case may be, they rely on their assessment involving the personal contact and interviews they have with the client. But a lot of it is any other collateral evidence that tends to support it. That involves arrest reports, that involves court records, that involves psychological notes, that involves medical records. And at that time, when the state took Dr. Harper, our witness's deposition, she said, yes, I did rely on George Torres' medical records. So they were well aware.
That doesn't mean they come into evidence.
I know that. I didn't say that. But they were well aware that that's one thing that she relied upon. A lot of that collateral evidence doesn't come into, and it's going to be...
I need to jump into the breach here. I understand all of that. I understand that there's been volumes of documents that have been provided between both parties. And I understand, based on my review of the highlighted portions that the state pointed out in their motion, as to what Dr. Harper relied upon. None of that is germane to the state's argument. And you've admitted that there needs to be a narrowing down. So let's just kind of compartmentalize what we've got here.
So it's premature. It's premature. I agree it needs to be narrowed down. And then based on Sarah Boone's testimony...
You are the proponent of the evidence.
Yes.
So you have to establish relevance.
I agree.
And you have to establish that is not so substantially unfairly prejudicial.
Yes.
That the prejudice does not outweigh its probative value, including but not limited to the other identifications in 90.403.
Yes, sir.
So my question is, sir, with regard to the 2018 incident of the fist through the plate glass window, and I can't recall 40-some-odd pages I think the state identified as that, what of those 47 pages is germane to an incident of violence that may be needed to establish the self-defense concept of those 47 pages?
It will be relevant after she testifies about that incident.
All 47 pages?
Maybe not all 47 pages. I've agreed that some of it needs to be narrowed down.
Okay, well, what of it needs to be narrowed down, since
Well,
we have some level of common ground here?
My case is not going to be presented, I would assume, until next week, so I've got a little bit of time. I'll let the state know.
That's not how this works.
Okay. I can't let you know today, Judge. I'll narrow it down, or we'll talk in the next couple of days.
Well,
by
the state's
Friday.
position is that the narrative should be permitted as to the 2018 incident, the why Mr. Torres was there. But the nursing rounds, the charts, the follow-ups, treatment, anything in the future other than the 4.5 centimeter laceration that required 2 sutures. I understand the narrative as to what transpired. What else is relevant? And I haven't seen these 47 pages, so I'm not sure there. I'm relying on counsel's representation.
I don't know. I'd have to look at them. But in one of the medical records, George Torres was over a .31 BAC. Every time,
In 2018?
2018.
I'm talking about the 2018 incident with regard to the plate glass
I have to look
window.
at the records, but there is other evidence in those records that's going to be relevant after she testifies. That's when she gets beaten, when he gets really drunk. Or that's when he does something violent or threatens to do something violent when he gets really drunk. In one of those incidences, he was over a .3. When he gets over a .2 to .3, that's when he gets angry. He's fine up until that point. We're going to establish that. I don't want to put on my defense today, but Judge, there is going to be relevance to more than just the narrative of those medical records. I'll narrow it down by Friday. That's the best I can do.
Okay, what about the 2017 incident, 487 pages, and those documents pertaining to the facial reconstruction and anything thereafter? What does that have to do with anything?
Same thing. You know, it's going to be based on her testimony, and then the judge is going to have to make a decision about whether that's admissible based on her testimony about what happened.
But what does the facial reconstruction, surgery, pre-surgery, post-surgery notes have anything to do with whether or not that incident actually took place?
That's going to depend on Sarah Boone, depending on what her testimony is, and you'll have to find, based on that, whether or not that's relevant and probative to the case.
That's not how motions in limine work.
I don't know what else to tell you, Judge. She's going to have to testify, and then we'll make the arguments as to the admissibility of that.
I'm struggling with understanding how I can understand BAC results. I can understand that based on Dr. Harper's deposition. I can understand the narrative as to why they were there. I don't know what are all in these records. What does nursing rounds or pre-op, post-op of facial reconstruction surgery have anything to do with an incident that purportedly took place on December 24th, 2017? How is it relevant?
Some of those may not be. Some of the records may be relevant, depending on Sarah Boone's testimony about how what happened to him was tied to what he did to her.
Okay. Anything else?
That's it.
Response?
The two parties' discovery responsibilities in a criminal matter are not equal. The state of Florida has a duty to disclose anything that anybody knows or may reasonably be calculated to lead to relevant information to the defense. The defendant's obligation is to let us know what they're going to use in trial. So for them to come in today on the third day of jury selection and to tell us that it's premature to ask for what is going to be their actual evidence in a trial is wrong. They got these records, and I understand that they're the 9th set of attorneys for Ms. Boone, but the defendant got these records in 2022 or 2021. And they just get disclosed to me overnight a couple of nights ago. In their discovery responses, in the First Amendment, Second Amendment, Third, so on and so forth, for weeks they were telling us that they didn't have them and they were waiting for them, but they were sitting in Ms. Boone's box, apparently, that Billy Lane had acquired years ago. So it's not premature to ask, and it's not unfair to ask for what is going to be introduced in this case or attempted to be introduced, particularly given the court's rulings. We had rulings from this court, I think you entered it August 5th or August 6th, setting forth a schedule for what are you both. In the state too, we both disclosed what are we actually introducing. The state has actually narrowed down the digital phone evidence from the defendant greatly to about 160 pages of the PDF from the thousands that it was, and handful and a few dozen pictures and videos. We have done everything we can to narrow it down. We're not asking for much here. We're not asking for much. And just to bring the point about the BAC, Jorge Torres had a 342 medical blood, so there's probably some conversion, 10-15% for legal blood, at the time that he was admitted for his facial injuries. That would be a different picture than on the date of the plate glass window. On that date, again, I expect that the testimony from the defendant will be that he was the aggressor, the violent one, and his blood alcohol level would be relevant for the plate glass window one. But I'm struggling to understand what his BAC's relevance is if we're all at a family gathering at the Torres's and she says something that triggers one of his brothers to violently beat him nearly to death, what his BAC's relevance is on that particular occasion, unless her testimony is the decedent was being violent with her that day, and that's just not my understanding of how the deposition's read. So, Judge, we're not asking for much. I don't think Friday's sufficient. We're attaching jeopardy to this case as soon as we swear this panel in, hopefully tomorrow morning. Thank you.
Thank you. All right. The court has reviewed the motion and has reviewed both the arguments. I'm struggling with the relevance on some of these things. So I'm going to grant the state's motion in part to the factual narratives as to why Mr. Torres was seeking treatment. That will be admissible. I'm going to overrule the state's objection with that, and I think they've conceded that that is relevant. Information regarding blood alcohol content in both the December 24, 2017 incident and the 2018 incident, I find potential relevance, so I'm going to overrule the state's objection with regard to those. However, the balance, I'm going to sustain the state's objection and grant their motion in limine unless there's evidence provided in the defense's case in chief that make these other documents relevant. Because at this point in time, it is unclear to me how the balance of other hospital records, nursing rounds, pre-op, post-op, the surgery itself from the 2017 incident are relevant to a fact of consequence, be it any of the material allegations the state needs to establish or any material allegations the defense needs to establish for the purposes of self-defense. I'm not foreclosing you, but there needs to be something for you to link these documents together for me. All right? Any clarification or questions with regard to the state's rule or the court's ruling? No, defense? No, sir. All right, thank you. That now takes us to the objections to the evidence. Give me a moment. We have the defendant's objections to state's digital exhibits filed October 15th. The state's state's response to defendant's fifth amended reciprocal discovery exhibit list filed also on October 15th. I have reviewed these. I'm a little bit of a loss in the state's response because I don't know what items 1, 2, et cetera are. It just identifies them. I'm not sure what it is that they are.
It's tracking their fifth amended exhibit list. As I pointed out before, it got really confusing because as they added things, it would not go to the end of the list. It would get put into the middle of the list. So I started over, scrapped my first response to the first amended one, scrapped my second response to the second amended one, both of which were filed on September 27th in a timely manner. And this is why my paragraphs start with 0 in my response, because they have a paragraph 1A, and then they list the items, and I wanted to make it very easy and clear for the court to just be able to flip to what paragraph I'm talking about for each item, tracking their fifth amended exhibit list.
But here's the problem that I'm having. On September 27th, I see the notice of provision of defendant's third amended exhibit list. When was the fifth amended exhibit list provided?
That might be a problem with them not filing things with the clerk of the court.
Okay.
I'm getting copies of some pleadings, but they're not bait stamped with the clerk of the court's e-filing system on the top left, so I'm not certain that they've filed anything with the clerk of the court.
Here's the other problem that I have. All I see on my end is the notice of providing. It doesn't identify anything. It's a one-page document. So it's hard for me to say what, I know you may have seen it, but the court hasn't seen it based on what's been filed.
I believe I would direct any questions about why that's not filed with the clerk of the court to the defense.
Okay, all right. I need clarification, Mr. Owens, as to when the fifth amended reciprocal discovery exhibit list was filed and what is in it. Because the notice that I see in the court file from September 27th is just a notice. It doesn't identify anything for me to line up item 1 and item 1 as to what they purport to be.
You're asking for when it was filed? We're checking on that, when it was filed. What was the next question?
All I have is a notice. So on September 27th, there was a notice of provision of defendant's third amended exhibit list. And it's just that. What we intend on utilizing has been provided. But I don't have anything else as to what those items are.
Okay. Did you want us to provide you with a copy of those to your JA?
Or you can send it to Madam Clerk and she can print it out to me, because I'm having difficulty lining up what these things are, because all I have in the court file is this was sent on this day, but I don't know what any of these things are.
We can move on to something else and let me get.
Unless we've got some housekeeping matters to address for this afternoon. But unless I'm missing something, the only other thing that we've got teed up to address this morning is the objections. Okay. Give me 1 second. Okay. All right. I got an email this morning from Juror Services. Juror number 551. I don't recall from what panel. No, I'm sorry. Juror number 471, panel 3, seat 48. Tested positive for COVID, and Jury Services has instructed him not to return. Juror number 551.
What was the first one?
Sure. Juror number 471, panel 3, that would have been yesterday morning, seat 48. Advised Jury Services this morning that he was not feeling well. After leaving the courthouse, he tested positive for COVID. I have instructed Jury Services to excuse him because we don't need that floating around. The other juror, 551, I don't have any other information as to what panel or seat. She took a COVID test and was negative. She is planning on reporting today. So due to the shrinking from 54 to 53, jury selection will take place here in 12 Alpha this afternoon as opposed to the 23rd floor. The deputies have already brought in additional chairs so that we can fit 53 people in here. That's the only other housekeeping matters that I have to address. So are there any housekeeping matters to address from the state before we address the objections issues?
Is it wise to not utilize that expanded space when two of these panels, or at least one of these panels, has already been exposed to COVID up in the 23rd floor? Would it not be wise to use the bigger space in 23 since one of our panels has already potentially been exposed to COVID, as opposed to packing everybody in like sardines?
Response.
I don't know the layout of 23, so
Can you all approach this for a second? All right, court's going to take a 15-minute recess to address jury selection location this afternoon, and to give the defense the opportunity to provide the fifth amended exhibit list. With regard to juror 551, what say the state?
No objection to the, if she doesn't have COVID, then I don't have a motion for cause.
Okay. Any response from the defense? Correct. That is correct. Anything in addition to how she was feeling? I read you what was provided to me. Okay. Court's going to be in a 15-minute recess. Thank you.
Aware of. Did she have a debit card?
Yes.
How did you know that?
She told me.
And would you go shopping together?
Yes.
When you would go shopping together, would Gary know where Melody was shopping?
Yes.
How would he know that?
Because if she ran the debit card, he got a notification immediately.
Did she ever explain to you how she felt in her marriage?
Yeah, she wasn't happy in her marriage.
Did she ever express to you why she wouldn't leave Gary?
Yeah.
What was that?
It had to do with wanting to stay because if she left, she wouldn't have access to any funds.
Did you learn about a man named Rusty Barton when you were walking with Melody?
Yes.
Who was Rusty Barton?
Rusty Barton was her boyfriend.
Whose boyfriend?
Melody's boyfriend.
And did you learn at any point that Melody had, how would she contact Rusty Barton?
By phone.
How many phones did you know Melody to have?
She had 2 phones.
Do you know how Rusty was saved in her phone?
Yes, he was in her phone as XO.
And would you see him call or see her text? Is that how you knew
Yes. Yes.
that? Do you know when Rusty entered her life?
I don't know.
Was it prior to you and her becoming friends?
Yes.
He was already in her
It was
life.
an established relationship prior to that, yes.
At any point did Melody send you her debit card?
Yes.
For what? Well, let me ask you this. Where were you when that happened?
I was in Minnesota. I was in Bagley, Minnesota.
And why did she send you her debit card?
She asked me to use it somewhere locally there because she had told Gary that she was with me.
Where was she, in fact?
She was in the Bahamas
With who?
with Rusty.
Ms. Cooper, I'm going to show you. Can I approach the witness, Your Honor? I'm showing you what's been previously marked as State's Exhibit Cooper 1. Do you recognize that address?
Yes.
State moves to admit State's Exhibit Cooper 1.
Submitted.
What did she want you to do with the card?
She wanted me to use it up there in Minnesota.
And did you do that?
Yes, I did actually.
Where did you use it?
I used it at a little cafe in Leonard.
Is this the cafe that you used?
It is, yes.
And was that the date on which you used it?
It is, yes.
Did you and Melody remain friends?
After which point?
Up until today. When did the friendship change?
I would say the friendship had changed when I had started going up to Minnesota and spending a lot of time away. I had moved. I wasn't her neighbor anymore, so we had less frequent contact with each other, and that happened. I'm sure early 2018, somewhere in there.
How many phone numbers did you have for Melody?
I had 2.
Okay. Did you show that to the police?
I did.
You spoke with the police?
Yes, I
After
did.
what happened to Gary? Okay. Do you remember when that was?
Yeah, it was just a few days after his death.
And did you tell them all of the information that you and I are discussing today?
Yes, I did.
Would Gary restrict what Melody purchased?
No, he did not. Not that I'm aware of.
Just had knowledge about what she's purchased?
Correct.
That's all I have, Ms. Cooper. Thank
Okay.
you.
Good morning, Ms. Cooper. My name's Michael Ray. I represent Farris. How are you?
I'm well, thank you.
You flew down involuntarily from Minnesota?
Yeah,
Okay. Now, when you lived, you didn't actually live on Purcell. You lived off one of those little side roads that come off Purcell.
correct, Hickory Hill.
And you and Melody, y'all used to walk up Purcell, up to Birmingham Highway, and around the neighborhood around Terry Braswell's house.
Yes,
Yeah. And Terry was a friend of yours too?
yes.
Okay. And y'all met him walking?
No, I knew Terry for years.
You knew him for, is that because of his business?
Yep, and he had a daughter that used to ride horses where my daughter rode horses, so I met him years ago.
Okay. And then you and Melody were out walking, and he was mowing his grass, and you were like, hey, there's Terry.
Yep,
Okay. And that's how Melody and Terry Braswell met?
correct.
Okay. Moving on to the phones. Ms. Francis asked you if you had 2 phone numbers for Melody. That is correct, right?
That is correct.
In fact, when y'all used to go walk, you saw her that she had 2 cell phones?
Correct.
Okay. Did Terry Braswell, did she ever have her 2 cell phones when y'all were talking with Terry Braswell on your walks?
Not that I can recall, possibly.
Possibly, though. Regarding the financial aspect of it, I believe you testified that Gary didn't limit what Melody could buy, correct?
That's correct.
And I think you actually said in your interview that it didn't have anything to do with about Melody spending money, right?
Correct.
It was just, he just wanted to know what she was spending money on.
He wanted to know where she was.
Yeah, where she was or what she's buying. All right. Now, you were aware that, because you had been to the Farris' home, right?
I had, yes.
Okay. You were aware that Melody and Gary basically lived separate lives,
Yep,
and that she lived upstairs and he lived downstairs.
correct.
All right. Now, you had also met Gary at least on one occasion,
Yes, I had, on a couple of occasions.
on multiple occasions. What was Gary's demeanor like when you met him?
Quiet. It's hard to explain. Different.
Okay. Was he friendly?
No, I didn't find him friendly.
Just, because, I mean, you have trouble in your interview too, trying to describe your interactions with it. He just basically ignored you, didn't he?
Yes,
Just paid you no mind whatsoever.
correct.
And I think you actually said that he wouldn't even make eye contact with you.
Correct.
Was that every time you met with him? Or that you saw him?
Yeah, it was every time.
Okay. Did you ever meet Scott Farris?
Yes.
How many times do you think you met Scott?
A handful, I suppose.
Okay. I believe because your first interaction with Scott is because when you lived on Purcell Lane, let me ask you this, right? Is there a lot of farms, or at least a lot of farm animals at Purcell Lane?
There is. There's a lot of horse farms.
Okay. Because I think you had goats.
I had sheep.
Sheep.
And horses.
Okay.
And
Were they like cute little baby sheep? Or
Yeah.
like pettable kind of sheep?
Yes.
Because you had lost some sheep, and I think you had contacted Scott Farris because he
Correct.
had some dogs.
Yes.
Okay. What was Scott like when you met him?
Similar to his dad in personality.
Okay.
Not super friendly, more matter of fact and different.
Okay. And you were invited to Emily's wedding, right?
Yes.
Up
there
in
was.
Tennessee. And that was the point where you actually met Rusty, right?
Yes.
Okay. I'm going to show you a photograph that's already been admitted into evidence. You may not recognize it, and if you don't know what it shows, then you just say, I don't know what it shows. Okay? Well, let me do it this way real quick. Change the view. And just for the record, showing Payne 10. Can you identify who that is?
That's Rusty Barton.
Okay. Do you know who this is?
Can you move the, I do not know who that
Okay.
is.
I'm just going to flip through and you tell me if you see yourself. Okay? All right. So 10, 9. Oh, well, I went too fast. Hold on. 10, 9.
I'm looking for myself.
Yeah.
I don't see myself.
Okay. A little louder.
I don't see myself.
Okay. Yeah. And this is that you?
Yeah, that's
Okay.
me.
Okay. So that's you. Is that the first time you had met Emily or any of them?
Yes, it is the first time.
Had you ever met Amanda before?
I had met Amanda.
Okay. How about Chris?
I had not met Chris prior to that.
All right, so you, at least at the wedding time, you had met 3 out of 4 children. Okay. And when did you move away from Purcell Lane?
I moved away in the fall of 2016.
Okay, so 2 years before what we're talking
Correct.
about. All right.
Almost. Yep.
And because I know you had gotten divorced, right? And that you got divorced when you lived off Purcell Lane.
Hickory Hill, but yes,
Okay. And did you still live in the general area?
I did.
Okay. That was always the confusing part about your name, was trying to figure out where you lived. All right, so you still lived in the area, and you and Melody could still walk, right?
We walked less because I lived, you'd have to drive to get to me.
Okay.
So we walked less. We occasionally walked
Okay.
after that.
When did you, I know you traveled back and forth a good bit to Minnesota during that period of time. When did you leave Georgia and go to Minnesota?
I was half-time for quite a while there, and maybe 3 years ago I did it permanently.
Did it permanently? Okay, so you're kind of back and forth between 16 and 2024?
Yeah,
Okay,
Yep.
up till, well, 2021, really.
correct. Until I was still coming back during COVID, so probably 2021.
Okay. And I believe that's because you have a child down here?
Yes, I do.
Yeah.
Yeah.
Ms. Frank, she had asked you about Melody getting divorced. You had talked to her about getting a divorce, right?
Yes.
And I believe you had told Ms. Frank, and maybe I misheard you, or I just didn't understand your answer. You said, did Melody tell you that she didn't want to get divorced because she didn't want to lose access to funds?
She didn't say that exactly, no.
Okay. Is that kind of your interpretation of maybe what she was meaning?
I would say quite possibly, yes.
Okay. Because when you got divorced in Georgia. Okay. So you're aware that Georgia has equitable distribution of assets.
I'm actually not, because we made our own agreement and it was
Okay.
very amicable, so no, I'm not familiar with the Georgia laws with regard to.
So you did an uncontested divorce and y'all settled your own assets.
Correct.
Okay. And you divided up your assets. Okay. And the whole debit card thing, you said Melody was in the Bahamas. Would it refresh your memory that, or that's the wrong way. She was actually in Jamaica. Now, does it really matter? Bahamas, Jamaica, whatever.
Yeah.
Were you aware that at least one of her adult children knew that she was in Jamaica?
No, I was not aware of that.
Okay. But you knew she was in Jamaica.
Only by a text, and I thought it was the Bahamas, but
Okay. I mean, that's fine.
yeah.
It's still Caribbean.
Sure.
All right. So she had texted you and said, hey, I'm in Jamaica, use my debit card?
The text came from Rusty's phone.
Okay. And it said, how did she get you her debit card? If
She
she's in
mailed it.
Jamaica.
She mailed it.
She She mailed it from Jamaica. Do you know how long she was in Jamaica?
I don't.
Okay. Was it 9 days? Sound about right?
I don't know.
Okay. All right. One second.
I have no redirect, Judge.
All right, you step down. We have a really quick witness.
We don't, Judge, and actually the next witness is.
That's fine. All right, we were gonna break early anyway. I don't know that lunch is here yet because I haven't gotten a message, but it should be arriving shortly. We're gonna break till 12:30 because that's how long my virtual meeting with the consulting group is gonna be. So, I will. Talk to, anyway, I'll see if I can find a destination for y'all to maybe go walk to instead of just hanging out here after y'all eat lunch, because we're gonna have a little bit longer, I think. So y'all step out and we'll just make sure you don't do anything that I've told you the rest of the trial.
Dave Kester on behalf of the state. William J. for the state.
Defense. Ms. Boone is still seated at council's table wearing the same gray suit and white blouse from this morning. Can you all approach? All right, court's going to step out for 1 second, and then you can email that exhibit list to Madam Clerk, and then we can go from there. Thank you. All right, we're back on the record, 2020 CF 2603, State of Florida versus Sarah Boone. State, you can get appearances.
William J. for the state.
Defense. All right, thank you. Ms. Boone is still seated at counsel's table with the same clothing from this morning. All right, I've been provided by Madam Clerk defendant's fifth amended reciprocal discovery exhibit list. I haven't had the opportunity to review it yet, but it is in my hands. Let's start with the defendant's objections to state's digital exhibits. I'll turn it over to you, Mr. Owens.
Judge, and I did want to say that the notice of provision of defendant's fifth amended exhibit list was e-filed on October 3rd. The fifth exhibit list was emailed to the state on October 3rd.
Correct. But the same problem I have is it's just the notice of provision. I don't know what any of the substance was. All right, you may proceed, sir.
Judge, I'm going to handle this.
Okay, go ahead.
And Judge, this was a little bit of a new procedure because what I did was review the images and these, as in the motion, we object to all the cell phone photo evidence. The state intends to introduce a trial as to, I'm not going to know until I hear evidence or see when they're trying to introduce it, if it's relevant or not at that time. Something might make something relevant at a certain time, or it might not make it relevant. So there. And also as to just the foundational stuff, because the images, as I've seen it, I don't have dates. So I don't know when it was taken in relation to the February 23rd, 2020 date, which is the date of the offense. And so I'm at a loss for that. So I don't know if it's 2 years before, does that make it relevant? If it's 3 years before, I don't know. So that's going to be, if the foundation is laid, that's my problem with these photograph exhibits, is I don't know until I hear who's trying to put it in, how's it identified, and if the proper foundation is made to make it relevant. Okay?
Response?
Is this going to be considered a separate hearing for the record? So should this be D or should it be A?
Everything was, when I called what was being heard today, it was all in the same hearing, so I believe it should be pre-marked as D.
What I'm having Madam Clerk mark as D for identification for purposes of this hearing is what has been provided to the defense as the very narrowed down portion of the phone extraction carve-out. What it has is what, and we were even so specific that we labeled one part of the PDF case-in-chief pages, of which there are 59. We labeled rebuttal pages, of which there are 108. Attachments that go to the case-in-chief timeline. Count up as 80 photographs and videos. Attachments and rebuttal. Count up as 147 photographs and videos. There is metadata that comes with all those files. So there is a date stamp and time stamp on each of those files. For instance, 12/25/2019, 1:10 p.m. Another one might be 10/26/2019, 2019, 6:06 p.m. They all have file names. Providing context would be the PDF outlook or PDF outline of the phone extraction, of which the state will now move into evidence so that the court consider this as States 4 for the purposes of these hearings.
Any objection to what was pre-marked as D? All right, that will received without objection as States 4.
So just to give the court an example, on page 49 of 59 of the PDF labeled Case in Chief, entry 31107 in this PDF from the phone extraction is labeled Videos, 2/23/2020, 11:12 p.m. 45 seconds, UTC -5, which means corrected to Eastern Standard Time for that time of year. And it's image_1062.mov. So that sort of information is going to be there for the majority of these files. The ones that end up getting recovered from unallocated deleted space are sometimes not going to be there. But there will be contextual clues as to their relevance. The court will be able to see that. So for instance, that image is the 2-minute infamous video of Mr. Torres being in the suitcase that started at 11:12 p.m. 45 seconds on February 23rd. So there is context that can be used both on the metadata that's in the file when you list these files by details instead of by icon, and then within the timeline. And what we have carved out is the Case in Chief timeline has a conversation that begins on Christmas of 2019, and it starts with Mo, presumably the decedent's brother, having a conversation with Sarah Boone, the owner of the phone, and it culminates in hide and seek, I shall. That's the context of that conversation on December 25th. Then it goes down to conversation that's going on January 12th into the 13th of January of 2020, culminates in a text from the owner of the phone saying, "And bless you and all of you too, I'll get capitals rid of him." So that's the context of those portions of our Case in Chief PDF. And then there's just the timeline that starts with February 23rd, 2020 at 8:35 in the morning and goes through the entire day to give context of what is going on with her on the phone. Is she using it? When is she presumably awake? That's the context of that file. The rebuttal file, which is, again, 108 pages. It starts, and it basically involves with conversations with or about the decedent, conversations with his family, which I anticipate the defendant is going to testify she was terrified of, and there was problems with all the time. It's going to give some context to those things. It mentions when they became a relationship on Facebook of March 8th of 2018 to give context as to when perhaps this relationship started or not. And then there's a timeline that starts from May 21st, 2019, that is filled with conversations about and with the decedent. At that point in time, he had his own phone, and then at some point he doesn't. And the discussions and the arguments between him and the family with the defendant. And then the images that are associated in the folders, case in chief and rebuttal, are the ones that are associated in these time frames. I have cleared out the vast majority of them. The vast majority of them were just icons and things that belong to games and nonsense. I cleared out all the photographs of Mr. and Mrs. Boone's child, any of that child's friends. There was no need for any of the pictures of the children. It's mostly photographs of the decedent and the defendant, but there's also just pictures of art and them going out because it gives context. You know, if she's in the middle of an argument, for instance, with the family, you know, one might expect there to be pictures of injuries. Instead, there's pictures of art. So we did our best to select which photographs and videos were pertinent within these time frames. We did our best to narrow it down to what time frames we believe will give a good rebuttal picture after she testifies about his family and her relationship with him. So that's where we're at. So as far as the relevancy, the general relevancy objection that was made, there was no specificity as to what particular entries in the PDFs are objectionable for any particular reason. We believe that everything is relevant. Again, we are submitting it for the court's review. I know that we're on the third day of jury selection, which will apparently resume in 81 minutes. If there's an authenticity issue, because one of their objections was relevancy, foundation, unknown origin date, hearsay, and Crawford issues. I'm submitting for the court, if I can approach the court. Gilbert versus State, 324 Southern 3rd, 598 from the 2nd District Court of Appeal, decided in 2021. Lamb versus State, 246 Southern 3rd, 400 from the 4th District Court of Appeal, decided in 2018. Gale, G-A-Y-L-E versus State, 216 Southern 3rd, 656, 4th District Court of Appeal case as well from 2017. The basics of these three cases are just the very low bar for authenticity. As Professor Earhart from Florida State University would tell us, authenticity is a very low bar for the court. It is generally considered a matter of weight for the trier of fact. And with this digital evidence, it can be established and authenticated in a variety of ways. What the state expects the evidence is going to be is that the defendant's phone was taken from her home by law enforcement, as we know from the motion to suppress, and it was provided to a digital forensic examiner who was able to use the defendant's passcode to unlock it and perform a digital extraction. So that should clear up most of the authenticity issues as to who the owner of the phone is. The state readily concedes and has provided context by using extra pages of conversations that at some point the decedent no longer had his own phone and was using Ms. Boone's phone from time to time. And in fact, that is part of her allegations about pornography and contacting other women. But I believe the context of those conversations makes it clear who is using the phone and who is not using the phone. So we believe that there is no foundation issue. We believe, based on the defense they are raising, that there is relevancy. We have split it up, the case in chief and the rebuttal. We are specifically only entering the two incriminating statements in the context of those incriminating statements about hide and seek and getting rid of him, plus the timeline of the date of the offense. Then the rebuttal, we have carved it out as best we could to present a picture of the conversations and the tone, as much as tone could be inferred from texts, and how the relationship was with the family and who may or may not have been the psychological aggressor. As far as hearsay and Crawford issues, I am unclear if they are talking about just in general the digital forensic extraction report itself. One of the cases I gave to you makes it clear that machines are not humans. They do not get subjected to Justice Scalia's version of the Confrontation Clause that he outlined in Crawford versus Washington in 2004. What he also talked about, though, and what has had some discussion since the Crawford decision, was what's hearsay versus testimonial hearsay. Obviously, there's no testimonial hearsay in these phone extractions. There's no implication that any of these statements made by any of the participants in the text conversations were doing so with an eye towards litigation or prosecution. So it's the state's position, number one, that the extraction itself and all the data that is coming from it is not hearsay, and it's not testimonial hearsay, much less. And the conversations that are going on with the other people, the statements that other people are making back to the defendant in the carve-out that we've provided aren't being offered for the truth of the matter asserted. There is no hearsay issue. It is to provide the context of the things that the defendant is saying. I'm going to go bond Jorge out. I'm going to go to the public defender's office and get this taken care of. Or screaming at his family, so on and so forth. Demanding immediate responses when somebody's cutting hair and keeps on telling her repeatedly, I can't respond to you. Can't respond to you, I'm working. So those sorts of things, it's the state's position, aren't being offered for the truth of the matter asserted. As far as the unknown origin date, I think it's pretty clear from the PDF timeline that there is a date and timestamp to every single entry from this phone extraction, and that corroborates with the images, most of the images, some were from unallocated space, but it corroborates the metadata for these images. So we're asking for that their motion or their objection to be denied preliminarily. Obviously, we have to lay the predicate properly at trial, but now the court has a copy, and hopefully we can get advice from the court if the court is believing that there are sustainable objections before we swear in the jury, so that the state can pull any photographs or videos, or we can have at least a discussion about those specifics, and then after discussing those specifics, the state can pull those out before burning a DVD to provide the jury. We also have the ability to black out entries in the PDFs. Again, no specific objections were made, so it would be our position that they're waived. There was a generalized objection, but so that we're not doing this when the jury is out. Trial is busy enough, trial is tedious enough to not be conducting discovery and doing redactions during the nights and mornings of trial.
Thank you. Response.
Judge, I think this procedure calls for a lot of speculation as to the defense part, as to what these photos, examples of the photographs, what's the use of this photograph? There's a piece of art on the wall. I don't know how that's relevant to the case. So without knowing how it's relevant and what their theory is of it being relevant, I have to form the objection. I don't think this is relevant.
What's your response to the lack of specificity? That these are just boilerplate objections to all photographs, all video?
Yes, well, they're not to all photographs and all videos. There are things that we list.
It is an objection to all cell phone photo evidence the state intends to introduce. Correct. It is objections to all cell phone video evidence the state intends to introduce.
Because at this point in time, Judge, I can't tell you what the independent objection would be. I don't know how it fits into their theory of the case. That's cause for me to speculate how it fits into their theory of the case. How can I do that? If they show you a picture, like a picture of artwork, all right, I don't know how that's relevant to this case. Or a conversation that takes place between two other people. At the time, I don't know how it's relevant to the case. So what am I supposed to say? No objection to it? And then am I later barred from objecting to it when I don't think it fits, so they hadn't laid the foundation to get it in? It's putting the cart before the horse.
That pertains to the rebuttal evidence. What about the evidence that was outlined that the state intends on using in its case in chief?
That's it, Judge. How do I know they are going to be able to lay the proper foundation for that evidence? How do I know? That's the thing well, I think the procedure goes like this. Yeah, I could be wrong, but I don't think so. The procedure goes like this. The state has a piece of evidence. They have that evidence identified to someone, all right? They get it marked as an exhibit. Okay, at a certain point in time, the state asks if we'd like to introduce exhibit number 1 into evidence. Defense, either objection or no objection at that time. I've heard the witness who've identified it. I know what it is that time, and I have some relationship to it at that time to make the proper objection. Just getting a picture now, and I'm supposed to say no objection? I don't know what they're using it for. Guess what, Judge? The videos of the suitcase, we didn't object to those. Do you know why? It was clear. I know when it was, and I know the purpose of using it. But when you have animate objects on the wall or pictures of individuals, and in this case,
But what I'm reading, it sounds like you're objecting to those. All cell phone video evidence that the state intends to introduce.
Correct.
Sounds like it covers the suitcase video to me. All.
The suitcase video is listed in in the things that we don't object to.
I don't know that. I have image underscore 0954. I don't know what that is. Image underscore 0980. I don't know what that is.
Okay.
I'm just looking at the words on the paper.
How does it need to be done, Judge?
Well, what the state is asking for is a preliminary ruling on these objections.
How do you have a preliminary ruling on an objection when the foundation or anything has not been laid in court for evidence being omitted?
The state conceded they need to lay the appropriate foundation.
Well,
Part of their argument.
okay.
So I'm not going to address foundation. If they're able to establish it is what it purports to be under the case law, under 90.901 and everything else, I mean, he's right. It's a low bar for what admissibility is.
And I have no problem with that.
Okay.
I have no problem with that part, Judge. The thing that I'm saying is I want to make sure, because I didn't object to something on here, it waives my right to object to it later.
Okay.
That's what this sounds like to me. It sounds like this is a situation, well, Mr. Henderson, you didn't object to this on the state's list of exhibits. You did not object to it. You can't object to it now. I don't think that's fundamentally correct. So I don't know what part I'm missing.
Anything else, sir?
Well, yes, Judge, I would like, because I know it's a different jurisdiction. People do things differently, okay? 30 years, I've never had to do this in a criminal case, okay?
Part of the reason the court issued the order back in August is at that point in time, Ms. Boone was representing herself pro se. And we need to establish deadlines to prevent any ambush or last-minute issues. Then you all parachuted in on August the 30th.
Yes.
There was no order. There was no request to vacate any of those deadlines. So those deadlines were still in full force and effect.
Yes, sir.
But the reason behind that was because Ms. Boone at that time was representing herself pro se, and to avoid issues at trial, the court had set a schedule for when certain objections needed to be provided. And I understand your position. I don't want to be in a position where I'm deemed to have waived anything. I get it. But the state's proffer seems to have established some level of relevancy for these things. And as we well know, the bar for relevancy is very, very low. As to foundation, I agree with you. And the state concedes that point. They need to establish the appropriate foundation. And if they're able to do that, I'm not foreclosing you for making objections. But as of this point in time, your objections are preserved for the purposes of trial. You can raise them, certainly. But at this point in time, based on the state's proffer of what they intend to use and why they intend to use it, I'm going to find that it's relevant and not repetitive.
Judge, at this point in time, as a pretrial ruling that doesn't waive my right to object to something as they're trying to admit it based on relevancy, foundation, or any of those things, then I don't have a problem with that. what my concern was, the way this looked like to me, if I didn't make an objection to it at this time for this, I am waiving it at trial.
I understand. Any clarifications or questions with regard to the court's ruling?
We're just, I believe we're trying to treat this like a video interview redaction issue. Like, it takes time to go back and pull out pictures and pull out videos or black out lines or remove pages. That's all we're trying to do is do that today. I don't know what the defense expects to be different at trial, what more information they're going to learn from the digital evidence. I mean, the foundation for this evidence is going to be the law enforcement officer that took the phone that is pictured in the CSI photos out of Miss Boone's apartment. It's right on the nightstand next to the suitcase. And then that person's going to have to testify, well, I gave it to Junella Wadden. And then Junella Wadden is going to come in and bring the phone with her and say, this is the phone that I plugged into my Magic Cellbrite software or whatever she used on that particular day. And this is how Cellbrite works. This is my educational background, blah-bitty with this software. And I pulled this extraction out. Mr. J sent me this carve out of this extraction before trial. In fact, she picked it up yesterday. And I believe, I'm going to testify that this is part of the larger carve out. This is from her phone. That's going to be the foundation. The rest of these things are things that we should be able to have an intelligent discussion about today with specificity about this line of text isn't okay. This particular photograph's not okay for this reason. That's what we were hoping for.
Okay. Have you reviewed what it is that the state intends on eliciting in this exhibit?
Yes, Judge, this is the things that I reviewed. I sat down last night and went through every one of them, preparing for this. What we did not, or what we failed to do because of the time restraint for the ones that we didn't list the number and I didn't give detail as to like IMG 0954, what it represents. My concern is this, because I don't have a problem with this or with the state's evidence at this time, as long as it's not a bar that when we come into court and I feel something is not relevant at that time, or they go to admit it and I say objection relevancy or objection foundation, then I'm not barred at that time. I don't know any rule that would bar me at that time.
Okay. I'm going to overrule your objections for the reasons that I previously identified. You can raise your objections at trial if you deem necessary. But based on the state's proffer, I'm going to find that the different categories of documents that he's identified is reflected in Exhibit 4 are relevant. They are not repetitive. They are not cumulative. And so long as they can establish the appropriate foundation, and based on counsel's proffer, seems like they might be able to do so. Any questions, sir?
Now, I just want to add something for the record.
Yes, sir.
The state during its proffer said there were no photos of the child. That's not correct. There are photos of the child.
That are being sought into evidence?
Yes, Your Honor.
State? Response, if any?
don't believe so in either of the folders. I don't have any independent recollection if I tied it up more than when I gave them what I believe the exhibit to be a week or two ago, but I don't see any. Okay, I see two images. I couldn't recognize it as a reflection of children in a, I don't know if it's a snow globe in an aquarium or whatnot, but I have no objection to removing those two. I just didn't recognize it as children. I recognize it as a crab.
I haven't seen the picture, so I'm at a loss.
Well,
I'm sorry,
it's an
Judge.
extraordinary file name, but I'm going to remove those two exhibits that they're
I'll
talking
take care of that issue for you, sir.
That takes care of that issue, Judge.
Okay.
But the point that I'm trying to make with that and why I raised it is that there are going to be certain things that I'm not going to know, and two, what is the purpose of it as far as how is it relevant now? They can make a proffer. I understand they can make a proffer, but their proffer isn't evidence. Once it goes up, the witnesses and all, and the court has told me that I don't waive my objection, so I understand the court's ruling.
Okay. All right, thank you very much.
Yes.
Anything else with regard to the defendant's objections to state's digital exhibits, Mr. Henderson?
No, Your Honor.
Okay. Moving now to the defendant's fifth amended reciprocal discovery exhibit list and the state's objections to same. There are some for which the state has no objections. Those need not be addressed. It will just be dealing with the objections outlined. It is not lost on the court that it is 12:30. We do have a jury coming in an hour. My court staff does need a lunch break. So how do you want to proceed, Mr. J?
I just want a ruling before we swear in the petite panel.
Okay. Do you have any concerns with proceeding with jury selection this afternoon and the final portion of the court's inquiry as addressed yesterday, and turning it over to you without having a ruling on these, and we could address these objections tomorrow morning before we bring in the balance of our panel? All right, is that acceptable to the defense? Yes. Okay, all right, so then here's what we're going to do. We're going to be in recess till 1:30. We will report to the 23rd floor. I've already advised jury services and court admin that a room is available for us. We will continue jury selection at that time. I will keep you apprised of whether or not we can continue jury selection in 23 tomorrow. As soon as I have that information, I or my judicial assistant will pass it along to you. Assuming we're in 23, we will advise the jurors when they need to return, and we can address all these objections tomorrow. And we'll address those objections either in 23 or in 12 alpha. Anything further from the state?
No, Your Honor.
Anything further from the defense? Okay, we will see you all at 1:30 and 23. Thank you.
So no, he does not. That and a couple witnesses, so that no, he does not.
And it's the third witness today, so we got time.
But we might have him test it during the next witness to see. Of course, we probably don't. I'll figure it out. All right, go ahead.
State calls Dr. Elaine Pope. Dr. Pope, if you could please stand and raise your right hand. Do you swear or affirm the testimony you're about to give in the matter now pending before the court will be the truth, full truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, could you please have a seat and introduce yourself to the jury?
Okay. Hello, my name is Elaine Pope. Do I need to elaborate?
I will continue to ask
Okay,
questions. How
thank
are
you.
you employed?
Right now, I do private contracts. So I do forensic casework, and then I also lecture. I lecture to fire investigators, law enforcement, crime scene investigators. So that's kind of what I do now.
What do you lecture them on?
Fatal fire investigation.
What is your education, background, and then kind of move forward from there through your professional background?
Sure. So I got my my bachelor's degree at the University of Tennessee in anthropology as well as in art. And then I got my master's degree at the University of Arkansas in Fayetteville. And then I went on to get my PhD at the University of Arkansas in Fayetteville. And my dissertation was titled The Effects of Fire on Human Remains, Characteristics of Taphonomy and Trauma.
So is it fair to say you had a specialty within forensic anthropology?
Yes.
What would that be? What focus would that be on?
Mostly burn bone, but also how the human body burns during different types of fire events.
And have you performed experiments on cadavers with fire?
Yes. So my research that I've been doing since 2000, I guess 4, for several years. Basically, I test on human cadavers. So we put them in structures, in vehicles, in outdoor scene conditions, and this is for law enforcement training. So we're able to show them how the body burns in those different environments, as well as outdoors, confined space, and others. And so we document time, temperature, photography, sometimes video, so we can see all the stages from start all the way to finish when the fire is put out, which could be minutes, it could be, an hour, 2 hours. It just kind of depends. So we kind of test all the different ranges and figure out how the human body burns in those different types of fire environments.
What would be the number of bodies that you've burned throughout the years?
I'm up to about 270. It's part of a training course that we do each summer out in California, and we do, it's a law enforcement training course for about 65 investigators from all over the country. We get people international as well, and we average about 15 to 17 bodies a year that we do fire investigation training on.
When you do these experiments, are you paying attention to not only the body itself, but the environmental factors?
Absolutely. The two have a relationship in terms of, say, for example, like a vehicle. It's going to hold heat inside that tiny container as opposed to an outdoor fire. It's going to be more, you're going to have, more airflow. So it's going to be a little bit different per each type of scenario, or each type of fire environment leaves different types of fire damage on the human body.
Do you, during these experiments, do some with and some without accelerants?
Yes, so we test both with and without accelerants. This includes directly on the clothing of the body, as well as, say, for example, in a bedroom. So we also use ignitable liquids there. But we've done several studies on the body, specifically just with ignitable liquids, and then adding other variables like wood, clothing, no clothing, and those will all kind of change the outcome and how the body, tissues of the body burn.
Have you testified as an expert in trials before?
Yes, I have.
About how many times?
Let's see. So I'm up to 17 different trials, both for the prosecution and the defense.
And were you asked by the DA's office back in 2019 to consult on this case with Gary Wayne Farris?
Yes, I was asked to evaluate the case, yes.
And you accepted that role?
Yes.
And so before we get started, I just want to ask you, are you being compensated for this the work
yes.
and the testimony?
Yes.
Okay. By the DA's office?
Oh, yes.
At this time, the state would move to admit Dr. Pope as an expert in forensic anthropology.
As to that, limited qualification, I have no objection.
She's admitted.
Thank you. Okay, when you were asked to do an analysis in this case, were you provided resources to refer to for your analysis?
Yes, absolutely.
What were you provided?
I was provided with images from Purcell Lane. These are the files or the documents that I received. So images from Purcell Lane and Crime Lab, GBI DOFS, the coroner report, the fire EMS report, the GBI DOFS anthropology report, the GBI DOFS arson analysis, and the GBI DOFS autopsy report.
And did you, after reviewing all of those documentations, come up with your analysis and opinion as to certain factors of the fire that caused Gary Wayne Farris to become remains at that point?
Yes, yes. I looked at the photographs as well as all the law enforcement documents, autopsy report, other reports for that.
Before we get into the details of this case, can you explain to the jury how generally, if you could, how a body will burn, the process of that once it is, I guess, for lack of a better term, set on fire?
Yes. So the body is layered in tissues. It's got skin. It's got, underneath that is going to be subcutaneous fat. Underneath that is going to be muscle. And then you have organs. And then my specialty is the bones inside. And so each different tissue burns differently. The skin is really thin. So when it's exposed to heat, it'll start to shrink and pull apart into little skin splits. And this exposes the next layer of tissue, which is going to be subcutaneous fat. Now, subcutaneous fat burns as a fuel source. It is a lipid material, and it turns into basically grease. And it'll fuel the fire, especially if it's absorbed into wood, clothing, anything that will retain that. And so that is a major contributing factor in this case, as well as my experiments in terms of after setting the fire, the body can actually burn on its own rendered fat, liquefied fat, for several hours, just as the main fuel source, even after ignitable liquids have been expended.
I want to walk through your report here. Did you have a recorded temperature at the time of the discovery of the body?
It was mentioned at about 100 to 130 degrees Fahrenheit.
Was that helpful for you to start your analysis of possibly the time that that Mr. Farris had been on the burn pile?
Yes, so the fact that there was still heat and temperature there just lets me know that it was a more recent event in that the fire was able to go out on its own, but it was still warm. If it had been cold, that could extend the time period. But in this case, the coals were recorded at a low temperature, so that kind of lets me know that it's a more recent event, under 24 hours as opposed to later on.
And had those temperatures been lower or like cold or ambient, that would have done what with the time frame?
It would just expand it potentially. Basically just the warm coals just kind of put it at a lower or a shorter time frame.
And does the fuel sources surrounding the body or under the body or over the body also depend on how long that may have been burning?
Yes, absolutely. So the more fuels in the fire, the longer it's going to burn. If there was just a few little, pieces of wood, it wouldn't burn quite as long. But in this case, there were pieces of wood at the crime scene. And so that kind of gives me an idea of the potential fuels that were there, not the exact amount. But with the wood being there, that's going to absorb the fat, and that's going to keep the fire going and fuel the fire for a long period of time, over several hours.
And in this case, when you mention fuel, wood is a fuel.
Yes, sorry.
You categorize wood as fuel. Or
Yes, wood is
twigs,
fuel.
leaves, brush, whatever's under the fire or
Yes.
over the fire. Okay. When you, I'm just trying to clarify, when you say fuel, you don't mean any sort of ignitable liquids or anything like that?
No,
Okay.
I misspoke there. Fuel is
No.
anything that burns.
Okay,
It could
perfect.
be wood, clothing, ignitable liquids, just any type of fuel that would burn.
Okay. And then I want to move on down to, you knew the date of the discovery of the body, correct?
Yes.
And those are the photos that you have are from that date.
Correct.
Okay. Tell the jury about, you made the determination that this was a single burn event. What does that mean?
Well, this is, so we do, in the experiments, we'll do basically set a fire and let it burn the entire course without adding wood. So with that, basically, the bones are more intact. You can tell where the head is, where the foot is, as opposed to if they were refueling, stoking, stirring, crushing, we would find little tiny pieces, and it would be, basically very different.
So, in other words, the body would not be in anatomical order.
Yes, it would be kind of stirred up, but in this case, there was intact long bones, the skull, and so that doesn't indicate to me that there was additional activity after the initial fire.
You also determined the position of the body. Can you tell the jury about how you determined that?
Yes, so this is looking at the photographs. I was not actually at the crime scene. But based on the photographs, we see his leg. There's a long leg bone, the upper thigh bone called the femur. On the back of it, there's a ridge where all your big muscles attach. And so in the photograph, we see that ridge on top, which basically means that he was face down. As well as the face was really well protected, as opposed to the back of the skull was more extensively burned. So that tells me kind of the relative position that the body was in with those two, the femur as well as the condition of the skull.
When you say that the face was preserved and it was face down, does that have to do with access to oxygen and airflow? How do you know that the preservation of the face means that he was face down?
It could be to where he kind of settled into fire debris where it was protecting the face. It's not suggestive that anything's wrapped around the face or anything like that. It just basically lets me know that that was the surface that was down. And again, fire debris can protect around the face as the wood burns down.
And as an individual who's burning, their subcutaneous fat you mentioned kind of acts as a fuel source.
Correct.
So if there was wood surrounding the body and the fat was wicking into the wood, how would that affect the fire?
That's going to sustain the burning process. Say, for example, if the body was burned on a cement pad or a parking lot, it would burn very differently than, in this case, we have wood, we have vegetation, potentially other materials, and so that absorbs the rendered fat, which is basically the liquefied fat. And it's called the wick effect. So it's kind of like an oil lamp, where the fire will continue to burn as long as it's fueled by the oil.
So considering the photos that you received in this case, it wasn't surprising to you to hear that there was no evidence of ignitable liquids on this fire.
Yes, ignitable liquids will get the fire going. but you don't have to have ignitable liquids to start a fire necessarily. If you build a campfire, you may be using kindling. Just different things can get the fire going. It doesn't necessarily have to be ignitable liquids.
Thank you, Dr. Pope. That's all I have for you.
Yep.
1 second, Judge.
All right.
Trying to be more efficient. Good morning, Dr. Pope. It is afternoon now. How are you?
I'm doing great, thank you, sir.
My name's Michael Ray. I represent Ms. Farris. A couple of things I just want to go over with you, okay? One, the jury doesn't have your report, but you had kind of talked about it with your appendix 1 and 2. I gave examples.
Yes.
Now, in both of those examples that you gave regarding time and things such as that, there was some type of diesel fuel or a mixture of gasoline and diesel used in those instances?
Yes, in the appendices that I provided, yes, ignitable liquids are used. One was primarily ignitable liquids and clothing as the primary fuel source. Then there was a second example of a body burn just on pieces of logs and wood and whatnot. But yes, ignitable liquids, I used it in both of those.
And from what you reviewed in this case, there's no evidence of any ignitable liquids being used?
Not based on the burn patterns.
Okay.
No.
Start with your compensation from the DA's office. What were you initially paid to render your report?
It was $200 an hour. I don't have the actual invoice with me.
Approximately how many hours did you work?
It could have been between 10 and 20. That's usually what reviewing photographs, reports, and then writing my report takes.
I mean, I believe you stated that you reviewed coroner's report, GBI, autopsy?
Yes.
So that's a lot of reports.
Yes.
You reviewed. All right, so $200 an hour?
Yes.
Okay. And what's your cost of testifying here today?
Well, on the stand, it's $200 an hour as well.
$200 an hour. I'm assuming you're like most experts. You do that from travel and everything.
No, just appearing, sitting here.
Okay. Well, I tell you what, you have negotiated yourself a better deal than the other forensic anthropology. You got $380.
All right.
So that out of the way, you're not a forensic pathologist.
No.
Okay. You are not certified in certifying cause or manner of death.
No.
Okay. And what state do you typically operate out of?
Knoxville, Tennessee.
Okay. So you're a Tennessee fan.
Yes.
Okay. We'll forgive you. And you went to school in Arkansas?
Yes, sir.
Okay.
Master's and PhD.
Okay. All right. Now, from your examination of what you've done, and I'm going to go ahead and get something ready to pull up to show you. From your examination, you can't tell us anything about Gary Farris's cause of death.
No, that's not what I was asked to do, nor am I qualified. I'm not a medical examiner.
Correct. Just making sure. There it is. And I'll show you that in just a few minutes. So you weren't asked, nor can you tell us anything about how Gary died?
No.
Okay. Now the effects on the remains, they would be the same regardless of who set the fire, right?
Fire started.
Yeah. How it was set would matter regarding the effects on the remains.
Just to get it going, ignitable liquids gets it going quicker, but once it goes, ignitable liquids have no effect after the first few minutes.
But yet again, we have no evidence of ignitable liquids.
Okay.
Now, all of those reports that you were talking about you reviewed, did any of them contain any witness statements?
One was talking about the readings of the CPAP machine. I mean, most of them I was just looking at the evidence.
So essentially the photographs?
Photographs and reports.
And the reports from the state examiner?
Autopsy, yes.
Things such as that, okay. So none of the actual witnesses or anything like that? You didn't listen to any of their interviews?
Their interviews
Yeah.
or
Well, let me ask it two ways. Did you listen to anybody's interview? Let's say Melody Farris's interview.
no.
Okay. I'm just making sure. But sometimes it references in those reports you were reading, here's what so-and-so said.
Yes, correct. I really don't pay much attention to the witness statements.
Because that's not what you're there to do.
Well, I'm there to look at the evidence, so I take witness statements with a grain of salt.
And you received all of those reports, I'm assuming, from the DA's office.
Yes.
Okay. Now, you had started talking about with Ms. Frankish regarding the human body burning about subcutaneous fat, correct?
Yes.
Alrighty. Subcutaneous fat can essentially become its own fuel source.
Correct.
Alrighty. So you can presume that a body of someone who has a lot of subcutaneous fat will in fact burn hotter.
No.
Not necessarily hotter. Will they burn up quicker?
No, not necessarily. I mean, it's more fuel, but it's not going to speed up the process.
Well, if it's more fuel, do I have more heat?
That's more of a fire investigator question because I'm not qualified to tell, exact heat ranges.
Okay. Well, you put in your report a heat range, and I think it goes up to somewhere around 1,500 degrees.
Yes, and that was just based on average temperatures of larger fires.
Okay, so nothing to actually do with this case. Just
No.
similar fires. that you
Well,
saw.
yes, the similar fires, similar reconstruction or experiments that I've done have been kind of in that temperature range.
Okay, because you already testified here, and we've heard it previously, that the fire when law enforcement arrived at the hottest portion that they recorded was 230 degrees. Correct? You said that.
Correct.
Okay. All right. Now, I was just curious about this over lunch. Is there like a scientific determination of a temperature range for it still to be? Because we kind of use the term loosely. There is a fire, right? All right. Is there a scientific determination of how hot it has to be a fire, or is it just actually there's physical, visible flames?
The output of heat.
The output of heat is a fire. So it's fair to say that at 230 degrees we still got a fire because it's still outputting heat.
I mean, it could be a smoldering fire. I base it on the fact that there's flames or not flames.
Okay, kind of like anybody else would, probably.
Yes.
So if it's 230 degrees in the photographs you saw, would you consider that to be more of a smoldering fire?
Possibly, only because it was reported that it was still warm.
Still warm. And you state in your report that you don't have an exact timeline, but you state somewhere less than 24 hours.
Yes.
Okay. So if law enforcement is recording the fire around, let's say 1 p.m., right? Less than 24 hours would be the next day at 1 p.m., or that would be exactly 24 hours.
Okay.
Okay. Is that right? In 24 hours? Like 24 hours from now, 24 hours from now will be 1:09 tomorrow.
Oh, okay, yes.
Yeah. So if I go back in time, trying to calculate something else, 1:09 yesterday would be 24 hours.
Yes.
Right? All right. So the fire was started or was recorded on July the 5th around 1 p.m. That would mean less than 24 hours would be July the 4th at 1 p.m. Correct?
Yes.
Okay. Now, you also state that you didn't find from the photographs any evidence of stirring or stroking or anything like that.
Not based on how the remains were found.
Okay. Now, that's what I want to show. Did you review Dr. Gooding's documentation? She did the anthropological report.
Yes.
Okay. She also attached with that a photograph, or I'm sorry, a chart. And it's been admitted into evidence as Gooding 1. Can you see that on your screen?
Yes.
Did you review that chart?
No.
Well, you were provided her report, correct?
Yes.
Okay. Now, what it says, and I was talking to her about this yesterday, and she didn't know. But you can see up here where it says cranium, right?
Correct.
Okay. And then you've got the pelvis, and that's kind of the center of the body, right?
Yes.
Okay. And then you've got the femurs, I learned, those are the leg bones.
Correct.
Okay. Now, you also agree with me that ribs are above the pelvis.
Yes.
Okay. And we've got a rib found way down here, below the legs and everything else. Okay? Wouldn't that be evidence of some type of tending to or something?
It could be disturbance from animals nearby. that one rib is not gonna tell me that the body was stirred up.
Okay. What if I told you that there was also another rib with a bullet in it found somewhere up in this area where the hand is?
Okay.
Okay, so you got two ribs, or two pieces of ribs or parts of ribs in two different locations. So you're saying that that could be evidence of animals?
It could be.
Okay. Couldn't it also be evidence of stirring?
Not with all the other bones found. I mean, you have the leg bones where they're supposed to be, you have the skull where it's supposed to be, and also it was kind of a shallow berm, so that you have to account for stuff potentially, rolling down as opposed to a flat surface.
Okay. Now, the body laying, you stated that, in your opinion, that the body was laying face down.
Yes, based on the photograph showing the back of the leg lying face up, and the face being very well protected and less burned than the backside.
Okay. Now, for the fact that the body is face down, you can't tell this jury whether or not Gary Farris fell into the fire or was placed into the fire.
Yeah.
Okay. You also have no opinion as to cause of death.
I'm not qualified to make cause of death, nor was this asked of me.
I understand. I blame you. You're fine. Give me just 1 second, okay? One thing too, you may have read it in some of the reports that you reviewed and did not. There was an eyewitness, in this case, that previously had testified that he observed flames from the burn pile on July the 3rd, later in the day.
July 3rd. Get my notes real quick.
Would knowing that information change your opinion about your report?
I mean, there's possible they could have started, had another fire earlier. I'm not sure.
Okay, but it's still your opinion that this fire was less than 24 hours old?
Yes, simply because it was still warm. If it had been cold, then we could extend the time frame.
Okay, all right. No further questions?
All right, redirect.
I have no redirect.
All right, thank you, ma'am. You can be excused.
Thank you very much.
All right, call your next witness.
Bobby Simmons. Have the juror come down and lead us in the exercises. Agent Simmons, raise your right hand. Do you solemnly swear affirm the evidence you're about to present in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Go ahead and have a seat. Make yourself comfortable. If you would, state your full name for the record.
Robert Simmons, go by Bobby.
And who do you work for?
The Tennessee Bureau of Investigation.
We just call that TBI?
Yes, sir.
If you would, just tell the jury, what is the TBI and how's it in comparison to our GBI here in Georgia?
It's basically the same thing as GBI. We investigate special circumstance cases that were requested by district attorneys throughout Tennessee. My unit is in Middle Tennessee. We handle everything from homicides to thefts to officer-involved shootings, just a wide variety of stuff.
Where did you start in law enforcement?
Metro Nashville Police Department.
What did you do there?
I was a patrol officer for 2 years. Then I went to a proactive unit, and then I was a detective the last 2 years I was there.
What type of proactive unit was it? Crime suppression or something? Or?
Basically, we called it a flex unit. We were unmarked cars, but just doing proactive stuff in high crime areas.
All right. And after you were there, what'd you do?
So when I left Metro, I started at TBI.
You were a detective before you left?
Yes, sir, I was.
What kind of cases did you investigate?
Mostly property crimes. We did do some homicides, but kind of a wide variety. We were kind of regional. We had a precinct. We covered a certain area of Nashville. We kind of covered all the crimes in that area.
Now, were you, we call it post-certified, which y'all call in Tennessee?
Yes, post-certified.
Were you post-certified with the state level, or is it just a state accreditation for everybody?
Correct.
And when you go to the GBI, do you have to go back to a new academy?
Through TBI, yes, sir. We go through
TBI, I'm
yes,
sorry.
sir. We are. They host their own special agent academy.
How long was that?
I believe it was 18 weeks.
After you got out of the academy for the TBI, what'd you do?
In the position I'm in now, so CID in Middle Tennessee. I've been in that position the whole time.
Now, in Georgia, the GBI investigates, they're assigned to regions, and they may have so many counties in their region. Is yours similar to that?
Yes, sir. We're assigned to the 4 grand districts of the state. So I'm in Middle Tennessee. Within that, I'm assigned to the 16th Judicial District, which is Rutherford and Cannon County. I cover those 2 counties primarily.
What are those counties like? Are they big, small?
They're actually both the opposite. Rutherford County is Murfreesboro, where Middle Tennessee State University is. It's a very large city, large departments, police departments. Cannon County is the complete opposite. Population is about 15,000, and they have 2 detectives for the whole county.
And how long have you been doing this type of work?
I've been there. I've been at TBI since 2016.
Do you have any specializations, or y'all just catch whatever cases come?
We catch them all, yes, sir.
Do you do crime scene and things like that, or are you mainly on the investigative side?
We do. We process our own scenes mostly.
You do too?
Yes, sir.
And oftentimes, do you work with sister agencies from other states?
Yes, sir, we do.
Now, in this case, did you get called upon, or someone get a hold of you from the Cherokee County Sheriff's Office ask you to help out?
Yes, sir, that's correct.
Just kind of tell the jury how that works. What happened there?
So we got a call from Cherokee County just saying that they had an individual in Middle Tennessee that they had identified and were trying to locate and interview, and they were asking us to go, given that it's a few hours away from where they were at, if we could go and try to locate that person and interview him.
And I think you went, and let's begin with the timeline here. July 6th of 2018, I think you went and talked to first, is it Martha Jane Barton?
Yes, sir.
And I believe she was related to, by marriage, stepmother to Rusty Barton, is that right?
That's correct, I believe.
So you went and talked to Martha Jane on July 6th that evening. Was it a long conversation or kind of just an introductory conversation?
I think it's pretty short. We didn't gain a whole lot of information.
What's Martha Jane like?
She was a little standoffish, but it wasn't. I don't think it was necessarily a terrible interaction.
Was she older?
Yes, she is.
And where was this at? What city was it?
I believe it was in Coffee County. I believe Tullahoma.
Tullahoma. I think Rusty's Tullahoma too.
Yes.
What is that like?
It's a little bit smaller than say the Murfreesboro where I'm from. It's not I wouldn't call it a podunk county, but it's fairly
rural, farms, things
rural.
like that.
Yes.
What kind of cotton fields, tobacco fields? What's the produce there?
Mostly down there is corn and soybeans, Middle Tennessee.
But rural area.
Yes, sir.
And but was Martha Jane, was she pleasant, nice?
Yeah, no issues with the interview.
A little reluctant to talk with you?
Yes, sir.
And did she really give you anything that was a significant that you went, hey, here's some great information and just solve the case for us?
No, sir.
After you talked to Martha Jane, did you go and talk to Rusty Barton?
Yes, sir, we did.
And I think that conversation was about, give or take, 45 minutes, probably around 8 or 9 o'clock at night.
I believe that's right, yes, sir.
And when you talked to Rusty, where did you go to talk to him?
I went to his house.
And did you have anybody with you?
Yes, Agent Elizabeth Williams, another TBI agent.
Now, this Tullahoma where Rusty was at, was this your area that you were assigned to, or was this outside your area?
That's Agent Williams' assigned area.
And how many TBI agents do y'all have per area, I guess?
Generally one.
How many cases do you have to work a year?
We generally may get 10 to 15 cases a year, and we maintain our cases through adjudication, so we're constantly carrying 10 to 15 cases at all times.
Is the TBI like the GBI that you basically have to get called in for assistance from a local agency?
Correct. Well, the way TBI, the statute reads for Tennessee, is the district attorney's office has to request the TBI investigate the matter.
It's the head prosecutor requests it.
Correct, yes.
Now, in this, since you're helping out, how much did you really know about what had happened in Cherokee County?
Very little.
Did you have great detail, or just basically the information that Gary was found on a burn pile?
Yes, and we were provided their information basically to go find them and just see what they know kind of deal.
So just kind of preliminary just to start the investigation?
Yes, sir.
And did y'all have a lot of time to prepare, or did y'all just hit the road and try to get out there and talk to people?
We went pretty quick and tried to find him.
Now, when you tell the jury, if you would, how would you describe Rusty Barton?
He was a little arrogant at first. I remember when we first got there and we explained who we were and what we were doing. He made the comment, "Well, do you know who I am?" or something along those lines. And yes, sir, we do. We know your birthday. We know who you are. We're here knowing we're talking to you. He was a little reluctant again to provide information. We kind of just had to tell him a little bit about what we did know, but to kind of peel the layers back and get to the bottom of it.
Kind of pulling strings to get some information?
Yes, sir.
Now, in the beginning, I guess there was an issue about who Roy Barton was, and junior and senior.
Yes, there was conversation about that.
So Martha Jane's husband, Roy, who had passed away, that was Rusty's father, is that right?
Yes, sir.
Now, when we start talking to Rusty, does he give, is it a voluntary talk?
Yes, sir. He invited us into his home. Yes, sir.
So he didn't put handcuffs on or anything like that?
Oh, absolutely not. No, sir.
Have you played good cop or bad cop when you've done interviews, interrogation?
We do, and depending on, I've done several interviews with Agent Williams and with other ones, and we kind of just feel it out and see who they better connecting with, and sometimes they gravitate towards one agent or the other, so we just kind of play off of that to get that information and talk to them.
To be a detective and also to work for the TBI, do you go through interviews and interrogation training?
Yes, sir.
Is it called interviews and interrogation, or what do y'all call y'all's?
They've done several. We do independent classes. They've done different techniques over the years.
Read method and bait method, things like that?
Yes, sir.
So are you kind of taught how to interview people, even reluctant witnesses?
Yes, sir. Oh, yes, sir.
Now, have you ever been in some throwdown interviews with people cussing, screaming, almost going to fisticuffs?
Absolutely.
How many of those do you think you've been in?
Only a handful. Most of the time, I feel pretty confident with talking civilly with people.
You ever have to get in a fist fight or anything, restrain anybody during the interview?
No, not during an interview, no.
What is your style? If you tell the jury, if we could hear a recording of you, what's your style like?
I try to be polite, yes, sir, no, sir. I try to respect what they're saying, but also make them understand that we know that there's maybe more that they're not telling us. Let them know that, let them talk, let them kind of say what they want to say, but then be able to talk them through, hey, it's okay, we're here for a purpose, we're not here to, again, we're not, at that time, we're not here to arrest you. I've had those interviews where we know we're arresting them. That was not this at all. This was just an informative interview, get as much information as we could. So.
Now, at this stage, do you even know if Rusty Barton is someone that's a suspect or is knows something or knows nothing?
I think we knew that there was going to be some kind of connection, but we didn't know the full extent of what that was at that point.
Have you even seen the defendant, Melody Farris, in this case?
No, sir.
So you never came this way to Georgia?
No, sir.
You just helped up there, is that right?
That's correct.
All right, so when you first start talking to Rusty, let him know it's just a voluntary interview. Did he could end the interview? Was that made clear to him?
Yes, sir. He knew. Again, he invited us to come sit in his home and talk with him. At no point did he ask us to get up and leave, and we refused to leave. I mean, that wasn't the conversation. So,
what level of sophistication would you say Rusty Barton has?
He's a smart man. He's a businessman. He's not.
He's in sales.
Yes.
Nice guy.
Yes, sir.
Pretty big guy.
He was. Yes.
But not super aggressive or anything like that.
No.
Now, did he like your partner?
There was periods where he didn't like maybe some of the things she was saying, and he, again, just gravitated more towards having a conversation with me, and that's just part of that's why we take multiple people to an interview.
Sure. I mean, it's something you do, right? Good cop, bad cop?
Yeah. Yes, sir.
On a scale of 1 to 10, 10 being where you're in someone's face, screaming, cussing, pointing at them, and, everybody's standing up, almost going to blows, and 1 being, hey, we're just kind of having a conversation, kind of like what we're doing. Where would you put this interview with him?
Oh, very low. Maybe a 2. I mean, we were definitely saying, we know that there are things you're not, we know that there's more to this than you're saying. And again, we're kind of just pulling the layers back of that onion and just, we know there's more to it, just getting him to, but it was at no point confrontational as yelling, screaming, anything like that.
Did you ask him if he knew Melody Farris?
Yes, sir.
Did you go through when there's a murder, do you try to get, when you investigate a murder or helping out in a murder, do you try to get a timeline?
Yes, sir, we do. Talk about when they last spoke to somebody, when they saw somebody, when things like that, how they communicate with the person, all those kind of things.
And he's going to be here. I'm going to ask him these questions. But did you try to get a timeline with him for July 3rd, 4th, and 5th? Gary Farris' body was found on the 5th. So did y'all try to go back through things to see where he was at?
I believe we did. I don't know that we knew all the details of the exact times, other than, I mean, it was the next day, so we knew we were talking about the few days leading up to that.
And did you talk to him about, do you remember talking to him about whether or not he gave the defendant a credit card?
Yes, we did talk about that. At some point, I believe it was during that first interview, yes, sir.
Do you remember, was Rusty from Tullahoma? Is he from that area?
I believe so. He talked about family connections to the area and that kind of thing.
Did he talk about his grandfather?
Yes, his grandfather used to be the sheriff or the police chief or something along those lines.
So there was a background to the
Yes, sir.
connection to law enforcement?
Yes, sir.
Now, when you investigate things, crimes and things like that, are you interested in cell phones?
Absolutely.
Are those ubiquitous today? Are they within arm's reach of most people?
Yes, sir.
Now, did you do any drug investigations?
No, I did not.
Do you ever see, well, how many phones do you have? So,
I have two, personal phone and work phone.
did you ask Rusty about phones, or how many phones the defendant had?
Yes, we had conversations about that he had a work phone, and then again, at some point we talked about that he had to end up getting a personal phone because his work didn't want him to use the work phone for personal business. So he told us he had two phones, I believe.
Do you remember asking him about the defendant's phone?
Yeah, we talked about if he had purchased a cell phone for her, a burner phone, a prepaid phone, those kind of things.
In your first interview, did he just give you the one phone or one phone number? Do you
I believe that's correct, yes, sir.
And then later on, did you get, maybe through his attorney, did you end up getting another phone number or knowledge of another phone?
Yes, sir.
Was that Bobby Carter?
Yes, sir.
So that would, so on July 6th, it was just one phone, and then
I believe that's correct, yes, sir.
later on you learn about another one?
Yes, sir.
The first time you talked to him, did he seem to have a lot of details about what had happened to Gary?
No, he did not.
Did he seem to indicate whether or not he was talking to the defendant a lot?
No, I think he kind of indicated that he had not spoken to her for a while, that I want to say maybe even hadn't seen her for quite some time, but kind of distance that there was not been recent communication.
First interview, did you get attacked by the cat, I think, maybe?
That sounds right, I think so.
His cat got on you or something?
Yeah.
Do you remember leaving that night, and what was it like to leave? Was there any issues or anything like that?
No, it was.
At some point, did he or his attorney reach out and want to talk again?
Yes, so a couple days later, I believe that first interview was on this July 6th, and then on July 10th, which would have been the beginning of the next week.
Okay, if you can look right there on Raleigh 1, there's a calendar for July 2018.
Yes, so Friday the 6th is when we talked to him initially, and then I believe it would have been Tuesday, July.
I got the 10th, is that
the
right?
10th, yes, sir.
And when you went back on the 10th, tell the jury who was all with you on this time.
So at that point, there was Mr. Barton was there, his attorney Bobby Carter was there, myself, Agent Williams were there, and then there was two investigators from Cherokee County there.
The lead detective in the case is Detective Hayes, Daniel Hayes. He's sitting right here. I don't know if you remember him.
Yes, sir.
And probably may have been dressed differently, more casual. I don't remember how you first went out.
Yes,
and then you had Ashley Pope, I believe.
Yes, sir.
Do you remember? So Hayes and Pope.
Okay, yes, sir.
For the record, which one was good cop and which one was bad cop?
I don't recall which one. I remember them both being there. One was doing more of the talking. One was dealing more with the cell phones and Cellbrite. I don't recall which was.
How aggressive was that second interview?
Well, I mean, it started with his attorney basically letting us know, hey, we've he told us, in the initial part of the interview.
That's okay, Judge. I'm gonna have him here. He can do it.
Well, I think the issue is whether it's the lawyer talking or the defendant talking, or the witness talking.
Just the lawyer.
Yeah,
Well,
so that's not going on.
I'll rephrase it.
All right.
In the second interview, someone reached out to y'all. Is that right?
I believe that's correct, yes, sir.
And when you got to the second interview, don't tell me what was said, but when you were there, did you get more information during the second interview that you couldn't get during the first interview?
Absolutely, yes, sir.
And was that because things had to be explained and clarified?
Yes, sir.
And that was on coming from their side and not y'all's?
Correct, yes.
So it had to set some things straight or change some things?
Yes, sir.
Right. Let's see. During that second interview, y'all talked about phones again, I believe, and deleting some things off the phone.
Yes, sir, we did.
And when we came to Rusty's phone, do you remember you were kind of quiet during the interview? You kind of, I could hear you talk, but you're not super aggressive, are you?
No,
I'm sure you can be when you have to, but
right.
If you're reading the room, is that your style is kind of how it is?
Yeah, that interview was going very smoothly, so there was no need to agitate the situation by being aggressive with it.
And if you saw, an interview is an interview, right? That's a different tone than
Absolutely.
an interrogation. Is that fair?
Yes, sir.
So if I said to you, what is an interview with a suspect? How's that different from what's an interrogation with a suspect or just a witness?
Well, in an interview, we're just having a casual conversation about just kind of what kind of the dialogue back and forth. Interrogation's more of, for me, is me being more forthcoming, that we know more information, we know you're withholding, we know there's certain evidence, whatever it may be, but it's more of us kind of trying to get that person to just either acknowledge or have that conversation with about whatever evidence that we may have. And it can go back and forth. It can be somewhat of confrontational, and then they may decide to speak, and we go back down to, just a casual conversation. And in this setting, it was absolutely that. It was all 6 of us talking, having conversations, and there was no jumping and screaming again. And
nobody ended the interview said, we're done, we're not talking anymore, or anything like that?
No, sir.
Now, if I said, is it either the interview or the interrogation where sometimes law enforcement takes the approach of, you're done talking, now I'm going to talk? Which one is more likely to be that?
Right. That's when you kind of get into that interrogation phase. If you're kind of doing most of the talking and trying to get them to get on the same page as you as far as agreeing that there is more information or whatever. But that's more of, for me, is that I talk more during that interrogation part.
Have you ever heard the saying, you catch more flies with honey you do vinegar?
Yes, sir.
Sometimes you got to use vinegar.
Yes, sir.
Do you ever do an interview where you with a suspect or a witness and they're sitting in a chair and you get close to them, you put your arm around them and tell you everything, kind of comfort them?
Yes, sir.
Do you ever get when you do an interrogation where you have to get up in someone's face a little bit and see if they'll break or give you some more information?
Very little. I take the approach of just being more honest with them, that there's more that we know, and just be kind of frank but not loud and argumentative or anything like that.
If a witness is reluctant or reticent or not completely forthcoming, do you try different things just to see what will happen?
Oh, yes, sir.
Did you feel like that's what was going on with Rusty?
Somewhat. It was more that we, as the investigators, knew more information, and we'd have to kind of feed him. And I'll go back to, let me give an example of that first interview, is when we approached him and we said, hey, this is who we are talking to him. And he asked, do you know who I am? And I'm like, yes, sir. I had to say, I know your birthday. And, oh, okay, yes. So he had to kind of understand that they do know something more, so I need to talk. If I'd have gone in there and he had no idea who if we said, oh, we don't know who you are, we just showed up, and he would have been more reluctant. But as we fed him a little bit of information to say, we know, X, Y, and Z, he would kind of, okay, I'll tell you more. It's just, I think it was more of him just being standoffish, of not wanting to let go of that information.
Was it a process to get more information as the interviews went on?
Absolutely.
Now, you asked a question, we're talking about him deleting things off his phone. Do you remember asking him the question about why would you delete things off your phone? Not hers, but yours.
Yes.
And why did you ask that question?
Well, I know that in my experience, people delete things they don't want to be seen. And cell phones, that's a very common thing. Delete text messages, photos, whatever it may be that they delete off their phone. So we wanted to clarify, to see had he deleted items off his phone.
Now, Rusty has some sayings, some unique sayings. Like he said, like heck fire, stuff like that.
Yes.
When y'all first approached him and asked him whether or not he was having a physical or a sexual relationship with the defendant, what was he like there?
Again, very standoffish. Again, that's a statement most people don't want to hear. But once we explained, hey, we do know a little bit more, then he was forthcoming with little bits of information at a time. But at first, no, he didn't like that.
Did he give more and more information about the relationship as time went on?
Yes, sir.
Interviews? All right, tell the jury, did you see anybody threaten Rusty?
No, sir, I did not.
Did you see anybody put a hand on him or hurt him or do anything like that?
Absolutely not, no, sir.
And if you were involved in an interview and you saw even another law enforcement officer cross that line, would you do something?
Absolutely.
See anything in this case give you concern?
No, sir.
Nothing further, John. All right, Weaver?
Good afternoon, Mr. Simmons.
Good afternoon.
My name is John Luke Weaver, and I represent Melody Farris.
Yes, sir.
I don't have a lot of questions for you because I know you really didn't have a lot to do with this case. Would that be correct?
That's correct, yes, sir.
So that first interview, you said you showed up, about 8 or 9 o'clock at night on a Friday?
I believe that's correct, yes, sir.
All right. So it's not unusual that if you show up at somebody's house at 8 or 9 o'clock on a Friday night, that you would ask, do you know who I am?
You're saying me ask that?
Well,
the person, yes.
Yeah. Like,
Yeah,
you know,
absolutely.
are you interviewing the right person?
Sure.
I mean, you catch people off guard.
Yes, sir.
So they want to verify who you are.
Yes, sir.
Okay. So you mentioned something about deleting cell phones earlier. That's
Deleted data off of a cell phone.
okay, but that you're talking about his phone. Did you do a phone dump on his phone?
During the second interview, yes, they were conducting a cell right extraction.
But did you?
No, we were sitting there, so as they're doing it, I was asking him about the data on his phone.
Okay. But otherwise, you were there for just 2 interviews?
Yes, sir.
All right. Are you aware that Cherokee County came up and interviewed him multiple times after you?
I've heard that, yeah, but we were not a part of that.
But you weren't present for that?
No, sir.
Okay. But, the district attorney was talking to you about how you were behaving, but, overall, Rusty was pretty respectful of you, wasn't he?
Yes, sir, yeah. There was no, again, like you said, somebody shows up at your door asking questions of why are you here, and that's understandable, we explain all that, but no, there was no, he wasn't yelling and screaming at us either, no.
Right. And it's not unusual for a person when you confront them with extramarital relationship to maybe not talk about that right away, correct?
Absolutely.
Okay. That's all I have. Thank you.
Yes, sir.
Yeah. Nothing further, Judge. All right, you can sit down. Thank you, sir.
Thank you.
All right, my next witness.
Agent Elizabeth Williams.
Judge, may he stay in? We're going to release him. Okay. All right, it's fine.
Agent, if you could raise your right hand. Do you swear or affirm the testimony you're about to give in the matter now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Thank you, ma'am. Have a seat. If you could please introduce yourself to the jury.
Hey, good afternoon. My name is Elizabeth Williams.
Can you please tell them where you are employed and how long you've been employed there?
Yes, I am a special agent out of Tennessee with the Tennessee Bureau of Investigation, and I've been there about 8.5 years.
What did you do prior to the TBI?
I was also a special agent with our state's Alcoholic Beverage Commission.
How long were you an agent there?
2 years.
And before that, what did you do?
I was in college, and throughout college, I worked as a certified pharmacy technician.
And they just heard from your colleagues, so I won't belabor too much of this, but you're also post-certified there in Tennessee?
I am.
Okay. And what is your region that you are assigned to?
So my colleague is assigned to middle. I'm east. Tennessee has 3 divisions. So east would be like Chattanooga, all the way from the Kentucky border to Chattanooga in Georgia.
Did you go with your colleague to Agent Simmons to interview Martha Barton?
I did.
Okay. And can you tell the jury a little bit about how Miss Barton was towards you all?
I think Miss Barton's interview was the second one that we did that night, and I think it was like a Friday night, maybe even after hours. And our hours end at 4:30, so we're talking probably 5 o'clock and onward, and I think she was the second one that we did. Miss Barton appeared gracious. She welcomed us into her home. She seemed very protective of Melody when we asked questions, Miss Farris. She answered our questions. She also, if I may explain a little further, she also said that she had been instructed to...
Without going into what she told you at this point, was she a little reluctant to chat with you?
She was, yes,
Okay.
ma'am.
And moving on from Miss Barton, what information did you have before going to speak with both Martha Barton and Rusty Barton in this case?
I don't think that I received the original call for assistance. I work with the state of Georgia all the time. GBI, Walker County, this being Cherokee County. I'm usually called, but I don't think I was in this case. I think Agent Simmons was. And because Mr. Barton lived in Tullahoma, which is Coffee County, that was my area at the time, the most natural way for me to get involved would have been for Agent Simmons to then call me. We would have linked up and then went to wherever to interview whomever we needed to.
And so you would have gotten your information from Agent Simmons?
Yes.
Is that fair? Okay. So did you have the occasion to go interview Rusty Barton on July 6, 2018?
We did.
But prior to entering into that interview with Mr. Barton, talk to the jury a little bit about your style, how you conduct interviews of this nature.
Each case is different, but I knew going in that this was a homicide case. I can't tell you what information that I knew just in thinking, trying to recall, other than this is a witness, we need to go talk to him. So I didn't perceive him as a subject, but clearly if the state of Georgia needed us to do an interview or Cherokee County needed an interview that night after hours, it was important. It was important to us because we maintain relationships with all departments, states, whoever calls. So we responded immediately. And the appropriate course of action is, it's non-custodial. We were invited into this person's home. It was his daughter's home. So we were respectful, we were nice, but there is a point where we're wasting our time and whoever we're talking to's time, whoever's requested our time, if we don't get straight to the facts. So this interview will start like all interviews do. We'll build rapport. We'll thank them for letting us come. We're super respectful and polite, but there's a point when we have to ask the tough questions, which is what occurred during this interview as well.
So is it fair to say that Mr. Barton was also reluctant in the beginning to chat with you?
In the beginning, he was nice. I mean, he let us come in. He was confused, or he said he was confused about why we were there. Once the questions became pointed at him, he was very reluctant to answer them, and at one point appeared to be upset that I was asking certain questions.
And when you were invited into his home, did either you or Agent Simmons have your weapons drawn or any handcuffs out or anything like that?
No, ma'am.
And did you promise him anything or threaten him with anything?
No, ma'am.
During that interview, at any point, did you press upon him the importance of what was happening and the seriousness?
Yes, I think so.
during that interview, did you inform him that at some point you're going to go and kind of corroborate, validate, or dispel the information he's providing to you?
Yes, I told him something along the lines of, once we leave this interview here, we have other work to do.
Throughout that interview, when you were asking about Melody Farris, did he sort of distance himself from her?
I can't recall exactly what he said, but I can tell you that he was reluctant to define the relationship. When I asked him something along the lines of being in a romantic relationship with Ms. Farris, he did not want to talk about that.
I want to talk about the subsequent interview. So, on the interview on the 6th, how did that interview end?
I'm sorry, how did it what?
How did it end?
He thanked us, we thanked him. I mean, it was non-eventful. He stayed at his house, we left, we went to do the interview with Ms. Barton.
And on the 10th, did you have the opportunity to interview Mr. Barton again?
We did.
Who was present for that interview?
That interview was divided into two parts. Agent Simmons and I, again, I don't know who contacted whom. However, we got to the attorney's office in Tullahoma, still in Coffee County. Now, Judge Bobby Carter was the attorney at the time that Mr. Barton had retained or agreed to meet with. It was at his office. And we met there in the afternoon. It was Bobby and I, and then I know Ashley Pope, and then there was another maybe detective from Cherokee County.
Would that be maybe Detective Daniel Hayes?
Maybe.
So during that interview, was that a longer interview than the first one?
I think the first one was about an hour. The first part of the July 10th interview was like an hour. We left. Judge Carter called us back and said, we think you need to come back and hear this. And I think the second part, so 1 and 2, part 2, I think was like 2 hours.
So total about 3. Is that fair?
Yes.
From the 10th. Okay. And during that interview, was his phone also being extracted?
Yes, at some point. I think the second part of the interview.
During that interview with Mr. Barton, did you eventually have to sort of, and I'm going to phrase it as have a come to Jesus moment with him about how you were interpreting his position on the questions at that point?
I didn't say a lot, I don't think, during the first and second interviews, both on the 10th. So we'll say July 6th, and then we'll refer to July 10th. July 6th, Agent Simmons and I both had a pretty dominant role because no one from Georgia was there. So whatever information we were going to tell Georgia, we had to get it because there was not a representative there. On the 10th, because there were people, law enforcement personnel from Georgia, we kind of took a back seat. However, the relationship with Mr. Barton and I was already established. We established that on the 6th. He called me pushy. He did not appear to be receptive to my questions. And I think on the 10th, that just kind of flowed right on into that atmosphere. So there was a point when he looked at me, and I don't even know if I knew he was talking to me at first. And then on playback of the recording, I heard him say something along the lines of, well, you don't believe me, or you don't believe anything that I'm saying. And then I go through this long spiel, and it ends with me saying, well, you're picking up what I'm putting down. I mean, it's obvious, whether it was my body language or the questions that I was asking or the way I responded to his questions and answers. It was obvious that he knew, that I knew, that I didn't believe everything that he was saying.
And so at that point going forward, did you continue to impress upon him the importance of this investigation?
I'm sure I did.
Give me one moment. Thank you, Agent. That's all I have for you. Thank you.
Ms. Weaver?
Good afternoon, Agent Williams. My name is John Luke Weaver, and I represent Melody Farris. Just briefly, so you were there for the first interview on the 6th.
Yes.
And Rusty wasn't really happy with you guys asking about an extramarital affair he was involved in.
Of course not.
Okay,
Right.
that's reasonable. Mm-hmm. And he wasn't happy about that on the 10th, right?
Yeah, I don't think anybody would be. Yes.
Okay. That's all I have.
All right.
Sit down.
No further questions, Judge, thank you.
Judge Rusty Bartle's next. Let's go ahead and take a break. We're going a little bit. This will be long. All right, y'all step out.
No, no, don't chew that. No, don't do that. No, no. Not nice. Sorry. Did he say they were having a break and I missed it? Oh no, he's right there. The judge is looking pretty animated. Or I guess maybe it's just their break.
occasions that he is taking certain medication that requires him to go to the bathroom often, and he's good for about an hour, he says, but he may literally jump up and just have to go. The other thing, Judge, is, again, I have no idea what's going to be said. I have a estimate of how it may come across. I have case law, I know the court knows this, I know counsel knows this. With this witness, under 24-6-611, because he's associated with the other side at some point, he's not hostile, but he is associated, so leading questions are more allowed under 611. I'm going to still try not to do a lot of that in the beginning. The other thing, Your Honor, is, as the court knows, the case law is that if a witness, as Mr. Barton's position and posture is, if he says, I can't remember, I don't recall, that's the same thing as a prior inconsistent statement. So I anticipate that he's not going to remember a lot. He also has a hard time hearing. So I've told Mr. Weaver, who I'm assuming is the cross-examiner,
That's correct.
that I'm going to go as far as I can. And I think he'll probably be on the stand tomorrow too, either with me or defense. And then when we break for the day, if I haven't finished, give him another opportunity to listen to everything and see if that refreshes. If not, then we'll just, because I just don't want to do piecemeal. I'm going to ask and he's going to say no, so that's my plan.
I understand. I appreciate that. All right. Go ahead and bring them in. I'm going to run in and grab my cup on the way.
Rusty Barton.
Yes, ma'am. Yes, ma'am.
Ms. Barton, if you just go stand behind the chair and we'll go stand up there and behind the chair, I'll swear to you and you can sit down. All right, raise your right hand. Do you solemnly swear from the evidence you're about to present this matter shall be the truth, the whole truth, and nothing but the truth, so help you God? I do. Go ahead and have a seat. Mr. Barton, does that device work? Can you hear me?
Yes.
It's working?
Yes.
I will try to keep this microphone as close as I can. State your full name for the record, please.
Roy Henry Barton, Jr.
All right, Mr. Barton, you're going to have to speak up louder. You have a very soft voice. We can't hear you. So if you'll do me a favor, try to speak to that back wall, if you would.
Roy Henry Barton, Jr.
Thank you, sir. Do you go by Rusty?
I do.
How old are you today?
71.
What is your educational background?
2 years of college.
And what did you study there?
Business administration.
Where did you go to school?
Montlow State Community College.
Where's that located?
In between Tullahoma, Tennessee and Lynchburg, Tennessee.
After you did that, what type of work did you get in? I believe, are you in sales?
I am, yes, but when I started, I was the bookkeeper for the dealership.
How long have you been doing sales?
Over 52 years.
In the 52 years that you've been doing sales, what type of things do you sell?
Construction equipment, bulldozers, backhoes.
Heavy machinery?
Yes.
If you would, just tell the jury, when you, as part of your job as a salesman, do you have a route? What do you do? Just kind of inform them of what your everyday job is like as a salesman.
I have a designated territory, 11 counties in central middle Tennessee. The core of them, which is about 5 counties, I've covered the entire time. The rest of the outlying counties from the core has been, it changes as they change territories and salespeople and stuff like that.
Is this inside sales or outside sales?
Outside sales.
So these are, do you have to cold call? Do you find your own clients, or how does that work?
Well, since I've been doing it so long, I do very little cold calling, but you know, as new businesses start up, especially nowadays with landscaping.
Is it John Deere, or what type of things do you sell?
John Deere.
Do you sell mainly like bulldozers, heavy machinery to construction companies or to farms, or what type of businesses do you deal with mostly?
All cities, counties, utility districts, farmers do buy quite a bit because I have all of my territory is very rural, so I don't have any large contractors. You know, the guys that do the big state jobs for the most part.
Are you from the city or from the country?
I live in Tullahoma, so.
Well, tell us about that. What size of a city or town is that?
Tullahoma is about 18,000 people, and I was born there.
Your whole life been there?
Yes.
Do you have a lot of relatives there?
Yes.
A lot of friends?
Yes.
Is it a place that you consider close to your heart?
It is my heart. My daughters live there. It's home.
Right. And I'm not going to ask your daughters' names, but you have 2 adult daughters, is that right?
Correct.
And they're your joy? Are they your joy? You love your daughters?
Oh, absolutely, yes.
And grandkids?
4.
Now, as a salesman, tell the jury, if you would, are you an extroverted person or an introverted person? Do you like to talk?
No.
But as a salesperson, I guess you have to do a lot of talking, is that right?
No, you do a lot of listening.
Listening? Mm-hmm. And when you interact with other people, is it important to listen to what they need?
Correct.
Is it important to listen to what their concerns are?
Yes.
Is it important to take details?
They generally tell you.
Yeah, they'll tell you how they feel about things?
Yes. I mean, they know as much about my equipment as I do, so they tell me what they want.
And is your business, is it one that you actually have policies and you have forms and you have computer and things that you have to do when you're doing your sales?
Oh, yes.
What type of tools do you use to do your job?
Well, I have my company computer, and with that is provided all the specifications, you know, for equipment. Most everything now is, there's no hard copies for literature. I mean, you just go on the internet and look up John Deere, just like anybody can.
Do you have, I guess, templates or forms on the computer that you use for quotes and stuff like that?
Yes.
Do you have to pay attention to detail on that?
I do, but I generally get somebody in the office to do that for me now. I don't keep up with the computer stuff that much.
How heavy is the sales when it comes to dealing with numbers and crunching numbers and things like that?
I don't understand what that question means.
Do you have to figure out how much things cost and how much percentage and anything, do any math in your job?
I mean, that's the way that it's done, but in the last several years, I have a sales manager that does that. With this newer company, the sales manager does it for me because we've had to change systems again, and I just haven't caught on to the new operating system.
When it comes to doing public speaking, do you like to do that?
Not particularly.
Do you like to have confrontational settings?
Not at all.
Are you more comfortable in a different type of atmosphere when talking with people?
No.
Are you comfortable at all talking with people?
Oh, yes. Yeah.
Do you like being a salesperson?
I love it.
And could you see yourself doing any other type of work, or is sales just what you do?
Well, considering I've been doing it for 52 years, I think that's, yes, sales is what I do.
Are you successful at it?
I must be.
Is that yes, you are?
Yes, I are. Yes, I am.
I'm from South Carolina, so I sometimes think things differently too. You agree, though, that you do talk for a living?
Yes.
And when you're a salesperson, is it fair to say that you have an objective when you're meeting with people?
Yes.
You want to make the sale.
Correct.
So you have to be persuasive?
I'm not a pushy salesman. One of the pluses of doing this so long is people know me, they come to me, so I don't have to go out and say mine's better than theirs and that kind of stuff. It's different than if you were a 30-year-old person out getting new into the sales and none of the customers know you.
So in some ways, you're either persuasive in a good sense or in a bad sense. Would that be true in your job?
I would assume, yes.
But you're trying to get someone to make a decision, is that right?
Yes.
You understand today that when you are answering the questions, the only thing I'm asking you, the decision I need you to help the jury make, is to get to the truth.
Correct.
That's all I'm asking you. You understand that?
I do.
Okay. I'm not asking you to make a case against anybody or anything else. Can we agree that your job is to tell us the truth?
Correct.
The whole truth?
And nothing but.
All right, let's go back to, you're from Alabama, is that right? Excuse me, Tennessee, I apologize. From Tennessee?
I'm from Tennessee.
Okay. And you are a Tennessee.
There's a big difference.
That's true. And you are a Tennessee fan, is that right?
I am.
And orange is your color, is that correct?
That is correct.
And how many, in your small town, how many people know your family?
A good number. I'm amazed at times at how many people are there that I do not know. But because we have an Air Force base, there's a lot of people that come and go.
And your grandfather was well known in the community?
Correct.
Was he involved in law enforcement?
He was.
Tell the jury about that, please.
All of my young life, childhood life, up to my probably 20s, my grandfather was either the chief of police in Tullahoma or the sheriff of Coffee County, which Tullahoma is in Coffee County.
Do you have respect for law enforcement?
Very much so.
Do you understand that they have a hard job to do some days?
I do that.
Even when they're investigating a former lover for murder?
I do.
Now, if I asked you if you were a fan of Detective Hayes and Detective Pope, which one would you be less of a fan of? Again, honesty is what I'm after.
Okay. Who would I be less a fan of?
Yes.
Sergeant Pope.
If I asked you to say between Sergeant Pope and Detective Hayes, which was the good cop and which was the bad cop when they talked to you?
Detective Hayes was the good cop.
Do you remember Detective Hayes here?
I did not recognize him, but yeah.
Are you married?
No, I am not.
Are you divorced?
Yes.
How long were you married for?
36 years.
36?
I think.
When did that marriage end?
The divorce was final in 2012.
Did your former wife work in the court system at all?
She did. She was a court reporter.
And how long did she do that?
I think 32 years.
Did you have some idea from your family connections and from your former wife's job about the legal system or the legal community?
Probably not as much as you would think, because I was never involved in anything with going to court or anything like that. My grandfather being the local police chief and the sheriff, you know, I was single digits teenager when he did most of that. And then my wife, when she was a court reporter, my biggest job was delivering transcripts back to people.
Sure. Never thought you'd be in the middle of a murder trial testifying as a witness, did you?
Never in my entire life.
Do you want to be here?
Not at all.
You understand why you're here, though, right?
I do.
Are you an outdoorsman?
I am.
Tell the jury, what are your hobbies when it comes to hunting, fishing, things like that?
Hunting.
What type of hunting do you do?
Almost all is deer hunting, whitetail.
How avid of a hunter are you?
Some would say very.
Do you ever travel to other states to hunt?
I do.
We talked about Kansas.
Kansas, Colorado, Texas, Idaho, Montana, Canada, Mexico. You want more?
Sure. Where else have you traveled?
New Mexico, Florida, South Florida.
Mainly deer hunting?
Deer, elk, antelope, waterfowl, quail, dove.
Do you use firearms and a bow?
I do hunt with a bow some, yes.
Do you use one more than the other?
No. Bow season for me is very short, and I don't use it a whole lot. But the rest of the time, I'm generally a muzzle loader and rifle hunter.
Do you have any experience being connected to a farm?
My other grandfather, not the chief of police, my daddy's dad, they lived across the street from us, or we lived across the street from them, however you want to look at it. And he had probably a couple 100-acre farm, ran about 80 Black Angus cows, and they had a little country store.
Did you have a farm at some point?
I did. I inherited my mother's farm and with my sister, and had it for a few years.
And how big was that?
115 acres.
What did the farm do? Produce anything, or was it animal farm or crops?
When my mom and her husband had it, they raised cows also. And then after my sister and I inherited it, I had one of the neighbors got to cut hay off of it. It was a hill farm, pretty steep hill. And the rest of the time it was, just a place for me to go deer hunting.
Are you a person that can basically build a house from scratch?
No.
Do you have any skills in carpentry or anything like that?
In what?
Carpentry, building things?
Not very good at it. I would be more a framer than a finished carpenter.
Have you ever tried to build a house or add on to a house or doing construction?
My dad and I one time built a 20 by 20, we called it a barn, but it wasn't perfect.
How about farm equipment? What can you use?
The only thing that I ran down at the farm was a small Ford tractor.
Okay. What size, do you remember?
I do not remember the model.
Old type of tractor or more common new tractor?
It was like
wheels narrow up front or wide?
I'm sorry?
The wheels in the front, were they close together or wide?
You didn't run it close together. You didn't run a tricycle on a hill farm.
Okay.
So they were wide, yes. It was about a 95 model.
How about RTVs? You ever used an RTV, drive an RTV?
I have.
Do you own any?
I do not. I never have.
Any side-by-sides?
No.
Do you ever use those things during hunting?
No. Now, when you're saying, I have a four-wheeler.
Okay, let's talk about that. What type of four-wheeler do you have?
It's a 1997 model Honda 200.
Do you take that hunting with you?
I have, but not in several years.
Anytime that you're hunting, do you ever use a four-wheeler or something like that to move deer?
Yes, I have tied a deer to the back of the four-wheeler and drug it,
You said tied. How do you tie it?
just with a rope to the luggage rack.
Nothing fancy, something simple just to move it?
Yeah.
Do you have a truck?
I do.
What kind of truck do you have?
Ford F-150.
Do you have a motorcycle?
I do.
What type of motorcycle do you have?
I have a Harley.
Which brand or model is it? Which model is it?
A Road King.
How long have you been riding motorcycles?
All my life.
Something you like to
Since
do?
I was 14, I should say. That's when I got my license.
Is that something you like to do?
It is, not as much so in the last few years.
Do you own any guns?
I own a bunch of guns.
Tell the jury, if you would, what type of guns that you have. Is the list too long? I think as you're saying, you said to law enforcement.
Okay, I was going to say, can you say that? Yes.
Yeah,
The
you can.
list is too long.
I think when law enforcement asks you about guns,
I couldn't even rattle them all off if you wanted me to, but I could tell you a good number of them.
roughly about how many do you have?
I don't know now. I probably have 40.
And out of the 40, how many of those are handguns?
Probably 6, 8, maybe 10. I don't know.
Did you ever talk to the defendant about how sometimes bullets and guns are tested?
Say again.
Did you ever talk to the defendant about have conversations about how guns and bullets are tested?
Not that I recall.
You don't remember doing that?
No, sir.
Where were your guns in 2018? Where were your guns stored?
They would have been in a storage building in my gun safes, except for the one or two that might have been in my pickup truck.
When law enforcement came and talked to you about this case, did they ask you where your guns were?
To the best of my recollection, yes, they did.
They were interested in your guns, were they not?
They were.
And they asked you where the guns were at?
I don't remember them asking them about being in the storage building in a gun safe, but I think they just asked me what I had and if I had any, I guess basically with me. And I told them that I didn't have any on my person, but that I had, I think, a couple in my truck.
You had 2 in your truck, I believe. Is that right?
I think that's right, yes.
357 revolver and a 40 caliber Glock?
Glock, yes.
Did you voluntarily turn over or give the 357 to law enforcement in this case?
I did.
And did you know that gun was tested or looked at by the GBI?
I didn't know that, but I kind of figured it was. That's why they got it.
Do you remember telling law enforcement about how many people knew where your guns were at?
I'm sorry.
Do you remember saying only 2 people remembered or knew where your guns were at? Yourself, I believe your daughter?
I don't remember saying that, no, sir.
Were they kept somewhere else besides your house?
Yes. Yes.
Tell the jury about that.
I did not keep any, I lived at my daughter's house at the time. I was in between houses. And I did not keep any guns in the house because her husband was not a gun person and was fearful of them. And so I kept them, and I had 3 gun safes, still do, and I kept them in the storage building, I don't know, a few miles down the road. And so all the guns were in there except, I guess, those 2 at the time that were in a bag in the kind of the back floorboard of my truck.
Do you remember when law enforcement came up and executed a search warrant to look at your guns?
Actually, I don't think they had a search warrant. They did for the house, and I guess they were looking for guns.
That's fine. Do you remember them coming up looking for your guns?
Yes, I do.
Now, you're junior, Roy Barton Jr., is that right?
That's correct.
Your dad is senior?
Yes.
And I'm sorry, I know he's passed away. I'm not trying to go
No.
down that or anything, but did he have a lot of guns?
He had several. Most of them had been rolled down to me at this point.
Do you have pistols?
I think he had 3.
Were any of those a 38 special?
Not that I'm aware of.
Do you know where those guns were at in 2018?
I do not.
Do you remember telling law enforcement that they were in Martha Jane's house?
With that, yes. I thought you meant like specifically in the house. No, they would have been there at Martha's house. Yes.
Wherever they were at in the house, is that right?
Correct.
But you don't know exactly what pistols he had, is that fair?
No, he had a Colt Python 357. He had a Browning 22, I think they called it a target pistol. And then he had gotten Martha Jane a pistol, and I really don't know what it was.
Had a 357?
I do not know.
I want to talk about Martha Jane. Who is Martha Jane Barton?
She is or was my dad's wife, second wife.
Stepmother?
Yes.
What year did they get married or come together?
1975.
And how long were they married?
Until he passed away in 2014.
In 1975 from 2014, where did they live?
They lived in the house that I was raised in with my mom and dad on Avoca Road. And then a few years after they got married, they built a new house on what's Carter Blake Road. And Martha still lives there.
How old is Martha today?
I think she's 83.
How would you describe Martha?
A good woman, worked at the bank for 53 years, I think. She's in very poor health now. She's had all kinds of procedures and heart valve replacements.
She's had heart issues.
Yes.
Doesn't do well with stress.
No.
And but in Tullahoma today, she lives still in the house.
Yes, she still lives in the house by herself.
Now, help explain to the jury the relationship between Martha Jane. Sometimes y'all refer to her as MJ. Is that right?
That's correct.
So the relationship between Martha Jane and the defendant.
Martha and Melody's mom were first cousins.
So the defendant would be second cousins to Martha.
I don't really know how all that
One
works.
level down.
Yeah. Because
So
there's
related,
first cousin twice removed, and
sure, related by blood, but referred to as cousins. Is that?
yes,
And you would be the stepson of Martha Jane.
correct.
When it describe to the jury the relationship through the years and how close they were, the defendant and Martha Jane.
Very close. My dad, when he was alive, he was not much of anybody of a man that wanted to drive. Martha always drove, so anytime Martha needed to go basically anywhere, which most of the time was to go to Nashville to the heart doctor, Melody would come up and get Martha and then drive her to Nashville to the doctor. and did that off and on for years.
Would you describe the defendant's relationship with Martha Jane more akin to a mother-daughter?
Very much so.
If you could say, who does the defendant love the most in the world, where would Martha Jane be on that?
Very high on that list.
Would you describe Martha Jane as a God-fearing lady?
I didn't understand.
Would you describe Martha Jane as a God-fearing lady?
Very much so.
A Christian?
Yes.
She didn't know about your sexual affair with the defendant, did she?
I don't think so.
Would that have broken her heart?
I don't know. Probably.
She'd been disappointed in you?
Yes.
The two of you hid it from her, didn't you?
Yes.
Through the years, how often would the defendant come and see Martha Jane?
Are you talking like 30 years ago up to now or then?
Yeah, what I want you to do is to explain to the jury, some relatives see each other once a year at family reunions. Some relatives
Right.
never see each other for 5 years. Some relatives never see each other at all. How often would the defendant come up and physically be involved in Martha Jane's life?
That I do not know, because I didn't always know even when she would come up. I mean, she would come up and do things, and and I wouldn't know it.
Would it be more than occasional?
Yes, I would think so.
So a common event for the defendant?
I would think so.
A lot, I guess, is another way to say it.
That's a relative question, so I don't know. Again, I didn't know every time that she came up through the years. Sometimes it might be weeks later, my dad would say that Melody had been up.
When they would see each other, would the defendant come to Martha Jane's house or home?
Yes.
And would she be family and have access to the home?
Yes.
Come and go as she please?
Yes.
Full access to everywhere in the house?
Yes.
Could even come to the house when Martha Jane's not there?
Yes.
Did the defendant help Martha Jane with her property and things in her house?
She did.
I want to talk to you about the defendant. You see Melody Farris here in court today.
I do.
Describe something she's wearing and point her out for the record, please.
Glasses on top of her head, gray jacket, black top.
Just point to where she's at, please. Now let the record reflect the witnesses identify the defendant.
All right, so
Is it awkward being here in court in front of her?
It's awkward being in court, period. So yes.
When it comes to your feelings for the defendant at this moment, how much love do you have for her?
Don't know that that's a measurable item.
That's what you have to do in court, sir. Tell me how much love you have for her right at the moment.
I do not know.
Do you love her?
I do not know.
But you did love her in the past, correct?
Correct.
You were in love with her, fair to say?
Yes.
And she was in love with you, fair to say?
Yes.
Now, you've had an opportunity to listen to some of your recordings in this case. Is that true?
I have.
And you know that there are recorded jail calls and other calls with you and the defendant?
Yes.
Can you tell the jury, did y'all have a special kind of words or codes or terms of endearment that you would use with each other?
I'm assuming that you're thinking about some of them. Yeah, we did.
Like what were some of those phrases y'all would share all the time on the phone or when you talk?
one of them would be all.
ALL, all,
Yes.
right?
Uh-huh.
What does that mean? At the time when this was, you were still together.
Yes, yeah,
Are you telling this jury today that y'all are not together, right?
correct.
Right. At the time, even after the arrest, when you were still together,
Mm-hmm.
what did all mean?
It meant, and it kind of started back when Dad got sick and Martha was having the heart surgery. You know, don't know what we would have done without Melody being up there taking care of Martha, because then I was having to take care of Dad. And so we talked most of the time. We talked several times every day, and it was, okay, we got this, get started, do the day, you know.
To encourage one another, maybe?
Yeah, just, you know, okay, you take care of this, I'll take care of that, and we get through the day.
Would that encapsulate for better or for worse?
No.
It wouldn't?
No, it was not I wouldn't put it as an emotional love you kind of thing. It was let's go tackle the day kind of thing.
But you would say that to her, and she would say that to you during this investigation and after the arrest. Is that true?
It is.
So it applied to this situation.
It means just handle the day. Do what's got to be done.
So my question
be
is,
strong.
My question is, yes or no, it does apply to her murder charges?
I think it applies to the whole thing. I wouldn't say specifically the charges.
But her situation in 2018,
Yes.
2019,
The situation.
right, when she's been arrested for murder, y'all are saying all to each other, right?
Correct.
How about, did you ever say the word forward? Tell the jury what forward would mean when you would say it to one another.
Forward is a very similar thing to all. It just keep moving forward, keep going, get things done, handle what life throws at you.
How about, would she ever say she wants your hand on her waist?
She did.
What does that mean?
At my father's funeral, she came up and we were standing by the casket, and you know, everybody comes by and you hug and thank them and all that, and we were just standing there, and I put my hand on her waist. It was kind of it was a strength for me to get through the day.
And she has said that to you after being arrested for murder. Is that accurate?
Mm-hmm.
What age did you meet the defendant? How old was she?
The first time I met her,
I think you met her when she was 15,
that would probably be about right.
1975?
Correct.
Where did y'all meet?
At Dad and Martha's wedding.
Really? And what did you think of her when she was 15?
I don't even remember.
Do you remember when her and Gary got together? Because they got together young, I believe. So at 15, how close were you with her during her teenage years and the early years?
Not at all.
Not at all?
Not at all.
Just kind of knew of her? You just knew of her?
Yes.
How often would you see her? I'm going to get to 2014, but before then, how often would you see her?
Rarely. Very rarely.
Now, how smart is the defendant?
I don't know.
Is she smart or not smart?
Well, I would consider her smart, yes.
Would you consider her hardworking?
Yeah, very.
She didn't suffer a slacker, did she? She didn't like lazy people.
She was not a slacker, no.
She didn't like lazy people, did she?
No.
Would you describe her as a take charge person?
Yes.
Would you describe her as a person that gets things done?
Yes.
In fact, that's what you told law enforcement, right?
I'm assuming I did, or you wouldn't have asked.
Is she a planner? Someone who makes plans?
I would say yes.
Does she have a backbone?
Yeah, she does.
In fact, I believe in 2014, you first talked about it. How much did she help with Martha Jane and your father during that time?
Oh, she was an absolute tremendous help. I don't know what we would have done without her. One time she was up, and of course, Dad and Martha both. I mean, Dad had a stroke, went in the hospital, then went in the nursing home, and he never came home. And Martha, then during that period of time, had tests and then heart valve replacement. And one of the things that happened was the sewer system backed up and flooded the house, and she met with the septic tank people to get it cleaned out. So,
She gets things done, doesn't she?
yes,
She gets her hands dirty, doesn't she?
yes.
All right, let's look at March of 2014. Why is that month and year significant in the context of you and the defendant?
Say it again.
March 2014.
That probably would be when Dad went in the hospital. I didn't remember that month exactly.
Okay, and that's when the defendant came up to Tennessee, is that right?
Yes. She was already there, actually, when Dad had his stroke. Her and Martha were, at the time, were already in Nashville at the doctor's office.
And then kind of later on, a couple months later, I think it was in September 2014, was it not, that things changed between friendship to romance?
I do not recall not even the month.
Do you recall the year? Was it in 2014?
Yes.
Tell the jury how that happened. What was going on?
We were just in close contact with each other, almost day in, day out, trying to handle everything, and it became, we became a thing.
So your relationship with her started in 2014.
Yes,
Did you know she was married?
I did.
Did you know she was married to Gary?
I did.
And I'm not asking for details or anything, but you two were intimate during this relationship?
We were.
And so you would know whether or not she has any tattoos on her?
I would.
Tell the jury what tattoos she has.
She has a red heart and the Roman numerals XO.
XO tattoos on her, right?
Yes.
And those tattoos represent you, do they not?
No, they do not.
They don't?
No, sir, they do not.
Who do they represent?
They do not represent anybody.
But you were with her when she got those tattoos, right?
I was.
And y'all went to the tattoo parlor shop together and got them?
We did.
So you were there when she got them.
Correct.
And y'all both like to drink Crown Royal, is that right?
That is correct.
And so you're with her when she gets the tattoos, then she gets the tattoos, and it's both of the drinks that you like. Is that right?
Yes, the XO is for the Crown Royal XO. That's
How about her phone having XO in it for you? Do you know anything about that?
No, I didn't know that.
Do you know if she's ever referred to you or the number for you as being XO?
I do not recall that.
You didn't know that or don't know that?
I do not recall that, so I don't know whether it.
How many times do you think you and the defendant, and again, I'm not trying to get into the list of details or anything like that, but you two would rendezvous at a certain place, is that right?
Yes.
What city would you both meet up at?
Dalton, Georgia.
And Dalton was about 106 miles from Tullahoma, your home, is that right?
Yes.
Takes about an hour and 45 minutes to get there.
Roughly, yes.
Do you know it's about 80 miles from her former home in Cherokee County?
I just kind of figured it was about halfway.
Takes about an hour and a half from her house to get there. Is that right?
That I don't know.
But I guess the point is, why y'all were meeting Dalton is because it was halfway between the houses.
Right.
And when you met in Dalton, there's a certain exit that you would meet at.
Correct.
What exit was that?
333.
333. What hotels would you stay at there?
Mostly the Super 8.
How many years were y'all meeting up there? From 2014 to 2018?
Yes.
Who would pay for the rooms for y'all two?
I would.
Always?
Always.
Why is that?
Just what I do.
Explain that to me. Why?
I always thought the man paid for things.
In the beginning, I think, did y'all meet there monthly?
Oh, I don't remember how often and when and that. I'm
But
sure
it-
there's records, but I don't.
Did it progress to meeting weekly?
At times.
Did you meet more than one time during the week?
It's possible that we did. I do not recall that we did, but I'm.
You wouldn't dispute if
No.
that was the
Oh,
case?
No, again, I know there's records, so.
Did you ever ask her when y'all were meeting up, what is she telling her family why she's not there? Did you ever ask her?
I don't think so.
You never asked her what excuse or what are you telling them when you're coming to meet me? You never got curious to ask her how she's doing this? Not one time?
No. I'm trying to think how to say it. She could go and come as she pleased, and so she was very open to get to leave home and be gone and come back. Nobody kept tabs on her.
She wasn't a prisoner in her home, is what
No,
you're saying.
Not at all.
My question, though, is if you're meeting weekly and you're having an affair, are you not worried about her husband going, where is my wife? Did that not ever pop up or y'all talk about it?
No, it didn't. I guess we did talk about it, but I think she got to do her thing and he did his thing, and I don't think they didn't keep tabs on each other.
Right, but you're not trying to tell this jury that y'all were having an open relationship.
And I guess I'm saying that they did.
From based on what?
What she said.
What she says?
Yes.
So were y'all open at the wedding, Emily's wedding, going around openly engaging in a romantic relationship at Emily's wedding? Is that what you're telling the jury?
I don't recall us being very openly romantic at the.
Right, that's the point. You weren't, correct?
I don't think so. I mean, we might have sat at the same table at times and we might have danced together, but I wouldn't call us. I did that with other people there too.
Sure. My question is, you weren't being openly romantic in front of her family at Emily's wedding, were you?
No, I wouldn't think so.
That's because y'all were hiding the relationship, right?
Yes.
Now, you had a girlfriend named Christina Grant, I think in 2017. Is that right?
I did.
And you were hiding the relationship that you had with Melody from her?
Correct.
And she did something that you did not want her to do. Is that fair to say?
Yes.
Tell the jury what she did.
She sent an email to Gary Farris, Melody's husband, telling him, I don't know exactly what it said because I never saw it, but telling him that Melody was having an affair with me or vice versa, however it was worded.
I think that was in October of 2017. Would that be?
Yes, I think that's correct.
Now you just said on the stand that you never saw the email, but did you not see an email, a copy of the email that the defendant took on her phone from Gary's phone?
I could have, but I do not recall seeing it.
Judge, you might just have one more. But you did talk to Christina about the email she sent.
I did.
What did you tell her to do?
I don't remember what I told her to do. I just told her that what she had done was pretty stupid and she shouldn't have done that.
Did you not tell her that to tell Gary it was just a rumor? Do you remember telling Christina to get back in contact with Gary and let him know that it was just a rumor because he's a lawyer and he would understand a rumor?
I do not recall that, no, sir.
Were you concerned that because Gary was an attorney that he could drag her information and her lifestyle into a court?
Yes.
Do you recall telling Christina that he could bring you in and ask you about your sexual partners or things like that?
Say again.
Do you remember telling Christina that you were concerned that Gary could bring her in and ask her about her relationships with other people?
I do not recall that, but I could understand that I might have said that.
Do you remember what happened with the defendant when Gary got that information from Christina? What did she say to you?
What did Melody say to me?
Yes.
That Gary came into her room and told her that he had gotten that email.
And how did she feel about that? How did the defendant feel about Gary finding out from Christina?
I think she was just upset because Christina had done that.
Mad at Christina?
Yes.
Mad at you?
I don't think so.
She's very forgiving towards you?
I don't think at that point I'd done anything wrong.
When you would, through the years, communicate with the defendant, would you talk to her in person? Would you meet her face to face? We know about going up to hotels and meeting in Dalton, but outside of that, would you ever just go and do things with her, go out to eat or do other things?
Yeah, sometimes when she would come to town, we would go somewhere and eat or something.
And when you would talk to her, how many times a day, tell the jury, how many times a day would you talk to her on the phone, whether it's by voice or by text messages?
Off and on all day.
Almost every day?
Almost every day.
What was your pattern? What time of the day would y'all talk and how would you do it?
Well, I didn't know there was a pattern. It was just random phone calls and random texts. I don't think there was a pattern.
Would you get up in the morning and call her?
Probably.
Would you call her through the day?
Mm-hmm.
Would you call her in the evenings?
Mm-hmm. Or
So-
she would call me or whatever. Yeah.
So once you get up in the morning, would she be the first one you would call?
Not necessarily. I don't
Normally?
know. I don't know. I mean, that I don't know.
Would she be one of the first persons you would call?
Probably.
And during the day, how many times do you think you would call her during the day every day?
I cannot answer that question. I mean, I'm sure you have records and could tell every specification there is about it, but I couldn't answer that.
Was it less than 5 times or more than 5 times?
I'm sure it varied. I'm sure it was both.
And what things would y'all talk about?
Everything from the weather to the kids to the grandkids to Martha, Daddy. I mean, just life.
Now, I'm going to talk to you about July 10th of 2018. Do you remember when you had another interview with the sheriff's office and some people from the TBI?
On July the 10th?
Uh-huh.
Okay?
Do you remember in July 2018
I do.
speaking with law enforcement?
I do, yeah.
Was there a time that when you were speaking to law enforcement that the defendant just kind of unannounced showed up?
She came into town, if that's what you're asking.
Yes, that's what I'm asking.
Okay, yes.
All right, tell the jury about the time she came into town when law enforcement was there.
I think that we had my attorney and myself had an interview with Detective Hayes, and I'm assuming since you said it that way that was the day that the TDI was there too. And I think after that meeting, and my attorney's office was downtown Tullahoma, so after that I left and went to Martha's house to check on her, to see how she was doing, and then on my way back to town, I noticed that Melody was behind me.
What vehicle was she in?
The Mercedes.
She had not told you she was coming up, correct?
Correct.
It was a surprise, right?
Yes.
Unannounced, would you say?
Yes.
And she was there because of why?
I guess because I was with the police.
What did she ask you?
What did they say?
What did you tell her?
I'm assuming whatever they said. I don't remember what conversations we had.
What else did she say to you?
Don't remember exactly, but I would say, why are you here?
And did she give you any instructions or anything to say or not say to them?
No.
She tell you not to talk to law enforcement?
Probably. I don't remember that for a fact, but
But has she told you through this case not to talk to law enforcement?
yes. No, not to talk to them, but I mean, I'm not going to run and hide, but just don't sit down and have a conversation with them. Be polite.
So you're saying she did not tell you to stop talking to law enforcement?
Okay, there's talking to somebody, and then there's telling them, answering questions, and that I think that's what was meant.
So tell me that. You're telling me that she told you not to answer questions of law enforcement?
That was my assumption of what it meant, yes.
She didn't want you to give law enforcement anything that could be used against her, right?
You don't want nothing to be used.
can answer. He's not speculating. He talked to her and had face-to-face conversations.
He doesn't know what she was thinking, so he can answer what she said and maybe how he interpreted it.
Go ahead and answer the question.
Sir?
You can answer the question. Did she talk to you and tell you not to talk to law enforcement because they were trying to get information on her?
I don't think it was spread out verbatim like that. It was just, don't talk.
I mean, it wasn't about anything else except the murder case, right?
Correct.
It didn't have any. I mean, there's no other reason you're talking to law enforcement, is there?
No.
Gary was found on July 5th of 2018. There's a calendar right there. Do you see that Thursday, July 5th, 2018?
I do.
And almost a year later, on June 18, 2019, the defendant was arrested. And you know that, don't you?
I do.
How do you know that?
I'm the one that carried her to the police station, turned her over to the police.
Because she was staying with you in Tullahoma?
No, she was not staying with me. We were together, having lunch.
Physically present with her that day, right?
Sir?
You were physically with her that day?
I was, that afternoon, yeah.
She was in your vehicle?
She was.
And y'all had been together for how many days?
We had not been together for days. We had just left that afternoon to go. We were going to go have something to eat and then go someplace else, like Franklin or something.
So you're trying to say you were not socializing or hanging out or being together as a couple during this time?
Well, we were going to go have lunch, a late lunch, so I would, however you want to word that, yes.
Well, how many days was she there before she got arrested?
Several.
How many several? Are we talking days or weeks?
A week or 10 days.
And how many times out of the week or 10 days did you see her?
I do not recall.
Probably every day, wasn't it?
I wouldn't think so.
The day of the arrest, you actually, when she was in the car, you brought her to the police department, I believe.
I did.
And then after she was arrested, you talked to her on the phone numerous times. Is that right?
What time frame were we talking about?
In June and July and other dates after she was
yes.
arrested? Now, I want to go from how many times do you think you talked to her by phone? Let's go from July 4th of 2018, the 4th of July, to, let's just go after the arrest, October 31st of 2019. So from 4th of July in 2018 to Halloween in 2019. How many times do you think you talked to her on the phone? There's roughly 484 days during that time period. How many times do you think you talked to her on the phone?
A lot.
What is a lot?
I don't know. You have the number, I don't.
More than the number of days?
I'm sure.
How many text messages do you think you shared with her during that time?
You have the numbers, I do not.
How many times do you think you said, I love you, or something all or for to her during that time?
Every day, probably. Or every day we talked.
Because you were there to help her, right?
Of course.
You loved her, right?
Yes.
You were supporting her, right?
I was.
You're going to do what you can to help her out of this fix, right?
I was.
In 2018, when they talked to you about the case, the first time that law enforcement talked to you, I think it was the TBI that came out on July 6th. That was a Friday of 2018.
Correct.
Do you remember how many phones and phone numbers you told law enforcement that she had?
I do not.
Do you remember when you met with them again, changing that number or giving more information?
I do remember changing it. I don't remember what was said.
After the first interview, you gave information that she did have a burner phone. Is that right?
That's your terminology. I don't use the terminology of burner phones. Both of her phones were, I would call a straight talk, that you actually purchased the minutes for. So,
would it be fair to say that one of the phones she used almost exclusively for you?
I do not know that.
And the other phone she used for public or other people?
I assumed that, yes, but I do not know that. Those they were her phones.
So her regular phone is one. Is that fair?
Say that again?
She has a regular phone, and then she had this other phone?
I think they were pretty well both identical. So.
Okay. But you didn't give law enforcement the other phone number the first time, right?
I don't know. I mean, I did not. I mean, I don't know the phone numbers. They were all in my phones.
Now, at some point when you met with law enforcement during this, you and your attorney, Bobby Carter, met with them and cooperated. Is that right?
That's correct.
And then when you met with them, you actually agreed to record calls between you and the defendant. Is that right?
That is correct.
And they actually gave you a recorder to record calls. Is that correct?
They did.
And you would actually try to do that at certain points?
I tried.
You tried to record some calls with her. And
With
that's
the
because
recorder, yes.
it was told to you, not only by your attorney, but during the conversations, that it's in your best interest to do that?
Yes.
And you want to help yourself. Is that true?
Absolutely.
But at some point, law enforcement had to come back to you and ask you about the recorder, didn't they?
They did.
And they had to ask you about the recorder because you actually told her about the recorder and recording the calls, right?
I did.
So let me get this straight. You want to help yourself because of the situation, and you agreed to record the phone calls with her, but you tell her you're recording the phone calls, right?
I did.
So she knew she was being recorded, is that correct?
Well, she knew that I tried. I never was successful at it.
Yeah, she knew you were recording the calls, right?
I never was successful at it.
I understand that because you told her, but she knew she was being recorded, right?
I told her that I had a tape recorder that Detective Hayes gave me, and that I was told and asked to try to record our phone calls.
And in fact, there was a conversation between you two that she said, didn't you say they were recording calls? And you were telling her, no, you were lying to her.
That's right.
And then they gave you after they confronted you about the recorder, you weren't forthcoming to tell them, oh, by the way, I did tell her. You lied to them, didn't you?
I did.
You told them you weren't recording. You didn't tell her you had the recorder, right?
You're correct.
And then they had Calios, the software on your phone that would record calls without having a recorder. Would that be fair?
Yes.
And you recorded a lot of those calls, right?
The way I understood how this worked, they put something on my telephone, and I mean, it was very odd the way it came through, but it came through, and then I would answer the phone, but at the same time, every phone call that I got from her through this system, also went directly to Detective Hayes.
Right.
And then I'm assuming was also recorded.
And counsel's going to ask you about those calls and what was recorded on those. But you agree with me that when they started doing the recordings on the Calios, that system, that was after you told her about the recorder, right?
Yes, yeah. We went to that system after we tried the tape recorder.
All right, help me on this timeline. She's arrested June 18th, 2019. This counter's not open. June 18th, 2019. And then on June 25th, 2019, you come back to talk to law enforcement with your attorney to give some more information, right?
Okay, you lost me. Say that again.
The last conversation you had with law enforcement, the last recording, you recanted the statement you given earlier.
That was not the last time that I was with law enforcement. That was the next to the last time, I think.
Okay. In June of 2019, after the defendant was arrested,
right,
you did have a conversation with law enforcement. Is that correct?
Yes, I think they came back the next week.
Okay. That next week, when you're talking to law enforcement, getting back to phones, did they not ask you if you ever met with a defendant in person and talked around the phones? Do you remember that?
I do.
And you told them, yes, we did meet in person and we did talk around the phones, right?
Correct.
So y'all were outside of law enforcement talking about the case so they couldn't hear it. Is that fair?
Mm-hmm.
And then they just took one more step and they asked you, did you have new phones? I call them burners. You may not like that term, but they asked you if you had other phones. Is that true?
Yes, it is.
And they asked you, did you talk about the case outside of the other phones that we had that we can listen to? And you said, yeah.
Yes.
So, is it not true that you were telling her the recording, I'm talking to them, don't say anything that you can incriminate yourself?
No, that's not true.
It's not true.
I didn't say that.
Not one time.
No, sir.
It wasn't even implied one time.
Nope.
So why are you having these other phones to talk outside of the phone calls?
I wanted to make her comfortable so I could find out if there was anything that wasn't known.
You want to make her comfortable. Mm-hmm. So you just had to go buy these other burner phones so law enforcement didn't know that y'all were talking?
Correct.
You agree that's suspicious, right?
Of course it is.
And you're doing it, correct?
I did.
With a woman charged of murder and burning her own husband, right?
I wanted to know.
But you didn't tell law enforcement until they pulled it out of you, right?
You're not going to put a banner up. I tried to find out. I wanted to know.
I'm going to come back to some of these phone calls. But I want to talk about when you were... Let me try to step it back and lower things just a little bit. You need a restroom?
No, but I could use some water.
Oh, sure. Do we have it?
But there's nothing here. Up here. It's empty.
Let me get you. I got one. I've got
Here.
a bottle of water here.
There's barely enough there.
Oh, okay. Thank you.
I was gonna say let's go about 10 more minutes and take a break. So.
It's gonna be a while.
I know, but I'm sure the other folks want a break. Do you need one? You want a break? Oh, you're good? Okay, all right.
Mr. Barton, let me know when you're ready to go.
Okay.
When you were in the relationship with the defendant, you did or have some future plans to be together?
It was talked about. No plans.
No plans?
No plans.
None.
No specific plans.
Did the defendant tell you that Gary was sick?
Yes.
Tell the jury what she told you, what ailment he had.
My understanding was it was esophageal cancer.
Throat cancer.
Yes.
And you had somebody, a friend, a young man that had died from that?
That's correct.
What did she describe he would do because of this? What things would happen to him?
He would throw up blood.
She'd have to change the sheets and things like that?
I'm assuming, yeah.
I mean, did she tell you? But you weren't forthcoming in all your answers, were you?
I didn't know my name.
But you knew enough to talk for several hours, though. Would you agree with that?
I don't think I talked for several hours.
But you did give information.
I might have been questioned for several hours, but I don't think I talked for several hours.
You did give information each time you talked to him, right?
I'm assuming I did.
And you didn't tell the whole truth in the beginning, did you?
Don't think so.
Well, you know you didn't tell the
No.
truth. It's a lot easier if you just come out and say it. You didn't, you're good with the TBI, how they treated you. You didn't necessarily like how the sheriff's office treated you.
Correct.
And that was because the demeanor of Sergeant Pope.
That is true.
Tell the jury how he was with you.
Very aggressive, vulgar, pushy, finger stuck up to my nose. I would back up. He would pull forward. I would back up. He would pull forward. Did that 3 times once. I had to ask him. Actually, I think I asked Detective Hayes to have Pope leave the room.
And how big are you, sir?
Sir?
How tall and how much do you weigh at the time in 2018?
Well, 6'3". I'm assuming that I'm still 6'3" and was then. I don't know. I'm probably in the 250 range.
Around 250. I think you went to the doctor and weighed one morning about 240 something. But do you remember what size Sergeant Pope was?
I wouldn't classify him as a great big fella.
And he never hit you, did he?
No, he never did hit me.
He never put a finger on you, did he?
He was very close. So I don't know if he touched me or not.
Well, I mean, he shook your hand, I assume, that day.
Well, yeah, but that's different.
But he didn't threaten to hurt you.
I think you're talking aggression.
Sure, he didn't threaten to hurt you or strike you or harm you or anything like that.
No.
Just was bad cop.
Yes.
I mean, got to cussing at you.
Yes.
Talked about death penalty, things
Yes.
like that. Talked about murder cases, right?
Mm-hmm.
Put the fear in you. Fair to say?
Mm-hmm.
You're doing pretty good. You're going to say yes or no.
Sir?
You're going to say yes or no, not.
Oh, I'm sorry. I'm sorry. I should know that.
That's all right.
It's all right. You've
You
done
don't-
pretty good until now.
Yeah, you haven't. You don't do this every day. I mean, at one point he talks about the serious nature of the case, and they expose you to how serious of a case this is. Is that fair?
Yes.
And do you understand when someone's murdered and then burned, that is aggravating under the law? That is very serious.
Do not know the terminology, but it is serious, yes.
Would you agree murder's one thing, but then burning the body is also adding to that?
Of course, yes.
So we're not talking about jaywalking or speeding. This is serious. And at one point, they came with, I guess, fake arrest warrants or some type of warrants for you for two charges.
There was a arrest warrant given to me. I just immediately gave it to my attorney.
Right. A physical piece of paper.
Correct.
But not have been issued into the computer or signed by a judge. They just said, here's the things we're looking at with you,
The
right?
way I understood that it was an unsigned arrest warrant.
And do you remember what those charges were?
I do not.
Conspiracy and then concealing, do you remember?
No, sir, I do not.
But you do remember they presented you with an arrest warrant.
Correct.
You didn't like that, did you?
Well, no, I was scared to death.
Sure. Your attorney, Bobby Carter, after July 6th, so I think it's going to be July 10th of 2018, July 24th of 2018, and then June 25th of 2019. When you met, your attorney was with you during the whole time, right? Outside the first time.
Yes, I think so.
Yeah, and he's a good guy, very smart guy, right?
Bobby?
Yeah.
Yes.
Yeah, a good man.
Yes.
And he's actually a judge up there now, correct?
Correct.
So he knows what he's doing, right?
I think so.
Yeah. I mean, you trusted him, correct?
I do.
You relied on him, right?
Yes.
And he would give you advice when this was going on, saying, I think this is in your best interest, or this is in your best interest, right?
It was, yes.
And that was putting on your mind of, I need to do some of these things, correct?
Yes.
So he was advising what he thought was in their best interest, and you agreed and did things for law enforcement, right?
We put a tap on my phone.
In fact, do you remember that during some of these meetings with law enforcement, y'all would be getting at it, and you'd have to stop and go out and meet with Bobby, and then y'all would meet and confer, and you come back in, and then y'all would talk more. Is that fair?
That's fair.
Because he'd have to talk to you, give you information, and then you would come and do certain things, right?
Bobby would try to calm me down.
Sure. I mean, an example would be, Ashley Pope confronted you about, where's your phone? If you're innocent, can we go through your phone? And you hesitated, correct?
I do not recall.
Do you remember going out, getting the phone after talking to your attorney, and then giving them the phone so they could try to dump the contents?
I do remember us giving them my phone and them trying to dump it in some electronic box there at Bobby's, and it didn't work.
But you had left your phone in the car when you were meeting with law enforcement, is that right?
I don't recall.
Now, during these meetings, some of them were just long. They were just long meetings, right?
Yes.
And you've had an opportunity to listen to some of these meetings?
Some of them, yes.
You go back and try to remember as much as you can, correct?
I tried.
And they can get aggressive. Y'all can get at it. Both sides, and Pope could go at you pretty good.
I don't remember both sides getting aggressive, but yes. Pope
Oh, that's
did.
fair. Sergeant Pope could get aggressive with you.
Correct.
But they were pushing you because they felt like you weren't telling them everything. Is that
Yes.
fair?
Uh-huh.
And you were not telling them everything, right?
Oh.
You were holding
Well,
back.
it didn't, yeah.
Yeah. But then at the same time, did you listen to it? Could you hear? Y'all sit around and ate candy together. You remember that?
Mm-hmm.
Y'all, I mean, I know you don't like watermelon because you didn't want watermelon during these meetings, correct?
Correct.
So during these heated meetings and when things are getting fierce, y'all could at the next moment get together and eat candy. So it just went up and down, right?
Mm-hmm.
Judge, this is a good. Just can we stop here?
Stay right. We'll take 10. You can step down. I'll get them to refill it. Thank you. Yeah, go ahead.
Barney, you can go to the restaurant and then come back. I'd leave, you take that out, just leave it here.
I was reading something on my phone. Did they say how long? What? Why'd they just stop? What happened? Can I rewind? I'm going to rewind it. I missed it.
Concealing, do you remember?
No, sir, I do not.
But you do remember they presented you with an arrest warrant.
Correct.
You didn't like that, did you?
Well, no, I was scared to death.
Sure. Your attorney, Bobby Carter, after July 6th, so I think it's going to be July 10th of 2018, July 24th of 2018, and then June 25th of 2019. When you met, your attorney was with you during the whole time, right? Outside the first time.
Yes, I think so.
Yeah, and he's a good guy, very smart guy, right?
Bobby?
Yeah.
Yes.
Yeah, a good man.
Yes.
And he's actually a judge up there now, correct?
Correct.
So he knows what he's doing, right?
I think so.
Yeah. I mean, you trusted him, correct?
I do.
You relied on him, right?
Yes.
And he would give you advice when this was going on, saying, I think this is in your best interest, or this is in your best interest, right?
It was, yes.
And that was putting on your mind of, I need to do some of these things, correct?
Yes.
So he was advising you what he thought was in their best interest, and you agreed and did things for law enforcement, right?
We put a tap on my phone.
In fact, during some of the, do you remember that during some of these meetings with law enforcement, y'all would be getting at it, and you'd have to stop and go out and meet with Bobby, and then y'all would meet and confer, and you come back in, and then y'all would talk more. Is that fair?
That's fair.
Because he'd have to talk to you, give you information, and then you would come and do certain things, right?
Bobby would try to calm me down.
Sure. I mean, an example would be Ashley Pope confronted you about, where's your phone? If you're innocent, can we go through your phone? And you hesitated, correct?
I do not recall.
You remember going out, getting the phone after talking to your attorney, and then giving them the phone so they could try to dump the contents?
I do remember us giving them my phone and them trying to dump it in some electronic box there at Bobby's, and it didn't work.
But you had left your phone in the car when you were meeting with law enforcement, is that right?
I don't recall.
Now, during these meetings, some of them were just long. They were just long meetings, right?
Yes.
And you've had an opportunity to listen to some of these meetings?
Some of them, yes.
You go back and try to remember as much as you can, correct?
I tried.
And they can get aggressive. Y'all can get at it. Both sides, and Pope could go at you pretty good.
I don't remember both sides getting aggressive, but yes. Pope
Oh, that's fair. Sergeant Pope could get aggressive. Sergeant Pope could get aggressive with you.
Correct.
But they were pushing you because they felt like you weren't telling them everything. Is that fair?
Uh-huh.
And you were not telling them everything, right? You were holding
Well,
back.
it didn't, yeah.
Yeah. But then at the same time, did you listen to it? Could you hear? Y'all sat around and ate candy together. You remember that?
Mm-hmm.
Y'all, I mean, I know you don't like watermelon because you didn't want watermelon during these meetings, correct?
Correct.
So during these heated meetings and when things are getting fierce, y'all could at the next moment get together and eat candy. So it just went up and down, right?
Mm-hmm.
Judge, this is a good. Let me stop here.
We'll take 10. You can step down. We're good.
Journal, sponsored by Michael Gaughan's South Point Hotel, Casino, and Spa.
Soundly rejected all of that. All of the theories offered by Mr. Tellis were rejected by the jury, and the jury was left with the facts and the evidence that have always been there since the beginning of the case. And that is that Mr. Tellis planned this extensively. He drove to Mr. Gehrman's house, he was lying in wait, and he attacked him from a place of cover. And of course, Mr. Gehrman was 69 years old at the time it occurred. The court knows from the evidence in the trial that the planning was extensive. Mr. Tellis used taxpayer-issued resources to look up personal information about Mr. Gehrman. He scoped out Mr. Gehrman's neighborhood ahead of time, and then of course he attacked someone much older than him by surprise. His reason for doing this, we learned, was that he didn't like what Mr. Gehrman had written about him. He felt that Mr. Gehrman had cost him an elected position. This type of violence, this sort of political violence, because of being upset about an article that has been written about you, is unacceptable and dangerous to our community as a whole. Beyond that, Mr. Gehrman's position as a reporter for decades in Clark County, his death affects the community in a unique way. There are many people who are readers who felt like they knew Mr. Gehrman and relied upon him to supply them with information about various news within Clark County. And finally, and most importantly, the family of Mr. Gehrman lost a beloved family member, an uncle, and a brother. Based on all of these factors, the state respectfully asks for the maximum sentencing enhancement available to the court. We do have one victim speaker.
Thank you. Mr. Tellis, do you wish to address the court?
Yes, Your Honor.
Thank you.
First of all, I want to say that the family has my deepest condolences. They're, Mr. Gehrman was, very impactful in the community. He made a difference. And we know from testimony by the family that he was a good brother and a good uncle. And I understand the desire to seek justice and have somebody accountable for this. But I did not kill Mr. Gehrman. And unfortunately, the people who should be held responsible, who should be brought to justice, the chances of that happening now, right this minute, are slim to none. But that said, again, my deepest sympathies to the family, and they navigate the rest of this tragedy.
Thank you very much. Mr. Paxton?
Yeah, I'll be brief. Your Honor was very attentive through this trial, which was lengthy. The jury was able to hear the state's case, the defense's case, and they ultimately reached their verdict, and we're not here to question the verdict this morning. Mr. Tellis exercised his constitutional right to go to trial and to testify, period. That's what makes this country so great, this judicial system where we take cases, we take facts, we take theories of prosecution and defense and present it to a jury. Obviously, the jury was very thorough and careful. They took 3 days to go through everything before they reached their ultimate conclusion. Mr. Tellis was convicted. To punish him for doing that, and I'm not anticipating that the court would ever do this, and I'm not saying that Your Honor is, to punish him for exercising his constitutional right is obviously inappropriate. He intends to pursue an appeal. Obviously, again, that's not really for today's discussion. What is his utter lack of criminal history. If you look on page 3 of the pre-sentence investigation report, criminal record, we have a long string of zeros, felonies, gross misdemeanors, prison, jail. He doesn't have any prior convictions. He's not a recidivist that is before this court or others repeatedly being convicted or entering pleas for violent crimes, saying, "Judge, this time give me a chance. This time things will be different." Your Honor heard from his family. He's an exemplary father. He was a good student. He was elected to office. In most part, he was a good husband. We have to look at the entire man. He's been convicted of perhaps the most serious offense. He carries one of the heaviest sentences in our judicial system. The jury elected to give him the opportunity at redemption. There obviously was an element of retribution in the sentence they imposed, but nonetheless they gave him the opportunity to one day be released. What's before Your Honor is, again, how much above that 20-year sentence will he have to serve before he's eligible for parole. Given his utter lack of criminal history, I would urge the court to sentence him to something less than the maximum. The maximum sentence, we can't stack these enhancements. Maximum sentence would be an additional 8 to 20 years. I'm going to urge the court to allow the parole board a bit more discretion. I would urge the court to consider a 1 to 10 year enhancement, which is allowable under statute, and allow the parole board to determine when he should be released. Of course, it's a two-step program. Number one, he'd have to be eligible for parole on the murder count, which won't occur until 20 years is served, but then there's the second consecutive sentence that must be served for the enhancements. I would urge the court to impose a sense of leniency in that he has no prior criminal record. Mr. Tellis has been actively engaged in his defense since the get-go. That continues through today. Again, I would urge the court to not hold that against him. And based upon the evidence Your Honor has heard, the statements of the parties, our arguments, and the information contained within the pre-sentence investigation report, which I just want to put on the record, there's no Stockmeyer issues. We submit it to Your Honor's sound discretion.
Thank you very much. We move on to first witness.
Jeremy.
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state and spell your first and last name for the record?
Sure. Jay German, Jaygerman.
Thank you.
Good morning, Judge. Thank you for allowing me to just talk a little bit. Yeah, we lost a brother. We lost an uncle, a friend, a leader. We're still in shock, and it's been 2 years. And I mean, it's going to take a long time to recover from this. It's taken up this whole ordeal, the trial, the crime, the murder. It's taken a big toll on our family, and it's been immense. It's been really difficult for all of us. We're doing our best to get through it. We really are. But he was our leader, and we're never going to see him again, and it's hard to come to that realization. But we're dealing with it. It's just going to take a long process for all of us, to recover. And we're struggling with it, but we're doing the best, and we miss him dearly. We really do. We've had a couple of his birthdays since he's passed, and it's nice to get together as a family and, kind of visit with Jeff, but it's not the same, and it never will be. We've lost a lot. He lost a lot. We have a lot of anxiety about the future safety of our family, and the children of our family, if Robert Tellis were to be released after just 20 years of incarceration. But thank you for letting me take a few minutes to talk about Jeff and our family.
Thank you. Thank you for your testimony. Anything else?
Not on behalf of the state.
In accordance with the laws of the state of Nevada, this court does now sentence you as follows. In addition to the administrative assessment, the DNA fee, and the collection fee, you'll be required to submit to genetic marker testing. At this time, the court's going to sentence you to life in the Nevada Department of Corrections, with parole eligibility beginning after a minimum of 20 years has been served, and after considering all the factors enumerated in NRS 193.165, the court's going to sentence you to a consecutive 8 to 20 years for the deadly weapon enhancement, for an aggregate 28 to life. In the Nevada Department of Corrections, he has 771 days. Does the defense agree with that?
Yes, we do.
Okay, and the restitution, was there any objection to the restitution amount?
No, Your Honor.
And imposed restitution, the amount of $23,347.71 to the victim's family. Thank you.
Thank you. We do have two housekeeping matters. One, there was a request for return of property. I've reached out to Mr. Hamler. We anticipate an order being signed to return items that were seized that were not of evidentiary value to Mr. Tellis' family. Secondly, we filed a motion to withdraw. There's not been a breakdown of communications. We've had a very good level of communication and participation from Mr. Tellis and ourselves through the course of this case. We were retained for trial in this matter. Obviously, now the case is going to the next stage. I visited with him yesterday. He's aware of the motion, which we gave him a copy of this morning. I know we have a representative from the Public Defender's Office here. Obviously, there's an appeal that's going to be pursued. We want to bring that to the court's attention. I would ask that Your Honor grant our motion and set the matter for a status check in a week for confirmation of appellate counsel. And that's I don't believe there'll be an opposition from or an objection from the state in reference to our request.
Okay,
or from Mr. Tellis.
Someone here from the Public Defender's Office?
Yes, good morning, Your Honor. Kathy Freeman from the Public Defender's Office. We're ready to accept confirm as counsel today. So.
Okay, and is that your desire, Mr. Thomas?
Yes.
Okay, so I'll grant the motion to withdraw. The Public Defender is appointed.
Thank you, Your Honor.
I think that's it. Thank you.
Thank you very much.
Thank you. Thank you, Your Honor.
You've been watching Breaking News from the Las Vegas Review-Journal, sponsored by Michael Gaughan's South Point Hotel.
That guy's kind of a real butthead. Why can't he do what he's supposed to? I just don't get it. He's how can he has zero remorse. Yay. Yeah, they have he has zero remorse. And I hope that he drops the soap a lot in jail. That's my feeling on him. All right, I'm going to take a potty break. They should be right back in Melody. Melody should be right back, so I want to run in and have a potty break. I'll be right back.
All right, go ahead. Thank you. Mr. Clark, I want to talk about the interviews themselves. I have July 6th of 2018, I think it's a Friday. July 10th, 2018, which is a Tuesday. And then July 24th, 2018 is a Tuesday. And then August 2nd, 2018 is a Thursday, and June 25th, 2019. Do you have anything to write with, sir? Do you have anything to write with there or anything?
No, sir. I got paper, but what? I got one.
May I approach you to give a legal pad?
Sure. Yeah. Oop. That's not good.
All right, for defense counsel, the dates again are July 6, 2018. It's a Friday. July 10th, 2018. July 10th, 2018 is a Tuesday.
Mm-hmm.
July 24th, 2018, I think is a Tuesday. August 2nd, 2018, a Thursday. June 25th, 2019, which is a Tuesday. All right, so I'm going to begin with July 6th, 2018.
Okay.
Do you remember that to be meeting, I think, was it at your house with the TBI agents?
Daughter's house, but
Daughter's
that's
house.
where I was living, so yes.
What do you remember about them showing up?
I was there alone upstairs in my bedroom. Heard, I don't remember, doorbell, knock on the door, dogs barking, something. Came out, I can look down onto the foyer and I could see several people walking away down the sidewalk. So I ran down the stairs and around through the kitchen and out into the garage and opened up the big garage door, and because they were out in the parking area.
And did you let them in your house to talk to you?
I did.
And did y'all have how would you describe the conversation?
Pleasant, professional. It was fine.
Did you know why they were there?
Well, not initially, but they told me.
What do you remember them asking you why, or saying why they were there?
They just said that, asked me did I know Gary and Melody Farris, and I said I did, and that they were, I don't remember exactly how it was worded, but basically that they were investigating a murder, and that Gary had been murdered, and then there was an attempt for a cover-up, and they just wanted to talk to me about my whereabouts.
What, do you remember them asking you when was the last time that you talked to Melody?
I do not remember that, but
do you remember them asking whether it was a day ago, a week ago, a month ago, or a year ago? Do you remember that phraseology?
I think it was something like that, yes.
Do you remember saying maybe a week?
Well, I listened to the tape that you gave me, so yes.
Okay. So your answer on that day was the last time you talked to her was maybe a week?
Correct.
But you do agree with me, if you look at the calendar there, is it not true that you got July the 3rd, 4th, and 5th, Tuesday the 3rd going into Wednesday the 4th, you agree with me that there were 3 main phone calls that you had with the defendant that night going into the next day?
I do.
Why didn't you tell them about those?
I don't know.
They asked you when was the last time you saw her in person. Do you remember what your answer was?
I do not.
if it was last summer or last year, do you remember saying that?
I do not remember what I said. No, sir.
Let me ask you today, going back on that, there at your house on July 6, 2018, when was the last time you physically saw the defendant?
I do not recall.
You have any idea? I know you're saying you don't recall, but do you have any idea?
No, sir. But you do, so you can tell me.
You said you listened to the recording. Do you remember after they told you Gary had been murdered and they were asking you questions about Melody? Do you remember pausing for quite some time and then saying, I don't know what I should be telling you?
I remember hearing that.
So you wouldn't dispute if you heard yourself say that you did do that?
I wouldn't dispute anything that there's a recording of.
Why did you say, I don't know what I should be telling you? Why did you hesitate to tell law enforcement about the defendant?
I'm being interviewed by the TBI for a murder that I know nothing about. You don't say nothing.
Did you do the murder?
No, sir.
Where were you in July 3rd, 4th, and 5th of 2018?
You should have a copy of that chart that I made that tells, and I have a copy of it, but I don't have it with me.
I just want you to tell the jury where
I
were
was
you
in,
at.
Tullahoma, my area.
Law enforcement got receipts and your phone records and
Yes.
showed you were not in Georgia, correct?
Correct. Even grocery receipts.
I think a video showing you getting groceries or something.
Sir?
A video showing you getting groceries?
Detective Hayes knows what my pasta salad recipe is now.
So if you didn't have anything to do with the actual murder, again, what would hesitate you to tell them what you did know?
If you don't know what you're talking about, keep your mouth shut.
But we've already established that you talked to the defendant over the 3rd and 4th for 3 phone calls, right?
Yes.
One of those was about 2 o'clock in the morning?
I think approximately. I don't know exactly.
Why did you give the defendant a credit card?
Because occasionally she said Gary would cut the credit cards off, and I didn't want her to just be stranded and not be able to, get gas or something to eat.
In 2018, in July, when they talked to you, were you still in a relationship with the defendant?
Yes.
Still sexual in nature?
Yes. But at that point, we had not seen each other in quite some time. This thing is echoing.
It's okay. But you were still having the affair, still ongoing.
We were still talking.
I think we argue over words. You were still in the same relationship you had been with her, right?
Just not physical.
She had your credit card?
She did.
Still talking every day, sometimes twice a day?
Yes.
And, pardon me, but during those conversations, y'all would talk about sex and everything else?
That's true.
Sounds like a relationship, right?
Not arguing that. No, I'm not. I'm not trying to. Yeah.
How much did the defendant like to clean?
A lot.
Is she a neat freak?
Yes.
Do you remember one of her friends by the name of Sherry?
Yes.
Did she spell her name differently?
Yes.
How does Sherry spell her name?
Don't know. I just remember that it was different.
It was different than normally spelled?
Yes.
Who was Sherry? Who is Sherry?
Just a friend of hers. I don't really know where Sherry came into the picture at or even where she lived.
Did Sherry go to Emily's wedding?
Yes.
How close of friends were the defendant and Sherry?
At the time, pretty close.
Do you know how they would spend their time together?
No, not really. I mean, I know they spent time together, but I don't know what all they would do.
Did you go to Jamaica with the defendant?
I did.
When was that?
September of 17,
How long did y'all go?
about a week.
Where'd y'all go? What, do you remember the name of the resort?
Hito.
Excuse me?
Hito.
Hito? And do you know if the defendant has Sherry do anything with a credit card?
No, I don't know that.
What did she tell her children where she was at?
I don't know. Like I said, she could come and go as she pleased, so I don't, that was,
She could even go to Jamaica for 10 days or so and not question her whereabouts?
I'm assuming.
But you don't know what she said to her children? Again, I'm sorry, you're going to have to say yes or no.
I'm sorry, no.
I can see you, but for the record.
I'm sorry.
That's all right.
No, I do not know what she said to them.
But it was it a special occasion that y'all went to Jamaica?
It might have been my birthday.
Who paid for it?
I did.
All right. July 10th, I'm going to move to that. So the next interview, July 10th of 2018. This is with the Sheriff's Office, Hayes and Pope, for the first time.
Okay.
When they came up and you met at the office, how did it start out?
I do not recall.
Do you remember reaching out to them through your attorney that you wanted to talk?
Do I remember reaching out to my attorney that?
Did y'all initiate the conversation with law enforcement?
I'm not understanding what you're asking.
Who asked who to come and talk? Did y'all ask the Sheriff's Office to come and talk?
Yes, we did.
Okay.
Yes.
And that was because you wanted to correct some lies that you said or deception?
Phone number.
Tell the jury about that.
Whatever phone number I had given, one of the phone numbers that I had given was incorrect, and I called Bobby Carter, my attorney, and told him, I said, I think I've got the right phone number, and I think he actually called and gave it to the TVI agent, and then they came up at that point, and then to meet us.
And it was during this interview that you finally told them about the other phone?
I'm assuming. I don't.
Did the defendant tell you that Gary had moved out for quite some time? That they had separated and he moved out?
I think that was like years before. I don't know any details on that at all.
When it came to what you knew of...
You're asking, did Melody move out? Or did
No,
Gary
did Melody tell you that Gary had moved out of the home?
I do not remember that at all. No, sir.
When it came to the control of finances between the defendant and Gary, who controlled the finances?
According to her, Gary did.
And to what degree did he, according to her, control the finances?
100%.
But was she able to buy things or have things?
Anything she wanted.
Do you know why he controlled the money?
I do not.
Did you know about Ted Wiley?
I did.
She never said that Gary had ever abused her or physically done anything to her?
No.
Do you remember Sergeant Pope kind of giving you at one point during the interview on the 10th, he starts talking to you about goodwill and vibes, or good vibes. Do you remember that?
I do not.
Do you remember anything where Sergeant Pope kind of kicked it up a gear to try to get you to get more information?
I remember that he did that. I don't remember specifically when.
And do you know why he was doing that? What was it that you were doing that made him start pushing you?
I have no idea.
Do you remember Elizabeth Williams from the TBI? You were asked the question, who bought the defendant's other phone? I call burner, you say other. Should they press you on, did you buy that phone? Do you remember your initial response?
I do not.
Do you remember admitting that you did buy the phone for her?
I do not.
Now, on July 10th, you haven't mentioned anything about the burn pile. Is that correct?
I don't know the time frame as to what was said when on that. I do not.
On July 10th, do you remember telling law enforcement that the last communication, not in person, but by text, that you had with the defendant was on July 5th when they were looking for Gary?
Yes.
Do you remember what that text was?
I think that's what it was. We're looking for Gary.
And respond ASAP?
You have it. I don't. I just remember it.
No reason to disagree if that was the message.
No.
So the last time that you say that you talked to her was by that text on the 5th, the morning of the 5th, right?
Yes.
The second one, yeah. We'll get you the page. All right. At one point, law enforcement asked you when Gary was on the 10th, when Gary had been murdered, they asked you about a motive. And they asked you, who has the most to gain out of this? Who did you say had the most to gain out of the death of Gary?
I don't recall.
In that context, they were asked about Chad Bruce. And do you remember telling law enforcement that Melody loves him to death?
I don't remember it, but you
Well,
obviously.
let me ask you independently, how does the defendant feel about Chad Bruce?
I think at the time she did.
Was Amanda's fiance at the time?
I don't know if they were engaged then or
But
not.
you know who that is, right?
Yes,
And you know who Amanda is?
I do.
And they're married now?
Yes.
And during this process, after the defendant was arrested, you met with Amanda quite some times, right?
They came up and got stuff from Martha out of the car. Yeah,
Talked to her on the phone or by text message?
I'm assuming. Yeah.
Chad also?
Yes.
You don't remember who bought the burner phone, the second phone? You don't remember whether or not you told law enforcement you did or didn't?
You've lost me.
Okay.
Start
You
again.
don't- The second phone that Melody had, the question was asked who bought it. Do you remember what your answer was?
I do not.
Judge, may I approach the witness to refresh his recollection?
If you prefer, Jeff, you can have my copy of it.
So let me see if you can see the screen there.
What am I looking at?
All right. Talking about the phone, you read that line there.
This was my words.
Yep.
Says I
Just
will.
read it to yourself, and I'll ask you.
I will say yes. I
Read,
bought.
I'm sorry, read to yourself. It's just a legal rule. Just read it to yourself.
Okay.
Does that refresh your recollection of what your answer was, who bought the second phone of hers?
I'm assuming that's what I said. So.
All right. The way the rule works is they show you or is that better? They either show you or play you your statement.
Yes, sir.
All right. The question is, does that refresh your recollection? Does that make it come back to you anew that that's what your conversation was? If your answer is yes, then you can say, yes, I remember, and that's what I said. If it doesn't refresh your memory as to what you said, then you say, no, that does not refresh my memory as to what was said. All right.
Now, here's my question again. Who bought her second phone?
I do not know.
Just move that. It is 42 minutes and 27 seconds. How much money did the defendant know that Gary would have in his ATM or bank account at times, like a month?
It varied.
And how much would he have?
I mean, it could be anywhere from a few hundred to a few $1,000s.
Was there times that there would be $40,000 deposited in the account, and then the next day most of it would be Gary would move it to something else?
That sounds familiar. Yes.
and that he would have $500,000 to $600,000 a year that he would make?
Yes.
All right, I want to turn now to July 24th, 2018. Law enforcement comes back and meets with you again. Is that right?
Yes.
Is that because your attorney and you want to clarify something?
I do not recall that.
When they met with you, where did y'all meet again? Was it Bobby's office?
Yes, sir.
And that was about 2 to 3 hour meeting with them. Does that sound about right?
I do not know.
Do you remember at some point that during the meeting that you had to take a break with Bobby and go out and do some more talking?
Yes.
And that was because they were pressing you with information. Is that right?
Correct.
Pope and didn't believe that you were telling him everything, and Hayes didn't believe that you were giving him all the information about those phone calls on the 3rd or the early morning of the 4th around 2 a.m., right?
Right.
They didn't believe that you were telling them everything that was said on those phone calls. Is that correct?
That's correct.
And they were pushing you to give more information.
Yes.
And because of that, you had to go stop and go talk to your attorney because you did have more information that you ended up telling them, right?
I stopped to go talk to my attorney because I was flipping out.
Okay. And after talking to the attorney, you did come back in and give them more information. Is that correct?
I came back in and told them something, yes.
I mean, you walked back in, right?
I did.
You opened your mouth and you told them the words, correct?
I did.
They didn't have to pull it out of you. You actually said what was going on.
Well, that's a matter of opinion as to pull it out of me when you are threatened the way I was.
And in your presence, Bobby, you were explaining that you were loyal to the defendant, correct?
I do not remember saying that, but
but you were there when your attorney was talking. Is that true?
Yes.
Right before.
Well, I think he talked to them without me, but now I could not swear to that one for sure. But I think they talked some without me.
At some point, though, you come back in, and it's you sitting there with your attorney, Detective Hayes is there, and Sergeant Pope's there. Is that true?
That's correct.
And now you're ready to come back and give them more information that you had not told them, right?
I'm ready to walk in and tell them something.
And you're going to tell them about a conversation that you had with the defendant on July 4th around 2 or 2:30 in the morning. Is that correct?
Correct.
In fact, you said it was the last part of the last conversation in that night. Is that right?
That's right.
And it was about Gary being in the burn pile.
That's what I said.
Tell the jury what you said the defendant told you during that conversation on July 4th, 2018.
I said that she said that, this is not going to be word for word, but that she said that Gary was on the burn pile. And I said, what? And she said Gary was on the burn pile. And I said, don't say nothing else to me. Something like that.
Would it refresh your recollection to, you can't remember the exact words?
No, sir.
Would it refresh your recollection to look at something to see if it does?
You're welcome to show it to me.
Judge, may I approach? here's the rule. I'm going to hand it to you where it says R. Barton. Read it to yourself. I know. Read it to yourself, and then I'm going to ask you some questions. Don't read it aloud. Go ahead. You go ahead and read it.
What is the recording from?
The recording is July 24th, 2018.
Interview?
It's an interview with the TBI and the Sheriff's Office.
All right, so this is a
transcript of that.
That's where I'm going. Who prepared it?
We had a contract for the office prepared.
Y'all paid someone to do it.
Yes, and Judge, what I would also, if
it is a transcription. I have called it an interpolation. It is not a transcript. It is not a court transcript. It is not done by deposition, sworn under oath, in court, anything of that nature. Correct?
Yes,
So when I'm just saying. So when they're going to refer to it as a transcript because that's what they're used to calling things, where people take down what people say and spit it out in a written format. But it is not a transcript to the extent that it is a deposition or certified court testimony. This is what someone who was paid to listen to the recording typed out and prepared and gave to the district attorney's office. All right.
Does that refresh your recollection?
Somewhat.
Judge, this time if I can have the jury step out, I'm going to play it for him outside their presence.
I'll step out for a minute.
Board Defense Counsel, this is going to be from Rusty, the file that I think it says Rusty and has his interviews. This is going to be for Roy Barton 072418. I'm going to label it as Barton 1. And it is a recording. It's 2 hours and 32 minutes and 4 seconds long. I'm going to cue it up at 1 hour, 31 minutes and 44 seconds. I'm going to start at 1 hour, 31 minutes and 13 seconds. So, Judge, I tender Barton went into evidence this time just as an exhibit. I'm not tendered into the case in front of the jury.
Right. All right, go ahead.
All right, sir, I'm going to play this. Let me know if you can hear it, okay?
Is that
Absolutely
sir?
not.
I want you to, could you maybe diagnose the first call that would be of interest to us, not the time or anything about what
I
happened?
think there was only one conversation that is what you're looking for.
Okay,
Okay?
okay,
And it was the last conversation.
okay.
And would it be safe to say there wasn't much talking after that?
No, that was the end of the conversation.
Okay. And is that the last time you've spoken with her? No.
But I talked to her.
Yeah.
I talk to her every day. But again, every day was just every day.
So when let's talk about that conversation that you feel was
probably the last minute of the last conversation. She said, "Gary is in the burn pile." No, she said, "He is in the burn pile." And I said, "What?" And she said, "He's in the burn pile." And I said, "Do not say another word and do not tell me anything. I do not need to know."
Okay.
And that is everything, period.
You discussed with her?
Period.
She didn't say anything about
nothing before, nothing since. When I talked to her after that, it was just like it was portrayed to y'all. We're looking for Gary. And
did she say, okay, so there was we ain't gonna get the time.
I stopped it at 1 hour, 32 minutes, and 44 seconds. So having listened to your statement about the burn pile, can you tell me in your own words what you said?
I said, she said he was in the burn pile.
Can you give me the whole couple of sentences that you said?
And I said, "What?" And she said, "He's in the burn pile." And I said, "Don't tell me anymore. I don't need to know."
So you can't fully remember? You
No.
can't say it verbatim?
No, sir.
Was your memory at the time that you said it to law enforcement in July 24th, 2018, was your memory the best at that time when you said it?
No, sir.
I mean, was it better then than it is now?
No, sir.
Do you agree that what you heard you say, that was you saying it?
Yes, sir.
And that was inaccurate? What you said is what you said to law enforcement.
It is what I said.
Judge, I'm going to play this statement under past recollection.
What's the discrepancy from what
He
you just
can't-
testified to?
Well, he can't say everything verbatim, and also it's a prior inconsistent statement that I'll be playing later on. When
What's
he flips.
inconsistent about it?
Well, no, when we get to his,
He's going to get to something that he
right,
says.
then I'm going to
said
play
that-
it then. So I was just going to go ahead and play it now. I can wait till then.
I mean, I don't know what's inconsistent at the moment in what he's saying or why you need to introduce a statement, because he has essentially said that's what he told the cops.
Judge, there's two lines of thought here. Prior inconsistent statement under 24-6-6-13.
What's the inconsistency?
It's not there yet. The one is that. No, Judge. The inconsistency
is upcoming because he says it was a different conversation on a different day.
Sconiers v. State, S24A-0139, April 30th, 2024. The failure of a witness to remember making a statement, like the witness's flat denial of that statement, may provide the foundation.
He has not flatly denied making the statement. He substantially adopted what was said in the conversation that you just played. So why is there a need to play it?
One, because when a witness says, "I can't remember," that's a prior inconsistent statement.
You've
Two,
now confronted him with the statement, and he has adopted it.
right, and so he has to, when the jury comes out, he's going to have to be able to say the whole statement. He's not going to be able to do that.
What is inconsistent with what he just said on the stand just now from what he said in the recording?
Yes, I'm not owing the inconsistency, Your Honor. It's past recollection recording.
You have refreshed his memory. He knows what he said.
Right.
He just said what he said. You're saying there's 3 words different. What's the issue there?
One, precision. I think it matters that they hear the exact words. I think that's an important thing, Your Honor. I don't think a word.
Well, you
off
can
here-
cross-examine him. Isn't it true that you said, and you can say it to him, and then he can say, yes, that's what I said, or no, that's not what I said.
You're just not going to let me. I'm just not going to be able to play it under this.
There's no reason to play it at this point.
Well, then I'll move on, Judge.
All right.
I'm ready.
Okay, bring him back in. it true that these were your exact words?
I understand, Judge, and I will do that.
All right.
The court's ruled. I'll follow the ruling. Mr. Barton, on July 24th, 2018, while meeting with your attorney who was present, and Detective Hayes and Sergeant Pope, after they had to take a break to get you to give more information that you did not originally give, you told them that the defendant, probably the last minute of the last conversation, she said, Gary is in the burn pile. No. She said, he is in the burn pile. And I said, what? And she said, he's in the burn pile. And I said, do not say another word and do not tell me anything. I do not need to know. Those were your words to law enforcement in July the 24th of 2018. Is that true?
Yes.
And then afterwards, you said, that is everything, period, correct?
Yes.
And you also told law enforcement, did you not, that if I'm going to give an ounce, I'm going to give a pound, right?
I don't recall that. But
would you dispute it?
no, I would not.
And you made it clear several times after telling them that she told you Gary was in the burn pile, that that's everything she said and that's what happened, correct?
Yes.
And at the time that she made the statement to you that you said she said, on July 4th, about 2 o'clock in the morning, Gary had not been reported missing yet. Isn't that true?
Yes.
Now, in July, when you gave this statement to law enforcement, you did mention something about taking some Advil PM or Tylenol PM. Do you remember saying that?
I do.
But you never said about being afraid or terrified that you couldn't, because you were so scared from what was going on that you couldn't say what happened. Isn't that true?
I don't know what you're at. I don't know what you're saying.
In July 2018, July 24th of 2018, when you told law
During
enforcement...
this conversation?
Yes.
Yes.
You never mentioned, I'm scared, and I need to... That wasn't right what I just said. You never said I was scared, did you?
Not to law enforcement.
Right. You never told them you were scared, did you?
Not to law enforcement.
There's not going to be a recording of you saying I was scared, and that's why I said what I said.
True.
And that night that you said about the defendant telling you that he's in the burn pile, you never came back and said, I need to recant that this night, did you? You know, in July of 2018, You never came back and said, I need to recant that. That was wrong.
Not in July of 2018.
Correct. You didn't do that, did you?
I did not.
And you didn't do that, you actually didn't recant until your statement in June of 2019. Isn't that true?
That is true.
And in June 25th of 2019, I want to turn to that one. Melody was just arrested with you in her presence in the vehicle, right?
Correct.
The week before. The
Correct.
18th, I believe.
I don't know the date, but yes.
And after she was arrested, a couple of days later, you then get in contact with law enforcement and want to tell them something. Is that true?
I don't recall if we contacted them to get them to come back or if they just came back.
But you wanted to tell them, you wanted to recant the statement you gave about Gary being on the burn pile.
I did.
So you got with them and you wanted to tell them that I want to recant this,
Correct.
retract it, right?
Yes.
And when you met with them in June the 25th of 2019, your attorney was with you, is that correct?
Yes.
And Sergeant Pope was there, is that correct? Detective Hayes and Sergeant Pope?
I'm going to say yes, but I couldn't. Yeah, I'll say yes.
Well,
I'm not 1,000% sure.
Was law enforcement from Cherokee County there?
They were.
And they came up to Tennessee to meet with you, right?
Yes.
And you were meeting at your attorney's office, correct?
Yes.
And you were there for the purpose because you wanted to tell them or clarify something, is that correct?
Again, I don't know if they came up to see me or if we requested them to come up. I do not recall who set the meeting.
So this meeting in June of 2019, after the defendant's been arrested and you were with her and all that, what did you tell law enforcement that what was wrong with the first statement about being on the burn pile? How did you retract that? What did you say?
Well, I don't have the verbatim, and that seems to be important, but basically what I said was what I told you was correct, but when it happened was not correct.
So what you said is she did say those words to me, but it was
Yes.
just a different date?
Yes.
And so what date did you say that she told you that Gary was in the burn pile?
I don't know that I set a date. I just said that I had gone to Martha's house. Martha had told me, and then while I was there, Melody had called, and then she told me it.
You remember saying it could have been July 9th?
I do not know what day it was.
Well, looking at the calendar on the floor there, July 2018, you talked to the the sheriff's office with the TBI on July 10th of 2018. You agree with that, right?
Yes.
And then you talked to him again on July 24th of 2018. You agree with that, correct?
Yes.
And on July 24th, 2018, you tell them, Melody told me Gary's in the burn pile. I don't want to know about it, don't want to talk about it, right?
Yes.
So you're saying that at some point you got the date wrong. Would it have been before the 24th?
Yes, it was before the 24th.
Was it closer to the 9th of July or a different date?
I don't think anything transpired on the 9th of July.
So tell us, what day did this conversation happen where the defendant said Gary's in the burn pile that you said is a different date from July 4th at 2 o'clock in the morning?
I do not know the date, but I do know that it happened after Detective Hayes and Sergeant Pope had been up, because after they left, I went to Martha's house, and that's when it was. So it would have been after that.
After the defendant was arrested, you had an opportunity to talk with her while she was in the jail, is that right?
I did.
And you were able to listen to some jail calls that I had to confirm that that was you on the jail calls, is that right?
That's right.
It was you talking, is that correct?
That's correct.
It was the defendant talking, is that correct?
Yes, it is.
And they were fair and accurate recordings of your conversations with her while she had been arrested in this case, is that right?
Yes.
Being here in Cherokee County Sheriff's Office, right?
I'm assuming so.
At the jail here in the county. And some of those times that she was in the jail, you talked to her about meeting and talking with Amanda and Chad, is that correct?
Yes.
And you would actually check on Melody, ask her questions, or she would tell you stuff, and then you would go and talk to Amanda and Chad about things. Is that right?
I'm assuming yes.
And one of those meetings was on June 24th, 2019. Is that correct?
You talking about a phone call?
Yes, phone call with the defendant.
Okay, there was a phone call most every day.
All right, so you agree that you had a conversation with her in jail on June 24th, 2019. Is that fair to say?
If you have it down, yes.
And June 24th of 2019, that's the day before you go and actually meet with law enforcement and, quote, recant your statement. Is that correct?
Yes.
Do you remember the defendant telling you that you need to explain to Amanda about the chess match?
Yes.
And ask you if you've been interviewed, and you say, I'm going to be tomorrow by our two favorites. Do you remember saying that? Mm-hmm. And that's because the next day you were going to go up and meet with them and Bobby, and that's when you were candid, correct?
I'm assuming yes.
Remember the defendant talking about, well, there has been a very well-played orchestra in this?
Yes.
And tell Amanda about Chris? She would tell you to tell Amanda about things about Chris and Scott?
I remember hearing that on the recording, but I don't know what that meant.
June 26, 2019, do you remember in a jail call there that the defendant told you you need to stress to Amanda that she needs to find out whatever kind of trouble Chris is in and have that dealt with?
Yes.
And that you need to explain to Amanda that there is a well-played orchestra?
Yes.
And you need to explain the chess match to her?
Yes.
And that she was supposed to meet with somebody and be interviewed? Do you remember that?
I don't remember that, but who was somebody? Sir.
That she was supposed to be interviewed either by an attorney or somebody in the case.
Okay. I don't know.
Now, I had you listen to, in full, 2 of the phone calls. Do you remember that?
You had me listen to a bunch of phone calls.
Do you remember that in July 5th of 2019, the defendant had a preliminary hearing? That was the one that was on TV that you watched. You remember that?
Yes.
You did watch it on TV, right?
Part of it, yes.
And she wanted you to watch it. Is that correct?
Yes.
You listened to that July 5th, 2019 conversation that y'all had about the prelim. Was it a fair and accurate conversation that you had with the defendant?
Yes.
This time, Judge, I'm tendering to evidence calls 13. So July 5th, 2019 jail conversation.
No objection.
All right, so move. Go ahead.
Remain on the line. Hold for acceptance. To remain on the line. Hold for acceptance. This is a prepaid call from an inmate at a correctional facility. Three-way or call waiting is not allowed and may automatically disconnect this call. This call is also subject to being recorded or monitored, except your call has been accepted.
But
Hey.
You okay?
No.
Did you watch it?
Yes. Watched it live.
Okay. Did you watch it with Bobby?
No, I didn't know it was going to be on until it was already going.
Okay.
And found it, but I sent it to him to watch.
Okay.
They didn't talk much. Bobby said they wouldn't have said that. They wasn't supposed to. Because it was recanted. It was said under duress, and they weren't supposed to use it.
Right.
But there's a whole lot they left out, but I have not seen it all.
Well, I had a minute, Michael and I talked back and forth during it, and he talked to Amanda afterwards. And, it's okay.
I know they're devastated because all of us are. How are you?
I'm okay. Oh, you do need to call Amanda, though. And
You
explain. Do what?
You sure she'll talk to me?
Yeah. 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 Michael talked to her afterwards.
Okay.
Yeah. And I talked to her.
Explain what happened?
Do what?
You said explain to her what happened?
Yeah.
Okay.
Yeah. Oh.
Still a whole lot that don't make any kind of sense to me whatsoever.
Well, that's what Michael said.
I told them, I said, I've never been so afraid of anything in my entire life. But I didn't know my name. And Bobby said, that happens all the time. Well, it ain't supposed to happen to me. And I should have better control of my faculties.
Well, that's what trial's for.
Fear will do.
Do what?
So that's what fear will do.
True. So who watched it with you?
Nobody. I watched it by myself. I just pulled it up on the computer and I turned it on just right before I started talking about it.
So can you go back and watch the entire thing then?
I think so. I haven't tried to yet. It's on that WSB TV Facebook page, and I don't know if you're not on Facebook if you can get into it or not.
Right. We'll see if Bobby can get you into it.
Yeah. Said it was about 2 hours. See, I thought it was over with, and then realized they had taken a 10-minute recess.
Correct.
Yeah. So I thought it was over with. I didn't see nothing after the recess.
Oh, okay. So you really need to watch that.
Okay. Well, I just a few minutes ago sent it to Bobby to tell him where he could find it so he could watch it.
Right. Now, I was going to say, I wish you would do that and let him talk to you.
Okay.
Michael did say that he'd be talking to you.
Okay.
I wanted to know, and I said, definitely.
Well, yeah.
I love you.
I love you too, buddy. I'm sorry you're in this.
Yeah, me too. Apparently Chris and Scott were there. Emily was there. Emily looked horrible. See, I was told not to even look back that direction. So.
Well, and that's what they said on TV. She didn't even turn and look at her family. Like, that's pretty.
Well, I was told not to keep my head down and do not look to the back.
Right. Don't look back and don't show any emotion.
Right.
Yeah. Wow. Thank you for calling.
Did you think I wouldn't?
I was afraid.
Pinocchio was singing loud today.
Yeah. Yeah. Still the chess game.
Very much so.
Mm-hmm.
But please call Amanda and explain to her, because she said she had some questions for you. That she was, she said she hadn't had to eat, because she had slept, she hadn't whatever, and they had actually just left Michael just 2 minutes ago talking to him. So.
Okay. Well. Yeah. We'd be glad to talk to her.
Bethany, she said, I just got some questions that I want answered,
Right.
Because I said, Amanda, just remember that, what this it is. And remember what they can do at this hearing.
Right.
But yeah, you need to go back and watch the entire thing.
Okay. I will do that.
And keep it. But yeah, definitely watch it with, him.
Yeah. Well, he told me that he had just settled a big court case that he thought was going to have him tied up all month. So he was going to be a lot more accessible. Wasn't really hoping that I needed him, but obviously we do.
Well, Michael told me, he said, no, I know it sounds bad. He said, but if you go back and watch it again, he explained to me what's not,
Right. Yeah. I just hope he's got the knowledge that, Manny said he had.
Have you checked on MJ lately?
I talked to her today after all this.
How is she?
She said, I think I'm going to need a pill. I said, yeah, me too. She said, well, come on over, I'll give you one.
I don't know how close that we are on time, but
8 minutes, 35 seconds from when it started ringing, I think.
okay.
I don't know how long you got.
15 minutes.
Okay, well, let's don't waste it. Holler back at me when you can.
Well, I mean, this phone call is 15 minutes. So.
Oh, okay. Okay. Well, like I said, I'm gonna try to talk to Bobby, give him time to find that thing and see if he can watch it. I'll find it again and see if I can watch it.
I would have never not called you.
Huh?
I would have never not called you.
Thank you.
So when did you recant?
2 weeks ago. I've been trying to ever since last year, and Bobby just said, well, you don't need to say nothing unless something happens, because if nothing happens, then it don't matter.
Right.
And I'd tell him all the time, Bobby, it's killing me that I said something wrong.
Well, even how they said it today in court, the second go around wasn't right. there was nothing to tell you, so.
I know, and that's what I said. I told them that 50 times.
Well, there still is no evidence.
No, I think everything they've got can easily be explained.
Well, and I don't know that they've got anything.
Well, that's true too.
Because there is nothing to have, because I didn't do anything.
Right. Oh. Well, just remember that Michael knows how sick he was and what he was going through.
I do.
Yep.
I do know.
I know. I know, baby.
I know, and I'm not upset with you.
Thank you.
Just remember, this is all us, you know. But you need to go back and really watch it, and all of it.
I will. I will.
I'll do my best to call you back tonight
Okay.
after you've watched it. See?
Yes. I'm going to watch it.
I love you.
I love you. Be strong.
I will.
All right.
I promise you too.
I'm telling myself that every day, ever since last year.
Breathe.
I'm trying.
I know you are. Hey, baby. I love you.
Hi, Donna. I love you.
Oh,
Oh,
take a breath.
I am.
Okay.
Call me when you can.
I will. Talk to Amanda. Okay?
I will.
Okay. This call will be terminated in 2 minutes.
Okay. I love you. Bye.
This conversation with the defendant was after the preliminary hearing where they talked about the evidence in the case. Is that correct?
Yes.
And you had said that you had waited to tell law enforcement. Can you hear me?
That's better.
You said that you waited to tell law enforcement that you recanted or made a mistake or said something that wasn't true for several months. Is that right?
Yes.
And you didn't tell the defendant that you had said what she told you back in July 24th of 2018. You had not told the defendant that you told law enforcement about her saying he's in the burn pile.
No.
So what you wanted to do, is it not, you were trying to wait to see if any charges were taken out, so you didn't have to reveal to your lover that you actually told law enforcement. She did tell me on July 4th about 2 o'clock in the morning that he was in the burn pile. You just didn't want to have to tell her that, right?
No, that's not correct.
But you did wait until to see if she got arrested and until it came out in evidence that you actually were cooperating with law enforcement, right?
Under advisement of my attorney.
And then when you, in the prelim, when it came out that you did, when Detective Hayes testified that you told them back in July 2018 that she told you Gary's in the burn pile, when that information came out, this was the phone call afterwards. Is that correct?
Say that again.
In the preliminary hearing, when it was revealed that you did tell law enforcement that the defendant told you Gary's in the burn pile, This is the conversation that you had with the defendant after that came out in court, correct?
I would assume yes, because you've got the dates, so.
And in this conversation on the call that we just listened to, you were very concerned that she was going to be upset with you for what you told law enforcement about the burn pile, correct?
Correct.
You were concerned that she was going to stop talking to you, correct?
Correct.
And you were concerned that she was going to end the relationship with you, and you didn't want that to happen, right?
Right.
And then she tells you that Amanda is very concerned over this, right?
Yes.
Because Amanda got really upset because she did not know that you had told law enforcement that that the defendant, her mother, told you that Gary was in the burn pile. Is that right?
Right.
And so after this, you actually had to go talk to Amanda and Chad. Is that right?
They came to Tullahoma, if I'm not mistaken. They came to Tullahoma to get Melody's belongings, and that's when we had the conversation.
But you had to sit down with them and explain to them why you told law enforcement that the defendant told you that Gary was in the burn pile back in July 4th of 2018, right?
Yes.
And you're not disputing that you said those words in July 24, 2018. You said that the defendant told me Gary's in the burn pile.
Yes.
You said that, correct?
I did.
That happened in time. It's something you said.
It did.
But what you're telling the jury is that you were treated in such a manner that you were so scared, and that's why you said it back in July of 2018.
Yes.
That the way law enforcement was treating you, the context, the circumstances of that interview were such a degree that you lost the faculty to control what you were saying, right?
That's exactly right.
That it was, quote, duress, is what you said in this phone call, correct?
Yes.
But you will agree with me back in July the 24th of 2018, in that same conversation with law enforcement, you sat there with them for hours, right?
I don't know how long we were there. But
Right, you can't remember how long you were there, right?
No.
You can't remember all the details, is that correct?
No.
But yet you can remember in June of 2019 saying, I misspoke. She said that some other date after the event. It wasn't on July 4th.
I remember that because Bobby Carter, my attorney, and I talked about it nonstop for however many months that was. So it wasn't a, miraculous thought. It was an ongoing conversation from day one.
So what we have is, you have one statement that you gave on July 24th of 2018 that the defendant admitted to you, a statement that she knew that she put that Gary was in the burn pile. We have that statement that you made, correct?
You do.
And then there's another statement almost a year later in June 25th of 2019, where you say, I recant that. She said that some other time, right?
That's correct.
But when you're talking to them in July of 2018, the 24th, when you're talking to them and saying Gary's in the burn pile, you're able to communicate with them and use complete sentences, right? You're talking freely, correct?
I was talking freely, yes.
Are you saying that you didn't have the ability to talk?
No, I had the ability to talk. You heard the words.
And you're saying that during this time, you agreed with me at parts during this interview that you would actually, y'all would joke and have candy and were sharing candy on the 24th, right?
I'm guessing that was the same time. I don't know. Was that the strawberry one?
The watermelon?
Yeah,
And
watermelon.
that would have been after the statement about the burn pile, right?
I don't know. Was it?
You don't remember?
No, sir.
So you agree with me that the defendant was worried about you talking and saying things, right?
Yes.
And she did tell you to stop talking to law enforcement and not say anything.
Yes.
Isn't that true?
Yes.
You listened to another phone call, call 16, that was on July 8th of 2019. It was a conversation between you and the defendant in my office. You remember that? The second conversation that you listened to today.
Yes.
And that was a fair and accurate recording of a conversation between you and the defendant.
Yes.
Just this time I tendered evidence, call 16. Call 16. only. 5 minutes and 5 seconds, I think.
Yeah, go ahead.
Please remain on the line. Hold for acceptance. This is a prepaid call from an inmate at a correctional facility. Three-way or call waiting is not allowed. Your call has been accepted.
Darling,
What are you doing?
just got through unloading the machine.
Wait.
You all right?
No.
What's wrong?
Well, back a long time ago, I said stop talking.
Right.
I haven't done anything.
I know that, darling.
But somehow or the other, what you keep talking about, you're going to single-handedly hang me.
I have not said anything other than the one time, and I have retracted that, and they failed to show that retraction. I haven't said anything else. Because there was nothing else to say. There wasn't even that to say.
Well, what about a phone?
Nothing wrong with that.
Okay. I got another, blast. So, just making sure that you understand.
I do, baby, but there's nothing. You didn't do anything wrong. I haven't done anything wrong. So there's nothing wrong with us talking.
I understand that.
And there's nothing wrong with us talking because there's nothing to talk about. Because
Exactly.
There's nothing to talk about. Yeah. So.
But I'm asking you to, if you get a visit,
I'm trying to get an appointment with Bobby.
thank you. Y'all need to get in touch with people here.
Yes. Yeah, that was my goal. I wanted him to talk to your guy.
Yes, please.
Yes.
Got to get a handle on that.
You know, the press took the one statement that was made out of fear, and they didn't pick up on the retraction of it. So that obviously hasn't helped.
Well, Amanda is now really upset, so I'm related.
Yeah. I tried to call her, and she didn't answer, so I wondered what was up.
Did you ever talk to MJ?
I did.
Is she okay?
Yes.
Where was she yesterday?
I don't know. I just told her I'd come by, and she wasn't there. She said, well, she didn't know where she was. She'd been out of the room. So I tried to call her after you and I talked, and she didn't answer. And then she did finally call me back. And she said then she was in the bathroom. So I told her I'd been by, and she wasn't there.
All right. I get to go. Today's kind of an odd day, so please, if you get up with him.
Yes. I promise.
If you can get some things handled with
Yes.
my people.
Yes.
Thank you.
Okay.
Paul.
I love you. Oh,
Be careful.
you too.
I love you.
I love you. I'm on Buzz Bobby right now.
Thank you.
Okay.
Okay. Bye.
Judge, I'm almost at a stopping point. That's maybe 5 more minutes, if that's all right.
All right.
Rusty, can you hear me?
Yes.
What I want to do is, there's a lot of stress in these matters, in these cases. Is that right?
Yes.
So let me do this. Let me just add a little bit more light than heat. So let me take it down just a little bit. Did you hear on this phone call on July 8th of 2019, while the defendant's in jail, she said about a minute 15, I have not said anything other, right before that she says about a minute, roughly 7, but some type or other, let you keep talking about you're going to single-handedly hang me. Did you hear her say that?
Yes.
And then y'all started talking about that one conversation that you retracted, right?
Right.
And that one conversation was the one that you made in your attorney's office on July 24th of 2018, right?
Right.
Are you a reasonable person? You try to be reasonable.
I would think so.
You would agree with me, would you not, that when you made this statement in July about the defendant telling you Gary's in the burn pile, when you made that statement, you and your attorney, very good attorney, Mr. Carter, had huddled up just you two for about 30 minutes to discuss what you were going to say, right?
We went back into Bobby's office, and Bobby was trying to talk me off the ledge. I was flipping out. And he was not expecting me to say that when I came back in.
But you were with your attorney, right?
Yes.
And you were paying your attorney, correct?
I was.
And you had 30 minutes or more to sit there and discuss what you were about to go do, right?
That whole 30 minutes was not what I was about to do. It was what I was just I was so distraught that I wasn't even making sense. And he was trying to get me to calm down.
And you would agree with me that you then went back out knowing law enforcement was trying to get more information from you about what y'all talked about on the phone that night of the 4th, and then you said he's in the burn pile.
That's correct.
And you agree with me that the defendant in this jail call was very concerned with you talking, right?
Yes.
And the words she used were single-handedly hang me.
Yes.
That's not what an innocent person says, is it?
That I don't know. Who? What she said or what I said?
What she said.
Well, I guess if you were locked up and somebody had said something against you, you'd probably say that too.
Because if the jury believes what you said on July 24th, that she had knowledge that he was in the burn pile, she's guilty of murder, right? If it's true.
No comment on that one.
Because you don't want to comment, do you?
No.
Judge, if we could stop here today, I'll pick back up. All right. Afternoon or
recess for the day. All right, we'll you got more questions for him in the morning, or you?
I may not, Judge.
All right, you're on
do
double.
have some legal arguments I'd like to take over the courthouse.
All right. All right, we'll start back at 9. Remember, tomorrow we're gonna break 11:40-ish. All right. Remember, don't look up anything, don't Google anything, don't read the newspaper, although I read what I think the newspaper article, if you get the free paper that gets mailed to you, it's just recanting what's happened in the courtroom, but let's don't look at it anyway. All right, y'all can be excused. Oh, you're fine? All right, anything else?
Judge, I do have, want to take up that issue. I understand the court's ruling. I'm not trying to go back on the court's ruling. I just think that I asked the court to consider that we can argue before he comes, we take back up in the morning. Not the past recollection recorded, not necessarily just the prior inconsistent statement. I think it also, I need to play it for the context to show whether or not he was actually under duress and how he said it and what he said.
It is probably more appropriate now based upon the testimony that it was earlier.
Okay.
So I'll
So,
hear from you on that.
I plan on basically playing where he starts talking to the end of that.
All right. All right, we'll be in break till tomorrow.